Item 2.
Item 2. My lord, I am entering appearance in the item number 2, my lord. I
Yes.
am in the BC. Due to
It's all
some,
right. Item 2.
my lord.
Where
Due
is the
to some-
petitioner?
I am the petitioner, my lord.
Okay, okay.
I am appearing on behalf of the petitioner. This is
Yes,
a
yes.
matter I have a suggestion before your lordship.
Yes.
This case was arises out of a complaint petition which was transmitted to police under section 156(3) for registration and investigation. The complainant has named 5 persons as the accused, not the petitioner therein, nor there is any averment that any other person involved in the case. And ultimately, charge sheet was submitted deleting the persons who are specifically figured as accused. And this gentleman with the petitioner before my lord was working at the Tahsildar and he was arraigned as an accused in this case. So I challenge the cognizance order. I am requesting your lordship, if the state council will obtain all the case records, it can be disposed of on the day of admission on merit. So that is my suggestion.
Okay. He also agree with your suggestion. Mr. Ragada is also agreeing with your suggestion.
My lord,
What, when do
I
you,
am
when do you
thankful
want?
to him. I am thankful to him.
When do you want, sir?
1 week after any day, your lordship, please.
Give it in. Fifth, Mr. Ragada, you get the, we'll dispose that. Okay.
Oblige me.
Item 3.
3.
This may be university. Here there are 2 cases. One is criminal miscase, 3-1,
Yes.
and 3-3.
What do you want?
My lord, here absolutely there is no sanction, and without sanction the court is proceeding against me. And we have brought this to the notice of the court. Some witnesses, no doubt, some witnesses have also been examined. Few witnesses are there to be examined.
Sanction is required.
In one case. Still then it is required because court has no jurisdiction to go against me.
What do you say? If the sanction is not there, everything falls flat.
This petitioner is concerned.
Right.
There is sanction is not at all required.
Yes. Then let us see how he says that it's required.
Let's see. I have filed some document today also. After this case was fought in the special judge court, it was rejected that sanction is not necessary because of the fact that after the retirement of the principal and this charge sheet was filed and the case was initiated or case was.
Right. So since you have retired, no sanction is required. That's what they say.
That was but in view of the amendment of the law that is required, that is the thing.
But
I have filed 2 documents today.
Yes.
Here what had happened? What had happened after the matter was rejected in the court below, and I filed here. Then the SP wrote to the DPI for sanction. You must kindly see.
Yes.
He also enclosed a draft sanction order that is there. You must see after last but 1 page.
Right.
Draft sanction order was also enclosed to it. And thereafter, the DPI, last page you will see, the DPI, he has addressed, or he was written a letter to the president of the governing body, principal cum secretary Adikavi Saradas College, Puttur, Jagatsinghpur, to accord sanction as the SP required it and enclose the sanction order given by draft sanction order given by the SP and requested to sign in the sanction order. So this is that. Probably I came to know that the college has also refused to accord sanction.
So, may I clarify, ma'am? By the time charge sheet was submitted, the petitioner was retired by that time. then accordingly cognizance was taken because sanction was not necessary in respect of officers was demitted the office by the time sanction was the charge sheet was submitted and cognizance was taken on the date of cognizance in view of that constitutional bench judgment. And another aspect is, so far as other accused persons, some 2 or 3 accused persons, those are in service, in respect of whom
No, it's Hemant Kumar Tripathi.
it's Hemanta Kumar, so far the present petitioner is concerned, so far as this sanction is not necessary, so taking cognizance and proceeding against,
He says that amended provision 19.
so far as the amended provision 2018 is concerned, will not be applicable because after cognizance
Amendment is.
amendment came. With view of that, telling,
Then why have you?
so far as this case letter is now, they have served this letter.
Ah.
So to my knowledge, in this letter relates to 3 accused persons.
No.
No, no.
The petitioner's name is there, but still then it is an, so I may clarify. Still then, even if it is in internal communication after,
Then you seek instruction. This.
I'll take instruction on
I'm
this.
just recording.
So-
Record that
The document he has filed, that is on record, your lordship.
the petitioner is challenging the entire prosecution initiated against him on the ground that proper sanction has not been obtained.
Without sanction, my lord.
Before the
Without sanction.
proper sanction was not without sanction.
Mhm.
No sanction was
My lord, my lord.
no sanction was obtained from the competent authority and placed before court when the cognizance has been taken by the trial court. He contends, the counsel for the petitioner further contends that in view of the amended provision under 19(1)(c), 191(c),
19C.
19(c),
19C explanation.
even after retirement of the accused, if the offences alleged to have been committed during his service period, the sanction is an essentiality. Sanction is an essentiality. However, the counsel for the vigilance submits that the amendment was carried out in the statute after the cognizance in this offense in this case was taken by the trial court. Counsel for the petitioner has filed a bunch of documents today to show that steps were indeed taken at the department level for the purpose of obtaining sanction to be placed before the court below against the petitioner. However, it has not finally culminated into a sanction order. Sanction order. Therefore, he submits that on the basis of the document he has filed, the prosecution launched against the petitioner is a exercise in futility and seeks indulgence of this court. Then counsel for the vigilance seeks time to obtain instruction in so far as the documents which are filed today by the counsel for the petitioner and matter be adjourned to the interim order to continue. Already
No, interim order is not there.
then why unnecessary? If sanction is required, the documents are there, we will stay.
No. Thing is that trial is going on. Evidence is going on.
Okay.
My lord.
Advance stage.
Evidence in one case.
So we will give a short date next
Any date,
next week or week. You
Next-
seek instruction.
My lord, my
If
lord.
that is the case, then why to proceed with it?
And the thing is that is not the case. The document they are relying, even if law is well settled, so the document and internal communication will not come to his
There
risk.
are judgment which says that the internal communication are unless culminated in a final order cannot be relied.
My lord.
Cannot be relied.
My lord.
That's there.
Hmm.
But these are appears to be internal.
Your lordship, I got your lordship's point. Thing is that 3 accused person has been, in respect of 3 accused persons, proceeding has been quashed.
These 4 accused persons proceeding has been-
Quashed on the ground that the sanction accorded by the person in respect of them was not competent. So on that count, we are also approaching before the Honorable Appeals Court challenging that order.
Chalo, you get the
Well.
Item 4.
four.
Minor. 22nd.
Petition. Yes.
22nd, may I pray one thing, my lord? Lordship, may I keep it to 20th or 21st?
21st?
Much obliged.
Well, 21st, 22nd would be better because.
नहीं, 21st.
Let it be 27.
नहीं कहीं कହୁଛି कि ମୁଁ 22 ରୁ 27 ରହୁନି ମେଡିକାଲ ଏମର୍ଜେନ୍ସି ହାଭ୍ ଟୁ ଗୋ ଆଉଟ୍ ଅଫ୍ ଷ୍ଟେଟ୍
Let it be 27.
ଠିକ ଅଛି।
ନା ମୁଁ ସେ 22 ରୁ 28 ରହୁନି ଟିକେ
What is road? 30 ତାହେଲେ
Much obliged, much obliged.
30 Saturday. 30 Saturday.
नहीं 30 ଫେବୃଆରୀ 30 ଫେବୃଆରୀ जो फ्राइडे
February तो 29 ही है.
sorry,
29.
first.
29.
So
29th much obliged.
29.
29.
Yes.
Item 4.
Pass over.
Item 5.
May I please, your lordship?
Yes.
I'm just passing on.
What is this?
My lord, the petitioners have prayed for the quashing of the criminal proceeding against him,
Hmm.
which has been filed by the OP number 2 informant, my lord,
Hmm.
for the alleged commission of offences under section 294, 427, 504, 506, 34 of the IPC
Hmm.
and section 3 of the SC and ST PA. Your lordship, may I kindly see both the parties are at litigated terms in a civil suit regarding the same subject matter, my lord, same holding number, plot number. And the injunction order has been passed against the OP number 2 and in my favor. After the pass of injunction order, the informant has initially filed a complaint case, my lord. Lordship, may I kindly see the list of events on 28/4/2022. She filed a complaint case. My lord, without
28/4/2022.
22, my lord.
Okay.
The London magistrate Loisinga, my lord, JMFC Loisinga, sent it under 156(3) to the police station for registration of the affair. My lord, without taking note of the fact that whether the mandatory provisions under 154(1) and 4 have been followed or not, and mechanically sent it under 156(3). My lord, I have given the law laid down by this honorable court. Your lordship, may I kindly.
Thereafter, what happened?
Thereafter, my lord, case was registered.
Hmm.
Police submitted charge sheet, my lord.
Hmm.
And in the complaint case, he even did not file an affidavit. According to the law laid down by the Supreme Court in Priyanka Srivastava
Yes,
case.
yes, that is there.
And your lordship, may kindly see.
Well, that is what you want to show. 156,
My lord.
no affidavit.
My lord, without any affidavit, my
That's
lord.
right. That is the judgment you are wanting.
My lord. And also this squarely, my lord, civil in dispute. And given criminal color, my lord.
First, let us go step by step.
My lord, my lord.
The first argument of yours is the 156(3) complaint was not supported by an affidavit.
My lord.
Show me the 156(3).
Yes, my lord. Your lordship, may kindly see.
Which page?
The affidavit. Now the FIR, that complaint petition has become the part of the FIR. Your lordship, may kindly to annexure 2, my lord. Annexure 2, my lord, it comes from place 16.
Come to the complaint, sir.
My lord, my lord. Your lordship, may kindly see page 23. Running page 23.
I saw it. Take it.
Advocate for the
There is
complaint.
no, this
No.
one ground is enough. Why are you bringing so many?
My lord, my lord. Right. Because, my lord,
I'll issue notice and stay the proceeding.
my lord.
Not here in this case, my lord. This
You can
482,
directly come out of the judgment.
this 482, my lord,
Hmm.
is not maintainable as because charge already framed, my lord. He has to
Yes,
file the revision. my lord.
The charge is.
Charge is also, my lord.
Charge already framed, my
My
lord.
lord, my lord, and
Personal
there are
medical
number of
cognizance
cases.
order. See, the complaint itself was not competent.
Lord, that is true, my lord. But in fact,
That's
charge
right, but in this case, the cognizance order has to go.
should notice it, lordship.
I'll issue notice and stay. Okay, issue notice to the opposite party.
Two.
No, first go. The petitioner is challenging the order dated 18/8/2023, passed by the court so-and-so, whereby the cognizance for the offence against the petitioner has been taken.
The charge has been framed.
Charge is in print.
Charge,
Charge.
You are challenging charge order. Why are you not challenging the entire proceeding to be quashed?
Proceeding also I have challenged.
no, no, prayer,
I have prayed, my lord. I have prayed for quashing of the entire criminal proceeding.
prayer, my lord, cancel prayer, my lord.
Inviting always problems for yourself. Anyway, 18/8/2023, by which the charges have been framed against the petitioner. The petitioner has also prayed for quashing of the entire criminal prosecution initiated against him. The first contention of the petitioner is that the present case is arising out of a complaint filed by the opposite party number 2 under section 156(3) CRPC. CRPC. So all the judgment you have given.
My lord.
There is
हाँ,
motion to
copy.
constitutional judgment. There is 156(3) complaint नथला. Take करायला. There is a people don't keep a track that.
Out case, similar case, madam.
Similar case I have done it. Therefore, I'm saying.
Well-
Fine, होगा. Fine होगा. The land council for the petitioner has relied upon the judgment of where is the judgment of Babu Venkatesh? Judgment of these three judgments. You give it to me also.
Babu Venkatesh has been referred to, madam.
Honorable Supreme Court and High Court and so and so and so to substantiate his argument. Give it to him.
But Babu Venkatesh has given.
His argument that in the absence of a supporting affidavit, the application under 156(3) itself was not maintainable. So therefore, any proceeding arising therefrom is vitiated. Mr. Ragada appears for the state and submits that since the petitioner had challenged the order framing charges against him, pulls up the remedy under 482 CRPC is not maintainable. Rather, the petitioner should have approached the revisional court. However, since the petitioner is seeking quashing up for the entire proceeding in this in the present petition, and he is directly covered by the judgment of the Honorable Supreme Court and the judgment of this court. I am of the considered view that notice should be issued to the opposite party. Opposite party number 2. Accordingly, issue notice to opposite party number 2. In the meantime, the proceeding. Which proceeding?
My lord,
Further proceeding.
special GR case number 26 of 2022. Further
proceeding in special GR case number 26 of 22 arising out of Loising PS case number 177 of 2022 pending in the court of
Special Judge SCN ST PO Act Balangir.
also is state till further.
Grateful, my lord. My lord, OP2 notice, my lord.
Notice, sir. I mean,
Notice by my lord, speed post for register.
field force.
Grateful, my lord.
Yes,
Item 6.
yes.
लिखी
Oh.
नहीं यहाँ पर नाम थैंक यू.
May I please, ma'am?
Yes.
My lord, here the petitioner prays for quashing of the criminal proceeding, my lord. The petitioner has been implicated in the case only basing on the statement of the co-accused persons, my lord. Apart from that, there is no other material against the present petitioner.
You are Tapan
Tapan
Jena.
Jena.
Let us come to charge sheet.
My lord, charge sheet lordship may kindly peruse. I have annexed the charge sheet.
Yes.
At page 11, the relevant part of the charge sheet
Reading.
is starts from page 22.
Come on, reading.
My lord. On 23/5/2022 at 9:15 p.m.
You forget about
complainant,
all these things, come to them.
yes,
While you are
During
going towards the
my lord. During course of investigation, the initial IO, SIM have visited the spot, examined the complainant and other witnesses and recorded their statement under 161 CRPC. He has seized a piece of Mangal Sutra, cash memo of gold chain and tax invoices of Mangal Sutra from the complainant under the proper seizure list. He has seized the CCTV footage of Narangpur Choko under seizure list and verification of CCTV footage. The witnesses identify the accused as
Tapan Jena.
Tapan Jena, Deepak Kumar Jena, Badri Patra, Nillu Patra, and Kanhu, all are of Dangodi area, district Jaspur. Accused persons, namely Nillu Patra, Badrinarayan Patra, has been arrested on 31/5/2022 and forwarded them to the Honorable Court on 8/1/6/2022. He has seized the, basing on their statement, my lord.
No, but you
CCTV
were identified there, the
On
CCTV
CCTV
footage. You are the
footage.
first person. Suppose
CCTV footage, my lord, I was present there.
that's a corroboration.
No allegation was there because the FIR is unknown. FIR is unknown.
You can't say that the only
It is a
statement.
it is a public place, my lord.
Public place CCTV footage you found to be present there.
And still yet he is absconding.
Yes, Para come.
Along with others, I was present also.
Also. 395.
But initially 392 and subsequently charge sheet file under 395.
No, 5-6 people are there.
Yes. Because 5 are there, it has been turned to 395.
Difficult to interfere. Sir.
All other persons were on bail, my lord.
You are also bail.
No, my lord. My anticipatory bail was rejected.
That is why 482. There are allegations, but you get the anticipatory bail. What is there?
No, anticipatory bail rejected. I have given the order at page 30.
But this is a case you should get.
At page 30, I have given my order, my lord.
39, one.
31.
31. 30 it starts.
25 the other people. Right?
My lord.
What about 31? Huh?
31, my anticipatory bail application has been rejected.
You tell me what should I observe so that you can get the anticipatory bail.
My lord, only lordship may kindly say to surrender and to maintain parity, my lord. Because all other co-accused persons has been released on bail standing on similar footing. That Badri Patra and that another Nilu Patra, they have been granted bail.
You have the parity. Who can say no to it?
With that observation,
The petitioner has filed the present petition seeking quashing up the criminal prosecution launched against him under section so and so. He contends that except the statement of co-accused persons, there is no material against him. Against him in this matter. Mr. Ragada is from the state point out from the charge sheet that apart from the fact that the co-accused have disclosed the name of the petitioner, his presence is confirmed through the CCTV footage. The petitioner CCTV footage. Therefore, Mr. Ragada submits that this is not a fit case where the proceeding could be scuttled at this stage, and he has to raise all his points at the appropriate stage of the trial.
But
The land counsel for the petitioner submits that he was unsuccessful in his attempt to obtain anticipatory bail. And he seeks to withdraw this petition to withdraw the petition with the liberty to avail the remedy under law, seeking parity with the other accused persons
who have been granted bail.
Co-accused persons, as all other co-accused persons have already been
Released
released on bail.
Their bail order also I have annexed.
Bail, and he has also relied upon the orders by which bail to the other accused persons have been granted. With the proper mentioned observation, the petition is disposed of.
Lordship,
I will
direct to surrender, my lord. Otherwise,
and you will have to surrender. Obviously.
or not before lordship.
Because the petitioner seeks to surrender before the court, honor before 20 on or before 20th of February, and seek his remedy available to him under.
Item 7.
This is indirect 430.
My lord, one word will. My lord,
I have parity.
court will consider the
don't
principle of parity, my lord.
see. We
While-
not dilute 482. I have given this. I can understand because other co-accused persons are already granted bail.
Yes.
Unfortunately, your anticipatory bail is rejected.
My lord.
Go on. I have observed that. You
My lord. God bless you.
You can get regular bail also. Surrender, so it you get regular bail. That is a better idea for you. Instead of applying for anticipatory bail, because I have protected you till 20th. Before that, you move application regular bail and get it. Because all other accused have got the regular.
Yes.
Better you surrender and get regular bail. That is a better idea.
May please your lordship.
Yes.
The petitioner challenging the order of a cognizance.
Item 7.
My lord. Cognizance dated 26th April 2023. This case has been arising out of a complaint case, my lord.
Yes.
Petitioner number 6, Jarina Khatun, filed one criminal proceeding under section 498A, 294, 323, 354, 307, 506,
Right.
along with 4 DP Act against the opposite party number 2, along with the others. That is Nemalo PS case number 218, 81220.
Now, what is your case? You tell me.
My lord, only to save their skins, the opposite party number 2 lodged this complaint case before the court below against the present petitioners, my lord. Afterthought. Prior to that, prior to initiation of this case,
All these things, how can I go into at this stage?
my lord,
Whether it is afterthought or right?
my lord, kindly have a glance the annexure to the complaint petition.
Okay.
That is at page 13.
Yes.
It was filed on 31st, 3 January 22.
This is under which provision?
That one CC number 7 of 23.
Now, this is what you want to quash.
The order of a cognizance, my lord, that is under annexure 1 at page.
Nay, I'm trying to find out which is the 1cc case complaint.
Yes, my
Copy
lord.
of complaint.
My lord, annexure 2 at page 13.
This is under 156(3).
No, my lord.
Then
153, my lord, filed by the petitioner, my lord. One complaint that has been sent to the petitioner is registered.
At page, my lord, at page 13. 13, the complaint petition, 7 of 2023.
yes.
The prayer is that 156(3) or further that,
This is against you.
my lord,
This is against you.
like, my lord. But prior to that, the petitioner.
1 minute.
Okay.
If this is against you, you want quashing up for this proceeding.
My lord.
You see, the very supporting affidavit.
Arising out of 1cc case, my lord, notice.
No, but there is no supporting affidavit. It's covered by that judgment by unnecessary
Notice
witness.
complaint notice.
And I will have to state.
My lord, notice.
Notice so I
Madam,
issue, but say
My lord,
main point you are not arguing. You are arguing here and there.
Madam.
See, this is arising out of a complaint case under 156(3).
No,
And-
my lord, these present cases are not sent for 153, my lord.
No, that's
That-
what he.
No, my lord.
Prayer just see.
No, my lord, cognizance taken.
No, prayer just see the prayer.
Prayer of the page
156(3).
My lord,
Yes,
if it's sent for 153, then my lord, the question arises, affidavit file or not, my lord.
But it-
Here, my lord, directly complaint file, my lord, and cognizance taken. Initial statement, others say not given. some time.
page 14.
No, the
Unless-
156(3) application. It was then FIR was lodged thereafter.
FIR se ko
Yes,
tako
next
case vedera.
formal FIR. Just see.
Formal पर tankar.
Sir.
He filed my lord the another FIR, my lord. Here, my lord, the direct cognizance taken under section in a complaint case, my
Under
lord.
200. It's
200.
200. That will not cover the judgment.
ନା ସେଟା police ପାଖକୁ ଗଲେ affidavit separate
That's the idea. Simply I will issue notice.
No, my lord.
फिर भी से point raise କରିବା କଥା raise କରିବା କଥା cognizance taken ହେଇ ପାରିବନି raise କରିବା କଥା
So we will issue notice. Let us see.
Further proceeding may kindly state.
Further proceeding, how can I say? You can move application for adjournment. Okay.
My submission is that.
The council issue notice to the opposing party number 2. The council has to be returnable within 2 weeks, and in I number, the land council for the petitioner seeks the stay of further proceeding. We may move appropriate application for adjournment before the court below, owing to the fact that the matter is sub judice before this court. Material subdivision.
No, I'm not going.
You move an application, you get in, you'll get.
Congress.
Yes,
Item 8.
this is basically a matrimonial dispute
Right.
kind of thing. If they'll come,
Okay, they'll come.
yes.
Item 8.
Sir, my lord, this matter may come next week.
Protest.
No problem.
Item 9.
May I please, your lordship?
It's arising out of a matrimonial dispute, my lord. Here, my lord, the petitioner challenge or the questioning of the entire criminal proceedings, so also the order taking cognizance, my lord. On the ground that, my lord, the same allegation.
One is the father-in-law.
Father-in-law, second one is the mother-in-law, third one is the husband, my lord. On the ground that, my lord, on the same allegation, my lord, one FIR has earlier lost by the opposite party number 2. In that FIR, these present petitioners faced the trial and they have been got acquitted. That judgment I have annexed your lordship at page 17, annexure 2.
Where
That
is it? Yeah, wait.
that judgment was passed on, my lord, 24th November 2022.
Okay.
Thereafter, after 10 days, my lord, this FIR has been lost against the present petitioner.
So what are the allegations?
Allegations, dowry torture, these are the allegations that your lordship at page, I have also.
What was the allegation in the earlier, FIR?
Same allegation, dowry torture, that your lordship at page 19, fact of the case, my lord. The informant, namely Janani Mangaraj, has submitted a written report at Dharamgad place alleging therein that on 7/2/2010 she has got married to Daitari Mangaraj, only son of Govinda Mangaraj and Anuradha Mangaraj of village Kuturu, as per social rights and customs.
Culture card and all. Now let us see which FIR you are telling.
That is at annexure 1, my lord.
Let us see.
It is in the Odia, my lord. May I?
Read little bit.
ଲେଖିବାର କାରଣ ଗତ ପ୍ରାୟ 10 ବର୍ଷ ତଳେ ସାମାଜିକ ପ୍ରଥା ଅନୁସାରେ ଶ୍ରୀ ଦୈତାରୀ ମଙ୍ଗରାଜ ପିତା ଗୋବିନ୍ଦ ମଙ୍ଗରାଜ ଗ୍ରାମକୋଟ ସ୍ୱାଂଶୁ ବିବାହ କରିଥିଲି। ବିବାହ ହୋଇ କେତେ ଦିନ ଗଲା ପରେ ମୋର ସ୍ୱାମୀ ନିଜ ବଡ ଭାଉଜ ଶକୁନ୍ତଳା ମଙ୍ଗରାଜ ସହ ଅନେକ ଥର ମୁଁ ମନା କରିବା ସତ୍ତ୍ୱେ
Issue the petitioner has filed the present petition seeking passing of the FIR number page 9. Under section 2. Petitioners, petitioners. Petitioner number 1 is the father-in-law. Petitioner number 2 is the mother-in-law. And the petitioner number 3 is the husband of opposite party number 2. Good, sir. Then counsel for the petitioner submits that on the self-same allegation, the petitioners were subjected to trial in which case is this?
it is my lord CTGR case number
CTGR case number
174 of 2014, my lord.
The after the petitioner faced the full-fledged trial, the learned court of SDJM Dharamgad by its order dated
24th November 2022, my lord.
24 November 2022 has recorded an acquittal in favor of the petitioner. Petitioner. The opposite party number 2, after the acquittal order, has now registered the present case on the self-same allegation. Issue notice to the opposite party number 2, returnable within in mark you give. And in stay application, you write that the further proceeding in so and so is stayed till next day.
Publication.
Yes. Next.
Item 10.
Yes.
May I please, your lordship? Petitioner is challenging the order of cognizance, my lord, wherein the learned magistrate taken cognizance under section 138 of NI Act, my lord.
138.
My lord.
You are accused.
My lord.
You are accused.
My lord.
What happened?
Actually,
Why cognizance order is wrong?
because 6 days delay in after 6 days he has filed the complaint petition. A magistrate magistrate is forbidden to take cognizance after but delay, my lord, 6 days delay. Thereby, I am under placing reliance, my lord. The partner has got
What is the check amount? Check amount.
my lord, your lordship, can I fastly see, my lord, the kindly
You tell me the check amount, sir. 24 lakhs.
my lord. Their petition, let me kindly see running page 17.
70.
Huh.
Yes.
8, clause 8, they have mentioned, my lord, complainant has mentioned. It is humbly submitted that there is a delay in presentation of this,
Where are you reading? Where are you reading? 17, 17.
my lord.
Yes. Yes.
Point 8, my lord.
Yes.
That it is humbly submitted that there is a delay in presentation of this present application. But they have not disclosed how many days delay. Actually, 6 days delay has, my lord, occurred, my lord. Let me kindly see the.
Due to pandemic situation.
Let me
Then
kindly see the.
Supreme Court in
Yes.
Promoter 1 has given that liberty.
Your lordship may kindly see the page 20.
2020?
20, my lord.
Yes.
Here it has been mentioned, my lord. Thereafter, the complaint filed the complaint petition on 22/6/2002 within the stipulated time. Magistrate not gone to the, my lord.
That's right. Wrong. That is a typo kind of situation. But pandemic was there and
Yeah,
Promoter.
My lord, here no separate delay condon petition has been filed, my lord. And magistrate has not taken, my lord, here similar matter, Patna High Court has quashed relying on a Supreme Court.
No,
judgment.
you had issued the check or not?
That is the matter of fact that will be decided in the matter.
No, that way you.
Only on this ground,
The courts are getting completely clogged because of these kind of petitions. You have issued check, the presumption operates against you. Why don't you pay and finish it up? I issue notice subject to the fact that you settle with it.
that is the, my lord, matter.
Under the garb of technicality, these technicalities neither are not there. He says that there was a delay owing to the pandemic. The Supreme Court Somoto 1 proceeding was there that delay will be.
But that has not been considered.
No.
That has not been considered by the magistrate. Lord, may kindly see.
See, the magistrate says there is no delay
No delay.
because of pandemic.
No, that has not been.
That what may not be there is what is this?
In this judgment, like,
He
notice may.
but you be ready to pay the money and finish it up.
That's right.
ନା ସେଟା ଡିସ୍ପ୍ୟୁଟ ଥାଏ ମୁଁ ଆକୁ ଦେଇ ନଥିଲି ଚେକ୍ ଆଉ ଜଣେ ନେଇଥିଲା ଆଜ୍ଞା ମୋର ଗୋଟେ ଲୋନ୍ କରେଇ ଦେବେ ବୋଲି ସେଟା ମିସୟୁଟିଲାଇଜ କରିଛନ୍ତି ଦ୍ୟାଟ୍ ୱିଲ୍ ବି
FIR ଫାଇଲ କରୁଛନ୍ତି ଆପଣ?
ନେ ମୋଠୁ ନେଇଥିଲେ ଗୋଟେ ଲୋନ୍ କରେଇ ଦେବେ ବୋଲି ଥାର୍ଡ ପର୍ସନ ସିଏ ତାକୁ କରେଇ ଦେଇଛନ୍ତି ଏଇଟାକୁ ଆଣିକି ମିସୟୁଟିଲାଇଜ କରିଛନ୍ତି
ଆପଣ 138 statutory notice have you replied?
ମିଲଟା
Have you said all these things?
ମିଲଟ
You have said? Then you may have a case for the okay. Issue notice simply.
Kindly stay the middle.
No.
Audit may be issued.
No, 138 matter, what are you talking? See, in a complaint case. I'll issue notice, just see. Let us see, then find out. Yes.
Item 11.
Yes.
Item 11, may I please? Well, it's here. I have challenged the order passed by learned JMFC Jharsuguda in CMC 39 of 22 pertaining to section 12 of the Domestic Violence Act. My lords, that order has been passed ex parte against me. We are residents of Delhi. No notice has been served on us. And my lords, the order has been passed to our prejudice. My lords, we only came to know that there is a pending proceeding against us when an execution case was filed and we got notice in that case.
You have to go to that court and tell I'll protect to that extent. You go and appear in that court and move.
My lord, I am appearing there. I am appearing in the execution case. My lords, but I am challenging the ex parte proceeding that has been taken against me.
Now it is no more ex parte.
My lords, that is only limited to the extent of execution.
It's the maintenance order.
My lords.
Maintenance order, how can I interfere? After all, she has to use.
My lords.
She is your wife.
My lords.
Then you have to maintain in any case.
But I have to
Party or no ex parte.
My lords. My lords is absolutely right on that aspect. But I have to be heard with regards to my financial position to assist her to maintain the lifestyle.
What was the maintenance amount?
My lords, the amount is, my lords may see, page 19. The total amount, 3,000 protection order against under section 18. 3,000 as residential order, 6,000 as monetary relief, and 40,000 as compensation.
What are you doing?
My lords?
What are you doing?
I'm a businessman. I'm a small store owner in Delhi, my lords.
Businessman.
Small store owner, my lords. My lords, another aspect I need to bring before to your lordship's attention.
Small businessman in which area exactly?
My lords, the address of the petitioner is
First we have,
Harsh Vihar.
not important commercial hub.
My lords, I am not even aware of
This commercial place. Lal Mandir is there. In small place also they earn so much. Pay, this is what is.
But I have no objections in paying
What is your,
I should be heard, my lords.
I'll say that you should be heard and move appropriate application for varying the order, ex parte order.
My lords may remand it, and fresh hearing may be done, and then whatever the learned court decides, I'm willing to pay. But I should be heard in the matter, my lords. The ex
But
parte.
you have already appeared, you will be heard, but.
No, my lords, I have appeared in the execution case. This order has been passed under section 12 PWDV.
You are challenging the execution order.
No, my lords, I am challenging the main order, my lords. Execution is still pending. I have filed my objection there. I am challenging the main order, my lords.
Let counsel for the petitioner, by way of this petition, the petitioner is challenging the order dated 26/9/2022, passed by JMFC 1, Jharsuguda, in connection with the criminal miss case number 39 of 2022 under section 12 of PWADV Act 2005, whereby the court below has passed a slew of directions. Court below has passed the direction for granting maintenance to the petitioner on various terms. The petitioner, counsel for the petitioner submits that the said order was passed ex parte, full stop. The opposite party number 2 is
opposite party, my lords, sole opposite party.
The opposite party has now instituted execution petition for executing the impugn order. He submits that the ex parte order on merit needs to be varied. I am of the considered view that while exercising jurisdiction under 482 CRPC, this court need not go into the merits of the case. However, suffice it to say that the petitioner should be heard by the court below. Once he entered appearance in the court, appears in the court and move to appropriate application for varying the impugn order, full stop. Accordingly, the present petition is disposed of, giving liberty to the petitioner to file appropriate application for modification of the impugn order dated, what is that impugn order dated? Impugn order dated 26/9/2022 before the court below, full stop. Court below. But you have to pay whatever the order is for till full stop, till the court below decides the application on merit and take a call for varying the impugn order. The petitioner is liable to pay the maintenance as ordered by the court below.
My lords.
Keep on paying and move an application and get it very deep.
My lords. My lords, one small prayer. My lords, till I file such application before the court and that is considered, the execution case may
Why
be.
you are stayed?
I will pay, my lord.
I'll say it virtually. You pay as of today, whatever the orders are made, you pay and move an application, ask for varying the order. If the court varies, it's all right. If it doesn't vary, then. Okay.
I'm deeply.
I allow.
Item 12.
Again, you are making a grievance that ex parte. I'm allowing ex parte.
I'm extremely grateful to you, lord.
May I
Yes.
please, Your Lordship?
Petitioner has preferred the share length.
12? 12. Yes.
Challenging the order dated 19/10/2023, that is running page number
Yes, what is this order?
to recall the witnesses. Your lordship may kindly see first the page 93, annexure 6.
Which witness you want to recall?
No, my lord, I am not wanted to adduce any evidence.
Hmm.
The prosecution has closed the evidence by filing a memo not to adduce any evidence. That is under just now I am doing 28/3/2022, running page 93.
Then?
After lapse of 1.5 years, the prosecution has filed a petition to examine, that is running page 99. On 30/9/2023, your lordship may kindly see, accused person are present on call, filed Hajara, Learned APP filed a petition under section 13111 CRPC praying to examine such and such witness on the ground stated therein. And accordingly, I filed an objection. That this is a year-old case, and this honorable court has targeted the case as because targeted. That is the order.
Which witness you want? They want
They want to adduce some seizure witness, and in the meantime,
There
one
are
of the
certain witnesses, they are malad charge sheet, my lord.
Why have you not done earlier?
But the earlier PP, my lord. Here, my lord, the case, my lord.
Now
Your lordship
why
may-
the PP like
your lordship may- your lordship may
What
kindly
happened in this case, my lord?
take a room,
Actually, my lord,
because I am the petitioner. I will argue, and thereafter you will argue.
4
I
months
cannot-
2019 रे 4 months itla.
Your lordship may kindly see.
My lord.
PW7 is evidence is very clear. The seized article. I am an employee of the lower judiciary. I was dismissed from service since 2012. Appeal was filed. Though the appellant could,
What you are doing?
now I am jobless. I am.
No. What was the allegation?
they are committing criminal breach of, my lord, the trust, my lord.
I am the
They are
petitioner.
Malkhana, my lord. Court Malkhana. They have,
You have not gone to the evidence of PW7. You have never at all gone to the evidence of PW7. On the date of allegation, I was transferred from that judiciary to another judiciary. The informant
And
has
you are working in the court and intelligence.
But they,
no, I was working on another court.
But you are in court staff. If the court staff does like this, we will not.
but for that is
No, your lordship may kindly go through the evidence of PW7, who is the informant, and he has stated that I was also handed over the charge prior to my
What is the stage of the trial?
trial.
my lord, these two,
Ruan.
the rest charge sheet witness will be examined, the case will be closed, my lord. Case closed, my lord. But in fact, my lord, the PP, special PP who conducted the case, my lord,
But what will you do with this?
he is one of the witness, my lord, there, my
What
lord.
will you do with this?
But in
Targeted for 4 months in 2019.
my lord, that is true, my lord. But in fact, my lord, the case, my lord, here, my lord, the breach of trust by the government servant is working in the judiciary, my lord.
But that's
Yes.
right, but
But
you,
I
you have chosen to close the evidences.
My lord.
Now you choose the court after 1.5
What
years,
happened, my lord?
despite the fact that
The additional people who conducted the case, they are my lord, who gave the closure report, my lord, closure memo, my lord. He is one of the witnesses there, my lord. Subsequently came out and another people was engaged. When another people was engaged, since he was one of the witness, my lord, earlier people was a witness in that case. For that reason, my lord, this one opportunity.
what do you think over? One opportunity with 1 month.
One
Finish.
My lord, with that end.
We will not further prolong.
My lord.
And if what will happen to this? Who is responsible for not complying to the High Court order? Something has to be done.
My lord.
The High Court orders are
My lord.
defied like this. Has the
Prayed for
court below has asked for extension of time, or it's thrown in the dustbin?
No, my lord, till date, no extension was made. I was served in the today morning.
If suppose High Court targets a matter,
my lord.
if it is somehow it is not complete for any reason, will you?
He had to pray for extension of time, my lord.
Whether in this case extension of time
No,
was sought.
He's saying that no, my lord, but I have no instruction on that, my lord. The other, my lord, for only
Very
for
good. Suppose we will allow the court to defy the
Everybody should
order of the
respect
High Court, then
my lord.
Even if your lordship may kindly see the order dated.
Only
Then-
4 witnesses remaining, my lord.
Your lordship may,
whatever, but
your-
I'm
19/10/2023, that was allowed. Till date, the evidence has not adduced by the prosecution. In the meantime, 4 months has already been elapsed.
Witnesses were there.
The petitioner, the petitioner has challenged the order dated 19/10/2023, whereby an application moved by the prosecution under section 311 CRPC for re-examining which witness
No, not re-examine, my lord. Re-examine the rest of the charge sheeted witnesses, my lord.
to
Namely,
Namely,
Sumitra Patra, Dilip Kumar Sahu, Hrusikesh Bhoi, and
charge sheeted witness.
they are
charge sheeted.
charge-sheeted.
And in the
To
meantime,
examine the charge sheeted witness has been allowed. The learned counsel for the petitioner has pointed out which is the closing of the evidence.
my lord, by order dated 28/3/2022.
28 by the prosecution on 28/3/2022 has made a categorical statement before court to close the entire evidence. However, after lapse of more than 1.5 years, the application under 311 has been moved, and which was now allowed by the imperial. The learned counsel for the petitioner also hands up in order dated 18/1/2019, passed by the coordinator bench of this court in TRPCL number 106 of 2018, whereby the coordinate bench had directed the learned Sessions Judge Devgod to dispose of the TR case number 4 of 2012 as expeditiously possible, preferably within 4 months from the date of receipt of the certified copy of the order. However, it is surprising that the prosecution is prolonging the case indefinitely. Having said that, it is also found from record that the reason for delay is not coming forth, and the learned trial court has also not sought for extension of time. Let the report be sought from the learned additional sessions judge Devgod regarding the delay show cause. Delay caused regarding the reason of delay caused in non-compliance of the order dated 18/1/2019, passed by the coordinate bench in so-and-so 106. Insofar as the present case is concerned, since the prosecution, since the prosecution's application was allowed to examine the witnesses, I am of the considered view that at this stage no interference is called for. However, in view of the earlier order of the coordinate bench, I direct the court below to conclude the recording of evidence of the prosecution within 1 month. Within 1 month from today. 1 month from the day receiving certified copy of the present order. We take certificate for 1 month. The prosecution may do well to see that the witness, the evidence is closed within the time frame granted by this court, without any further.
better, my lord, if the she mentioned the charge sheet witness named Sumita Patra, Dilip Kumar Sahu, Hare Krishna Bhoi, and
You do whatever.
My lord, one of the witnesses
If
is
you
already
write,
there.
I'll write everything.
my lord,
You have to examine them. You may
allowed that allowed, but
the prosecutor may take a call.
No, they are
May
named
drop
there.
someone.
Madam.
So 1 month. I have sought the report also.
My lord.
Allowed. Yes, I'll just come within 5 minutes. What do you think?
page 9 of the brief.
Cognizance order.
Madam, your lordship may kindly see. The check was issued on 21/2023. That is running page 9, para 3 of the petition, last line.
Hmm.
And the check was presented on 30/3/2023.
Okay,
Para 5 of the said complaint petition.
right.
Immediately sent on 20/2/2023, prior to the check deposited, the notice was issued, sent to the legal notice through registered post.
No. I didn't get it. There are some corrections and all.
Your lordship, next 3 lines,
Where? Para 5.
para 5,
Yes, the complainant immediately on
22/2023 sent
this is
legal
2
notice.
or 3, who knows, yeah.
Madam,
The dates are
Through-
override.
through register.
Overwritten. How do
Then thereafter,
send a legal notice through registered post and accused for payment of the cash of such check amount
by
within 15 days.
12/3/2023, which is received by the accused on 24/2/2023.
All are handwriting and all.
No, my lord, that was the certified copy. This is the certified copy, and it was by 12/3.
Wait,
Check was deposited on
show me the legal notice.
legal notice is not with you.
We have to see the document. Unless you see the document, how will you confirm the dates?
My lord,
It's overwritten and all.
It was,
I have to see the document.
it was mentioned in paragraph.
Maybe, but see the document. There may be typo. How do you know? Unless you see the document. You say the legal notice dated is such and such. Let us see the legal notice, whether the date matches or not. Maybe see there are overwriting and so many things. How do you know?
Your lordship.
Legal notice. Why don't you place this? What is the date? 20th February 2023. 2023. 20th February 2023. When the check was issued, according to you?
20/1/2023. Presented on 30/3/2023.
Presented on
30/3/2023.
30/3/2009 year. Where is it? Show me date now.
Para 4.
Disconnected with the effect of so and so, whereby accused committed offence under 138. Para 4.
Para 4. The complainant deposited.
Check dated 30/3.
30/3/2023.
30/3/2023. Check. Okay. Check. Okay. Presented
on date issue is 20/1/2023. I was issued the check on 20/1/2023.
20/1/2023. ठीक है.
Deposited on 30/3/2023.
Right.
And notice was issued prior to deposit
No,
the
what
check.
is it? 20.
20/2/2023.
Are you sure that you have not issued any notice?
Prior to that, he has issued the notice.
No, apart from this, any other notice?
No. This is the certified copy.
There is some problem. There is some typographical problem. Just see this. Have you read it?
Not
See, this is on 20th February 2023. Like this paragraph you write that my client on 30th March 2023 deposited. The March 20 I know February 2nd March jama kartili boli. It must be April.
In fact, both the accused and the petitioner.
Have you read it?
I have not done.
Just see. Date 20 February 2023. ହେଲା ନୋଟିସ୍ ହେଇଛି ଏ ପାରାଗ୍ରାଫ ପଢନ୍ତୁ ଏ ପାରାଗ୍ରାଫ ଲେଖା ହଉଛି that my client on 30/3/2023 deposited the check କେମିତି ହେଇପାରିବ ଏଇଟା ଏଇଟା ହେଇପାରିବନି ନା
In the
ଏଇଠି
complaint,
ଏଇଠି typographical error ଅଛି
in the complaint case.
she writes that I know but there is some
For
typo
that reason I.
you are taking advantage of that you have issued check you don't want to pay
No, my
and
lord,
this-
both are closely related to each other.
Ah.
The complainant and that.
it is
They are not, they are
maybe some
not.
typo what is the check amount
That was 18 lakhs for purchase of land.
will you pay I will issue
My lord, there was settlement, notice should be issued.
I will issue notice, not that I will not issue notice, but why did you settle?
It will be settled in between them. My lord. I will take.
Because the petitioner is seeking, no, petitioner is challenging the cognizance order dated 13/9/2023 passed by the JMFC Talcher in one CC case number 11/2023 2020 initiated by the opposite party against him for having for the offence under section 138 NI Act. He has pointed out from the copy of the complaint that the check was issued by him on 20th January 2023 and which appears to have been which was deposited by the complaint party on 30th/3/2023 whereas prior to that the legal notice statutory legal notice under 138 NI Act was issued on 20th February 2023. He hands up to the notice dated 20th February 2023. Perusal up to the notice indicates that there are typographical errors because in the penultimate paragraph of the notice, the complainant writes that the check was deposited by him on 30th March 2023. Without going into the details of the without going into the veracity of the notice and to venture into the question whether the dates are rightly mentioned in the complaint and the documents are not. I posed a question to the land council for the petitioner as to whether he is interested to settle the dispute without prejudice, settle the dispute with the complainant. Receiving the answer in affirmative, I am persuaded to issue notice to the petitioner, to the opposite party, returnable within short date, 20th. Since there is a possibility, since there is a possibility of settlement in this matter, and this court has issued notice to the opposite party. Number two, it would be appropriate to stay the further proceeding in ICC case number so. Further aggravated like settlement we have better stay and come with the money and pay. Yes.
14.
May I please, your lords?
14.
Yes, ma'am.
Yes.
Here in this case, the petitioner implicated under section 376 to N 376/506 6 POCSO Act, my lord. Since the stipulated period is going to be end, my lord, the IO filed charge sheet without DNA report. He has sent for DNA, and your lordship kindly peruse the.
This is the cognizance order.
No, I have filed application to produce the DNA report. Technically, my application has been rejected. IO filed charge sheet. Since the period is going to be end, my lord, investigation kept open for DNA test. DNA test was over, and that report was not produced. Your lordship may direct.
Produce the report.
My lord,
If you have a
he has not given the copy of the charge sheet, my lord. But in fact, my lord,
ডিএন টা তো দেই দিলে
You file, see, you file the charge sheet, keeping 173(8) open, awaiting the DNA report. Now the DNA report has come, you place it, what is the big, whatever consequence will take place. The, show me,
yes
the, this order is 21/11/2023, what is that?
yes that application was rejected my application
You move the application.
yes my lord.
Their
What
prayer, my lord, again, my lord.
to produce the DNA report
after the charge sheet was filed.
But prayer is that, my lord, the prayer honorable court may please to take necessary step for DNA test. Now prayer এটা কথা সেটা রিজেক্ট হয়েছে সেটা
সেটা পরে যাইছে আগে চার্জশিট রে লিখছন্তি
রিজেক্ট করছেন
But DNA report asla ki nahi?
নাই আসিনি আগে that চার্জশিট has given my lord
No, you have just now
Read
said
there, my
DNA
lord.
report has come.
no no as per
my lord, he has
167
read there for a DNA report, my lord, before trial court, my
your
lord.
lordship kindly
Yes,
peruse the
I
charge sheet my
understand.
lord
Let us understand why.
এটাই কোন করছে সে ডিএনটি বাট টেস্ট হবে বলে করে দেখিতি
Nahi, nahi,
পিটিশন
he
সেটা রিজেক্ট
moved an application saying that ki DNA test kora jao.
করা যাবে
Seda reject হয়ে গেল.
That's
right.
পিটিশন
Now he says that DNA report has come. That's why I'm. Has it come?
that is not within our knowledge, my lord.
But
that
he
was
has extra knowledge.
pen
Yes,
your lordship charge sheet your lordship kindly peruse
Sir, since PW victim has already been examined in the court, my lord.
charge sheet রে লিখছন্তি
wrong procedure can follow.
নাই নাই wrong procedure কোন
My lord, this application may dispose of the liberty to him to pray there, my lord, before trial court filing a petition that may be.
Now what he says is keeping investigation open under 173(8).
That is in the charge sheet, my lord.
For DNA profile of newborn.
But that is my lord. That is in the charge sheet. He has not filed
as per charge sheet your lordship may direct my lord
Your lordship,
The petitioner had moved an application before the learned trial court seeking a direction, inter alia seeking a direction to conduct DNA test on the victim girl, victim girl, which was turned down by the trial court. He seeks interference in this matter. Full stop. The time of hearing, the petitioner has relied upon the copy of the charge sheet already filed in the instant case. And
that day na file.
দেইছি কোর্ট উপরে
No, ठीक है, that's it. He is relying upon. And he points out that investigation under 173(8) CRPC has been kept open for obtaining DNA profile of the newborn baby of the victim. Victim and accused. He submits since the preliminary charge sheet was filed awaiting the DNA report. The DNA report should be placed on record. Full stop. Mr. Ragada appeals for the state and submits that he has no instruction regarding the same. Having heard the parties, I am of the considered view that if the prosecution has obtained the DNA report, the same should be placed on record if advised so. Yes. That is their discretion. They will file or not. I can't give a direction. They may not rely on it.
within a period of your lordship
No,
immediately as expeditiously as possible
as
your lordship.
expeditiously as possible. So as to curtail the delay in the criminal prosecution.
yes
Whereas this is neither here nor there. Yes,
15, my lord, pass over, my lord.
yes, pass over.
17
16 कौन होला?
अर्जुन है
Calendar बोले नहीं तो 16 and 16.
अर्जुन नहीं
Yes.
Hey, please, your lordships.
Yes.
This is a bail jump matter, your lordships.
When you got the bail?
Your lordships. Pardon, your lordships. I was on 1st of February 2021.
Bail on 1st February 21. NBW on 14. I said
11/4/23.
But now the cost has to be increased because
As per your lordships.
you are how much? You tell me.
Your lordships will direct.
Commensurate to your standing in the bar.
It will be very little, sir, your lordship.
1,000.
Lordships.
500 each. There are two people.
One person, your lordship.
No, two.
Oh, two.
500 each. Huh? Oh, you will appear on 29th. Before,
Lordships.
on or before 29th.
Lordships.
Adi 229th. Okay.
Item 18.
My lord.
Pray for Passover.
Passover.
Item 20.
May I please, Your Honor?
Yes.
My lord, in this case, the petitioner Tonkadhar Bisi filing this application for quashing the criminal.
NVW.
No, my lord, criminal proceeding. My lord.
NVW has also.
Yes, and NVW issued, my lord. In this case, my humble submission is that, my lord, the
Are you on bail or not?
no, my lord.
That is the reason you have come, I know.
No, my
I will
submission.
say the NBW go and appear.
And he has not given certificate, it has been rejected, ABLPL rejected, anticipatable
I
reject.
know, I understand.
That should be,
482
certificate should be given.
Certificate he should have given.
That is the whole difficulty.
Share limits,
No, no.
Ah, yes, all.
Give.
You have to give.
Whatever petitions you have already filed
my lord.
for this accused, you have to give that information to the court.
Sorry, Your Honor.
But stay it for some time, you go and avail the.
My lord, my little submission is there, my lord. In this case, the present petitioner not a principal accused, he is the father of the principal accused, my lord. The principal accused during the time of occurrence, he was 17 years old, my lord. For that reason, he treated as juvenile, and juvenile case was already disposed of. That is page number 62, my lord, where 62, where the juvenile JCL is acquitted, my lord. As because, my lord, the victim examined in the juvenile case, she stated before the juvenile board that there is my lord, kindly glance the deposition, that is page number 74.
What is he said?
It is a fact that no such alleged occurrence has taken place. And in her deposition, she stated before the juvenile board that I cannot say the contents of the FIR. I deposed before the court under section 160.
Yes, so what to do?
Exactly. I am always agree with your lordship's views, but once this has been considered by the coordinate bench, can we sit over that matter? That is the whole problem.
That is one thing. Second thing is the same victim goes in the juvenile court, says that nothing has happened.
That's always open because he is absconder.
And now he is absconder.
He is absconder. That is the difficulty.
Why are you not appearing and you will be acquitted
My lord,
Immediately acquitted.
Actually, my lord,
what I'll do is,
my lord,
I will record everything.
my lord,
Yes.
Record everything, give you time, go and appear and just get an acquittal.
my lord,
Right.
my lord,
That's better idea.
Absolutely right.
That's better
Absolutely
idea.
right.
my lord,
Absolutely.
Let us follow the due process of law.
my lord, my lord.
Okay. Likho. How many accused were there?
My lord, total the three accused. One is juvenile and two is the
Okay. The petitioner is seeking watching of the entire criminal prosecution against laws against him. Laws against him at the instance of who is the FIR?
the victim herself lodged FIR. My lord.
He is party to this
Yes, your lords.
opposite party.
My lord, opposite party number 2, your lord.
At the instance of opposite party number.
Sorry, sorry.
You try to do everything to see that no relief is given.
Sorry.
At the instance of the victim. At the instance of victim. The FIR was lodged against 3 accused persons. Out of them, one of the accused was where is that? You have shown me that order. Where is the statement?
Page number 74.
72.
74.
74. One of the accused was a juvenile. The juvenile in conflict with law was subjected to the trial by the Juvenile Justice Board. The victim, namely the informant, in the said proceeding, has inter alia stated as under 74. You pura video, I am pura statement. 74 is pura statement. Statement. Full stop. Full stop. On the strength of the aforementioned statement, the petitioner now contends that subjecting him to the trial is a futile exercise because the victim has already resigned from her statement, resigned from the statement in the judicial record. Judicial record. Judicial record. Mr. Maharaj appears for the state and submits that the no leniency should be no lenient view should be taken against the petitioner at this stage. No indulgence should be given by this court to the petitioner because he has been an abscond. And he has to pull up. He has to, according to him, he has to surrender to the jurisdiction of the court below and follow the procedure established under law. Full stop. NVW has already been issued against the petitioner.
Yes.
Against the petitioner. Therefore, this court is not inclined to interfere in this matter at this stage. However, liberty is granted to the petitioner to surrender before the court below, honor before 29th of February 2024, and seek all available remedy under law. Till then, the operation of NBW issued against him by order dated NBW.
NBW order dated मतलब
3/1/2020.
3/1/2020 is kept in evidence. Kept in evidence. I have kept in evidence. I have given three kind of thing. Go and surrender and move application. You will be acquitted. What is the
till 29th.
till 29. Yes. Till 29.
Public jailers.
Yes. Dispose of.
ଆଉ ଯଦି 5 ଟଙ୍କା ଦେବେ ବାହାରକୁ ଭଲ କଥା।
He has to. 1000.
My lord.
1000.
My lord.
1000. This order is subject to the petitioner paying 1000. You got full relief therefore.
Highly applicable.
21.
May I please your lordship, my lord, here commencement of the proceeding on the ground that, my lord, other co-accused person faced trial and got acquitted.
You got absconded.
And judgment of the my lord Rakesh Kumar Sahu, my lord, in a NDPS case, my lord,
twice
squarely, my lord, covered.
Anticipated bill twice rejected.
Was biased.
His problem is he's showing my judgment only.
Here, my lord, also, my lord.
What have I said wrongly?
Wrongly?
Tell me.
NDPS case रे acquittal रे आपण abscond रे अछंती केमती आधरे
in this case, if I'm not wrong,
yes,
there was no chemical examination report.
And apart from that, my lord, the
So
independent.
therefore, I said that there is no chemical
Yes,
analysis report.
yes.
Nothing is there. Why should he will be?
But in this case also, my lord, hold that the independent witnesses, my lord, not supported
Maybe.
it.
Chemical analysis report was there.
yes that is there.
Chemical
That's the basic of basic.
That
Yet it is another applicable no.
apart from that, my lord, I am placing that judgment, my lord.
Which judgment?
Acquittal judgment, my lord.
You show me. Yes, that's a better idea. Show me. Which paragraph?
My lord, paragraph 15. From these evidence and non-compliance of mandatory requirements of law in respect of effecting search, seizure, and other facts, it can be concluded that the prosecution had not been able to prove the seizure of alleged contraband articles from the exclusive and conscious possession of the accused.
Beyond all reasonable right. Doubt.
Apart from that, my lord,
What was the, you see in that case which you are citing, he was the owner of the vehicle. He was not apprehended from the spot.
and here also, my lord, I am not apprehended in the spot. My name in fine does not find place in the preliminary affair, my lord, C4. Subsequently, my lord, in charge sheeted, my lord, on the basis of the confessional statement of the co-accused.
What was attributed to you?
My lord, attributed in respect of the confessional, he, my lord, confessed that procured from me, my lord, the contraband.
You are the boss.
That was, my lord, that, my lord. And moreover, my lord,
You were using other people.
And moreover, my lord, if the entire document judgment, my lord, I placed, my lord, section 32 not compliant, my lord. That's why the court below got acquittal in favor of the other accused. And PW1, my lord, who is the, my lord, independent seizure witnesses, he has not supported the prosecution case, my lord, accordingly hostile, and that is also taken care by the Law and Trial Court while considering, my lord.
How many accused were there?
One accused persons initially in affair, then, my lord, the petitioner.
There are two accused there.
Two accused persons.
So the other accused has faced the trial and got it.
Got the acquittal, my lord.
You were not found in this.
Not found in this.
କଣ ତ ରେସ୍ପେକ୍ଟ ଦେଲେନି ଜୁଡିସିଆଲ ଅର୍ଡର ଟାକୁ ସରେଣ୍ଡର କରିବା ପାଇଁ ଦିଆଯାଇଥିଲା ଆପଣ ସରେଣ୍ଡର କଲେନି ଦି ଥର ରିଜେକ୍ଟ ହେଲା
Problem.
ଆପଣ କିଛି କରୁନାହାନ୍ତି
ସେଇ କେସରେ ମଧ୍ୟ ସେଇଆ ହେଇଥିଲା ତାର ବି ମିଲର ଆଣ୍ଟିସିପେଟରୀ ବେଲି ରିଜେକ୍ଟ and apart from that ମିଲର ଏଥିରେ ସେ ଯୋଉ PW4 so far the chemical examination report ରେ କହିଛି ଯେ ମୁଁ ମୋ own experience ରୁ ମିଲର burning robbing ମିଲର
had you been other cases my lord I would have known this
How to strike a balance? You tell me. See, the fact remains.
Yes.
He has defied the earlier order of this court.
Yes.
He is not
Yes.
1 minute, 1 minute. And also the fact remains that he is subjected to trial. He is bound to be acquitted.
maybe my lord
Bound to be acquitted. This is also a fact
yes
looming at last.
yes
So, in view of that, find out a way out so that both the things can be taken care of.
let him to surrender first then come and
I will fix the time limit. Surrender.
release.
come and go
Then, see, which is permissible under law, we will do it.
Yes.
Which is not permissible under law, we will not do. Because there are two orders against you. You were asked to surrender and take the bail and all. You didn't go. So you absconded. There is a judgment in your favor now. This acquittal judgment.
yes
So what I'll do is I'll fix a time limit of 2 months or 3 months, whatever,
yes
to conclude the trial.
yes
Even if you don't get the bail, within 2 months you will be acquitted.
you'll be acquitted right
Even if you don't get bail, but you should get the bail.
At this juncture, may I pray one thing, my lord? My lord, fix the time limit, suppose 29 and kept
Surrender.
abeyance on
That
the
I-
my lord
that I get.
NBW order.
That I-
And also, my lord, directed the Law and Trial Court while considering my bail application, taken care into, my lord, the acquittal judgment by
Obviously.
the Law and Trial Court.
As
And
recorded-
maintaining parity and since, my lord, the confessional statement.
Where are the two orders by which your anticipated bail were rejected?
Repeat করছি ସେଥିରେ ଖାଲି ସରେଣ୍ଡର ରହିଥାଏ ସେଟା ମିଲ ଅର୍ଡରଟା
Where is
ଆଣି
that?
ସାର୍ଟିଫିକେଟରେ ଦେଇଛି ମିଲର 1334 of 2022 and 1057 of 2020 they are in middle only.
Petitioner is seeking quashing of criminal prosecution against him in the FIR number so and so. He contends that there were two accused persons in the said case. The co-accused surrendered to the jurisdiction of the court below and suffered a full-fledged trial, and eventually by the judgment dated 6/4/2023 passed by the special court Fulbani, the co-accused has been acquitted. The petitioner is strongly relying upon the acquittal order to say that the trial even if he is put to trial, the trial would be a futile exercise. Therefore, the entire proceeding is liable to be quashed. Mr. Maharaj, appearing for the state, on the contrary, points out that the petitioner has made two attempts. Petitioner is an absconder, Kutsa. He made two attempts earlier before this court for obtaining
pre-arrest bail
for obtaining the concession of pre-arrest
Right.
bail, and the coordinate bench of this court, while disposing of his BLAPL number 1334 of 2022 by order dated 16/2/2022, had directed him to surrender before the court below
within a period of 4 weeks
within a period of
4 weeks
within a period of 4 weeks and move bail application.
yes
On move bail application. However, the petitioner has defied the order of coordinate bench. Therefore, no interference in the present case is called for. Having said that, the petitioner is at liberty to appear before the court below on or before 29th of February 2024 and seek the remedy available to him under law, including urging the points he has urged in this petition. Yes, NBW has been issued against.
Yes, Mr.
The NBW issued against the petitioner by the order dated
22/5/2022
is kept in abeyance till 29th of February 2024 so as to enable the petitioner to take necessary steps available to him under law.
One more prayer, Miller.
Subject to payment of
Miller, one more prayer.
Subject to payment of cost of 1,000.
While Miller considering the
Because you have wasted time of this court and the coordinate bench and the trial court
that is
everywhere.
one more prayer, Miller.
Hmm.
Miller directed that while consider my bail application, the law and trial court.
Sir, right, yeah. While considering you will be acquitted also.
While taken into maintaining parity, since other acquitted persons.
Obviously, I have written that there are two accused, one is acquitted. What is parity? That means will be acquitted. Parity means.
Say acquittal judgment taken into consideration.
Yeah, I said that. I have said that. That judgment will be taken note of, including the points which you have raised here.
সেটা বি লেখা
This is the point I have written.
সেটা বি লেখা
সেই পয়েন্টটা সেইটা হজুরটি লিখে দিলে বেসিস অফ দি ইমপ্লিকেশন কনফেশনাল স্টেটমেন্ট গুলো
সে লেখা লাগলে তো 1000 টাকা দেবে ভাই
चलो 22 yes
22 টা ভিজিলেন্স কেস
22
এটা ভিজিলেন্স কেসটা ଆମକୁ କପି ଦେଇଛନ୍ତି ଆମେ we are not
vigilance copy ତାଙ୍କୁ ଦିଅ copy give copy to put it next to it. Yes 23
copy
My lord, I have
For a dead my lord, within that stipulated period.
yes I have given it.
I have filed this application challenging the execution order in the maintenance case, my lord. That is CRP 101 of.
Why?
It's because, my lord, the area maintenance filed by the opposite parties, that is 3,18,000 is pending nowadays.
3,18,000
3,18,000.
pay deposit 50% here.
50,
I will notice.
my lord, at least 1 lakh, my lord.
Huh?
1 lakh.
50%, 3 lakh, 1.5 lakhs you deposit, we will issue notice. Maintenance after all.
1 lakh, my lord. Kindly.
No, why? No.
It's because he is.
1 lakh if you can give, 50 also you can give.
My lord, during stay with the husband, my lord, he already paid 4 lakh to 6 lakh rupees to the opposite parties, my lord. Nowadays he is getting only 35 to 50,000 as a salary.
Okay, 1 lakh rupees. But what are you challenging then?
My lord, execution application, that is page number 11, my lord.
Execution.
My lord, 120 under section 125 clause 3, my lord, of the CRPC.
Execution re kaun halla?
He claimed area maintenance.
No, I can't reduce it. What will it?
My submission only.
The main order you have not challenged.
No,
By
ma'am.
which the court below has given you determine
Yes,
the maintenance.
yes, ma'am.
If that order is there, that has to be executed. What to do?
My lord.
You should have challenged that.
No,
order.
my prayer is only, my lord, I will pay entire amount 3,18,000 along with the interest, my lord. But at present I have no capacity to pay the same. my lord.
Installment you want to pay.
My lord, that I will pay
Right.
with.
The petitioner has suffered an order by the court below passed in favor of passed under section 125 CRPC application moved by the opposite party.
My lord.
Full stop. The opposite party has initiated the execution proceeding being CRP number 101 of 2023, whereby the court below has now directed to pay the arrears of directed the petitioner to pay the arrears of maintenance to the tune of 3,18,000. 18,000. 18,000. Then counsel for the petitioner submits that owing to his financial incapability at this stage, he can't make good the payment, the entire payment in one go. Therefore, he seeks indulgence of this court, indulgence of this court, full stop. Indulgence of this court. The petitioner, I'm of the considered view that no indulgence could be given to the petitioner in this matter, seeking quashing of the order arising out of an execution proceeding in the absence of any challenge to the main order by which the maintenance has been awarded against him. Having said that, the petitioner is given liberty to approach the court below for seeking indulgence for court below inter alia, making a prayer for making the area amount good by appropriate installments, with this observation, the petition is if the petitioner moves such application, the court below may consider the same on its own merit and fix appropriate installment for making good the entire area amount, making good this area amount on behalf of the district.
Highly obliged, Your Lordship.
You move an application.
Yes, Your Lordship.
Give installment and finish it up. Yes.
24.
Yes.
My lord, in this case, the petitioner appeared before the lower court and released on bail as a one, but in his individual capacity. But charge sheet submitted in 2 times in his name. Firstly, accused number 1 in his.
What do you want? What do you want? You want quashing of the NBW order?
Quashing the NBW order.
You tell me when you were on bail.
I was on bail as accused number 1, but charge sheet submitted in 2 times.
Forget about that. You were on bail on which day? Date, you tell me the date.
Bail on 20/9/2016.
20/9/2016. NBW issued on
NBW
23/6/2022. Set aside, you have to appear on or before 29th of February, seek remedy as available under law, and pay the cost of 1,000. Allowed. You have to pay cost of 1,000, okay? To the
my prayer, firstly, charge sheet submitted my name in 2 times, mentioned in the charge sheet. Firstly, my name is Swapn Mondal, Ajit Mondal, charge sheet submitted as accused number 1. Then second time in accused number 2 re nakhala, say Swapn Mondal, Ajit Mondal as a director of the Louisville Society. Accused number 1 le mu appear kori ki bail goli, kintu accused number 2, accused number 1 is same in one person.
That's what you have to tell all these things to the court below. There is a error on this part.
My lord.
Move appropriate application in the court below, okay?
Cost take na.
Cost.
Cost take na.
Cost 1,000 only.
Say that take.
Because you have challenged this order after 3 years. Therefore, 1,000. Okay.
25.
Complete.
26.
Wait,
yes.
Yes, whether the petitioners, they have challenged the order passed under Annexure 3, madam.
Yes.
In a proceeding under 107, on the face of civil litigations pending and where the first party has lost the same. Well, let me see Annexure 3, which is an order.
107 only, you have to give a bond. What is the big deal?
No, my lord, I have already given my show cause also. I'm quite conscious about, my lord,
what will be the consequence in 107?
consequences, my lord, the present petitioners, my lord, mother and son, they have not been allowed to, though, my lord, they are in possession.
But the injunction petition filed by other side in this proceeding, civil suit, that has been dismissed under the garb of under the being armed with this 107 proceeding. They are not allowing me to go to my land also. What I pray, my lord, what that will be decided by the civil court. What I pray, my lord, I have already given my show cause. Usually, my lord, the notice is being challenged as cryptic one, relying upon 71 Supreme Court 2186. But here I have given my show cause. What I pray before my lord, court, but not an executive magistrate, though I have filed my show cause, it has not been disposed of. My lord may direct that the application, the proceeding will be disposed of, and till that date, disposal, maybe 15 days, maybe 20 days, maybe 3 weeks or 4
Where is the
weeks.
notice?
Notice is annexure 3, my lord.
Where is notice?
Page 23.
1/8/2023.
My lord. And I have given my show cause also under annexure 4. I pray. That will indirectly bound me down to till that date, man. Till the
executive magistrate takes final call on the show cause notice. No coercive action should be taken against it. 27. Yes.
May I please, your lordship?
Yes.
My lord, the order of NBW under challenge before your lordship.
Now, when you got the bail?
My lord, I got the bail on 30th of June 2022.
NBW ka bail chalo?
20th of December 2023.
Bail.
Bail is 30th of June 2022.
22. अच्छा ये 23. पूरी ये 12
these are the
500.
Obliged orders.
Yes.
28.
8 visual arts. Yes, my lord, I have challenged the order taking cognizance passed by the learned special judge in taking cognizance of the offences punishable under sections, my lord, 341, 323, 294, 506, read with section 34 of the Indian Penal Code, and also section 32 of the SC and ST Prevention of Atrocities Act, my lord. My humble submission before my lord is accepting the entire case of the prosecution. No case is brought out in any of the offences alleged. My lord, may kindly see the FIR. So it will be convenient.
See the charge sheet that
Charge sheet, yes. Charge sheet I have annexed.
Page 18.
Yes, beginning from page 16 to 27. My lord, may kindly see.
Page 18. You are Pintu.
Subhashis Raut. and
Subhash
Kumar
Rao,
Rao.
Pintu,
and Abhay
Abhay
Kumar.
Kumar.
Yes,
Come.
ballot. Here ballot, I have my on a bare reading of the first information report as well as the statements recorded during investigation under 161 of the code, no case is made out in any of the offences.
Yes.
It may comes up ballot when I have uttered the word taking the name of their caste. So section 3 will be attracted. Ballot that has been dealt by Honorable Apex Court. Ballot and also relied upon by this Honorable Court in a recent judgment, which has also been reported in 2023 by Honorable Justice R.K. Patnaik.
So what is the allegation? Accused Subhash Rao scolded
Scolded.
in her.
My lord, is for
in her
what has actually
language.
happened here? What is the case is? My lord, when
Expressing
the
the-
petitioners were
caste and-
constructing their something in their land, the informant party they came with a dead body. They opposed. Why you came with a dead body to the spot? Because work is going on, masons are working. So there was a talk of words. In the talk of words, there was some sort of hitch had happened. It is alleged that ballot 294, 53, section 3, 354. How can it be ballot? Ballot may see the affair. For that reason, I was drawing
Fist blows and fights. During this time, the complainant lost her sense and the brother-in-law.
that has been taken note of by because of the fact that the section 3 of SC and SC Act is being misutilized, the Honorable Apex Court in a judgment, my lord.
How do you know it is misutilized? You have scolded taking.
Yes.
name.
You would say if you say whether that was with an intention. But they are at the spot of the movement, not that we had gone to their house and scolded there and assaulted this, that.
Where is that judgment?
My lord, that judgment is
required.
that is 2021 Supreme Court. My lord, I have got. No, that is Odisha High Court.
Just so me.
That they have taken the ballot series. This is very well discussed judgment and has been taken note of by Honorable Justice R.K. Patnaik. My lord, Hitesh Sharma. My lord, may see the judgment of our High Court. That has been taken note of. Very interesting judgment, my lord. Paragraph 4. It is further submitted by Mr. Bapat that ingredients of section 3110 of SC and ST PO Act are not satisfied, and hence the charge for the. It is contended that even by assuming the sake of argument that during the alleged incident the informant was abused by taking the name of the caste, that by itself does not make out an offence of section 3110 of SC and ST.
Intention should be to insult.
Yes. Since the intention should be an insult or to intimidate a person being a member of the scheduled caste or scheduled tribe, while advancing such argument, the decision of the Apex Court, Hitesh Verma versus State of Uttarakhand.
Yes, Mr. Maharaj, what is it?
Yes.
It is spur of moment, all these things has happened.
You'll
There
also
is
make
no
an-
intention as such.
that
I am coming.
and that is
Don't read it in piecemeal. Read it in detail. That judgment. My lord, I am coming to that. The paragraph 8. Here, my lord, the facts of the case has been discussed in paragraph 6 and 7.
You are reading the same judgment?
Yes.
Yes.
That has been reported in 2023 volume 1 Whaler.
Hitesh is noticed.
My lord, 2023 volume 1 Whaler 403. This judgment has been reported. Paragraph 7. On a reading of the affair under Annexure 1, the court finds that the informant was assaulted by the petitioner. It is claimed by the informant that the petitioner also abused him by taking name of his caste. It is further stated that as a result of the assault, the informant lost his sense. According to the petitioner, the alleged incident has been exaggerated by the informant as the incident did not take place such an ugly turn which is being claimed. According to the court, the truthfulness of the otherwise of the claim of the informant.
Yes, I got it. Mr. Maharaj, now.
you'll also make kindly
How to deal with it?
para 12 minute
Para 12 of
of the judgment minute. 2010
In
Supreme
the result,
Court.
the criminal discuss stands partly allowed. Yes, sir.
Good. No,
Paragraph
para 12. The basic ingredients of the offences.
Yes, come on.
The basic ingredients of the.
the
I can do that.
The Supreme Court judgment, basically.
Supreme Court. The basic ingredients of the offences under section 3(1) of the Act can be classified as number 1,
intentionally
insult or intimidate with intent to humiliate a member of a scheduled caste,
What was the intention?
or my lord, remove it, then or humiliate a scheduled caste persons.
On the spur of the moment. That is why this section has been added.
Spur of the moment.
We cannot assess at this stage because it's a stage of taking cognizance. It is to be proved by the taking the ingredients all, but these ingredients have been elaborately explained. Or had it been not or, then matter would have been different. It's or. But that is the
how to get about the justice? Justice Patnaik's order.
Let's notice go. Let's notice go.
In the present petition, petitioner is seeking quashing of the criminal procedure, quashing of the. But Mr. Dhal, if I record everything and I'll give you liberty to argue on the charge sheets, so section 3 could be dropped also.
Well, section 3 can be dropped here. Almost all the offences can be dropped here. It can be tossed here.
You have argued only one offense.
No, I have.
You
for
have
that
scolded,
reason,
you have
for
beaten
that
up,
reason-
you other thing.
For that
Even
reason,
3 goes and the other.
No, for that reason.
I'll tell you what is the difficulty running in my mind. Supposing I have to, if I issue notice, in these circumstances, I have to stay the proceeding.
Valid.
If I state the proceeding, I am staying the proceeding qua the other offences also.
But that is the case which is travelled by court of special judge because of the section 3. But for that reason, I was drawing Bylard's attention to the affair and 161 statements, which will also not make out the ingredients of section 354, 294, and 506. I have categorically mentioned in my body of my application.
Watching up to the cognizance order dated cognizance, the order of cognizance dated whereby the trial court has taken cognizance for the offences against the petitioner. The Mr. Dhal, the senior counsel appearing for the petitioner, has taken me to the gravamen of allegation against his client. The allegation indicates that the allegation in the FIR and charge sheet indicates that on 19/2/2023, the mother-in-law of the complainant had died. They had brought the dead body from the hospital and kept the body in front of a house of the complainant at the time of construction of work of a building of the accused person. The complainant asked the worker to stop the construction as till the rituals are conducted. To this, the accused persons got annoyed and scolded scolded the complainant in the Hindi language, expressing her in class. Okay. The petition, the accused persons have also gave fist blow to the complainant. Full stop. On the strength of the aforementioned allegation, the petitioner was subjected to the criminal prosecution. The legend, where is the order of cognizance?
That is order annexure 3.
The learned court below by order dated 26/6/2023 has taken cognizance of offences under section E page nature 20 offences. The counsel for the petitioner submits that if the allegations and evidence placed on record by the prosecution is taken at its face value, also no case as such is made out against his clients under section 3(1) so and so of SC/ST POA Act. He has relied upon 2 judgments two judgments to substantiate his argument. Firstly, the judgment of the Honorable Supreme Court in Hitesh and so. Which paragraph?
Paragraph 4.
No. Which paragraph? Supreme Court.
Supreme Court, my lord, that is
He
just kidding.
he is relying upon para so of
Valid.
the state judgment. Supreme Court judgment.
My lord.
He has also relied upon the judgment of a coordinate bench passed on 19/12/2022 in criminal MC number.
My lord, that is reported in 2023, volume 1, Velar, page 403.
Reported in zone. He relies upon para 4 and para 8 of the said judgment, which reads as that. The sole contention of the legal counsel for the petitioner is that there was no intention. Attributed to the petitioner for insulting the complainant, therefore, the offences under section 3 of 3 so and so of SCST Act is not attractive. Mr. Maharaja appeals for the state and submits that the judgment cited by the petitioner, judgment of the Supreme Court, judgment cited by the petitioner, namely Hitesh Burma, Supra, will not come to the aid of the petitioner in view of para 12 of the said judgment, which reads as that. Para 12. So I have taken into consideration the averment made in the FIR, charge sheet, and the statement of the witnesses under witnesses. Full stop. Taking into consideration the judgments cited at the bar, cited by that, I am persuaded to issue notice to the opposite party number 2. Opposite party number 2, returnable within 2 weeks. In the meantime, the proceeding before the so is stayed till further on.
Para 12 and 13 will also make an.
Yes, 12
and 13. So, yeah.
That has been constituted.
Yes.
1 hour has been constituted.
Okay.
29.
Yes.
May I please, my lords? Annexure 4, my lord, that on rejection of a 205 CRPC petition.
Where are you?
My lord, 138 says NI Act case, my lord.
138, you are accused.
My lord, that.
Nowadays, everything is in virtual mode.
No, my lord. My petition is my lord staying at Hyderabad and case is my lord for
it is easy.
No.
You can appear through BC.
No, that is not possible.
And 317 also you can take.
205 notice may issue, my lord. What happened in the lordship can finally have an annexure.
Through BC,
Can have annexure 1, my lord.
Yeah, I'll record it.
Like annexure 1, my lord. The partnership of that is known.
Is agreed by an order.
My name is not there, my lord. Annexure 1, my accused name is not a partnership form. Summons or issue, my lord.
In 205, I will not decide. I will only say that you appear through BC. If required, it resort to the procedure under 317 and let it go. How does it make difference?
BC, my lord, from Hyderabad.
Yes, of course. From Hyderabad. Why not? What is the problem?
By taking instruction, my lord.
What instruction?
Whether my lord
Either you are depending upon the instruction, or I.
I'll take instruction.
You file a petition, I'll
my lord, 1 day, my time will to want to take
Why? He is an accused, he will not appear at all.
No, advocate.
Neither BC nor.
I will take instruction, advocate means the riot advocate, my lord.
What is the prejudice that will cause to you if you appear in BC? You are in Hyderabad.
My lord.
What is the big deal about it?
And a businessman, my lord.
It's a ego issue. You are an accused. You have issued a check which is dishonored. You have to pay the.
It is the farm issue, my lord. Therefore, annexure 1.
Those are the defenses you can take even if you are sitting in the BC through your lawyer.
That's
This is
like,
not the subject matter in this petition. Only 205 is rejected. I am giving you full relief. You seek instruction whether your client needs relief or not.
say Gauli millets, remote area from Hyderabad millets.
Hyderabad. You see Hyderabad, now
Whether
remote area.
he is acquainted, we will also be the advocate is also acquainted with the BC millet. Some of advocates, I think,
No.
I'm not telling the all advocates.
People, Hyderabad is a
No,
electronic, what is that? Help.
I'm not taking steps of one time.
Tomorrow. Keep it tomorrow. Seek instruction. I simply tell that through BC he will appear. I will allow your application.
I am going to instruction.
30.
My lord, questioning the NBW order.
When you got bail, when? Bail. You are on bail or not?
Bail.
Tell the date when you got the bail.
Not mentioned yet.
Oh, see.
Yes.
Yes. Petitioner, counsel for the petitioner says that the petitioner was on bail, could not appear and all. NBW issued on 9/11/2023. Give 500. Set aside. 29 February. Yes. 31.
May I please, your lordship. Chairman, challenging the order of cognizance, which is at Annexure 5. It starts from page 37.
Yes. What is the ground?
On the ground that, kind of a glance to page 34 for a moment.
34.
34.
Okay. You tell me orally.
May I read it? It will be convenient. Fact remain, taking into consideration, it is a wife and husband and the family members. Lost the affair by the informant. So originally 307 was not there. The specific IO has given, I am reading out this one. The Diptirekha Mishra, alias Panda 32 years, such and such, PS Jaipur town, Koraput, to be appeared before the IO court and when required for the investigation of this case. During investigation, it is ascertained that as the vehicle and the cash could not be seized, hence 406 may be added in this case, and also as the injury report could not be obtained. Hence 307 may not be added to this. Inspector S. Behra supervised the Mohila PS case number such and self-attended her supervision. Received a note from the Inspector Santoshi and Honorable SCP Zone 1 BBSR UPD with a prayer for order to submit the charge sheet against the accused person, namely such and such the petitioners. Then, my lord, skip the thing. Then last, Koraput under section 498A, 341, 323, 294, 406, 506, 34 IPC. Then next, my lord, receive the order from my Honorable SCP Zone.
Where?
I am reading out 7th line from the top.
Top, which page?
Page 34.
Yes, I'm on that. Receiving.
Receive the order from my Honorable SCP Zone 1 BBSR UPD by the order number 670 SCP-1 on 29/4/2022 to submit CS against the accused person, namely such and such. Under section, this is 307 has been added. When the investigation itself satisfied, there is no question of implicating the petition.
Investigating officer writes something in the charge sheet is not the final thing,
Exactly. But saying something, received a information order from my SCP.
Senior officer.
Exactly.
He is supervising.
In fact, supervising, but the person who is the investigation in charge, she is not satisfied that 307 is attracted.
What is the allegation, you tell me? Forget about whether he is satisfied or supervising officer is not important.
Allegation is
what is the allegation?
At Annexure 1, page 13, Miller. It is a allegation of the informant wife.
Okay, come to that.
It is at page 13.
Who are you?
I am the husband and my family members. In-laws. I can say.
Yes. Show me the allegation. What have you done?
Page 13.
FIR is 307. FIR was 307, charge sheet was filed in 307. Merely because the
But-
IO says that according to him, no case is made out, doesn't make any difference. The allegations are-
But in fact, so far the medical report is concerned, kind of a
Oh,
glance.
show me that.
Exactly.
Show
I'm
me
coming to that.
Ah.
Page 36 for a moment.
36. Now, what is the allegation? Medical report may be grievous hurt.
Nahi,
And intention-
nahi, there is no injury and all other things.
No, show me the allegation.
A-
That's part of
a-
that's part of the allegation where you have manhandled or beaten or something.
That is at page 13, so far the affair story is concerned.
Show me.
The demand of this amount of 10 lakhs for the purpose of making a business for the EV vehicle, you know.
ନାଇଁ ସେଠି କିଛି ମିଳିବନି
ତାପରେ
may kindly down to
subsequently-
page 14
13 ଅଛି।
1 2 3 4 5 6 7 line 7 ମୁଁ ପ୍ରାଣ ବିକଳରେ my lord
ମୁଁ ପ୍ରାଣ ବିକଳରେ
ଚିତ୍କାର କରୁଥିବା ସତ୍ତ୍ୱେ ମୋ ଦୁଇ ଗୋଡକୁ ନଣନ୍ଦ ଓ ଦିଅର ମିଶି ଜୋରରେ ବାନ୍ଧିଦେଲେ ଓ ମୋତେ ଜୀବନରେ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ସ୍ୱାମୀ ମୋ ମୁହଁରେ ପିଲୋ ଦେଇ ଜାବୁଡ଼ି ଧରିଲେ ମୁଁ ସଶବ୍ଦ ହୋଇ
Man, that is the allegation. The affair story is of 2 pages. Man, kind of a glance to the medical report next.
Yes.
It is page 36.
36. Yes.
no external injury.
Oh, you see the type of you
Well, that
tied
is-
the
that is- that is
leg
mere-
and all.
that is the mere allegation.
The injury, where will you get the injury?
And that is the mere allegation, my lord. And this environment belongs to Bhubaneswar. And there is no, so far the injury is concerned, so far the investigation report is concerned. I was released on 41A of all these in-laws and
Is
the,
there any chance of settlement?
ସେଇଟା ଯଦି ହେଇଯାନ୍ତା ଭଲ
that I have to
Think over to
take
settle it.
instruction.
Because the allegations are such, then I don't think you can revive marital life. Better you pay alimony.
Next, I have to take instruction because
I'll simply issue notice, let us see. Don't ask for further anything. I'm making it very clear before that. I'll simply issue notice only to see if we can persuade them to go to mediation and
mediation.
put an end to it.
Exactly.
ସେ ପାର୍ଟି
This can put an end to
ପାର୍ଟି
it.
ନାହିଁ
Party, what is this?
state ଖାଲି ପାର୍ଟି
Yeah, that is the whole difficulty. You not made the party.
ସେଇଟା ପାର୍ଟି କଥା
And
Party
parties.
Informant with party kare matrimonial dispute re to
No, no, that I will do it in, if at all, I will be permitted in course of the day also, in court. Can I be?
do it and tomorrow it will be listed. Tomorrow we list it, we will issue notice tomorrow.
Will I be permitted in
Yeah, it's
court?
permitted.
yes
Do it. The land council for the petitioner submits that he would be impleading the
informant as opposite partner
informant of public injured.
As OPG, OP number 2.
In the instance
First
case, as the opposite party number 2, opposite party number 2, the same may be done you here countersigned by the council and all, issue notice to the newly implemented opposite party number 2, returnable for the day to day. Issue notice where.
It will be to Bhubaneswar.
So that we will allow her to implead and countersign. You don't see when you file the 482 petitions, which are party common format, copy paste and do it. Sometimes the petition name also you copy paste.
No, I will do it right. I'm sorry.
Yes. Next. No, notice. Notice, written about. You implead notice I have issued. Okay.
ଆଉ ଲିଷ୍ଟ ହେବନି ତ
ଆଉ list करे तो
ठीक ଅଛି
implead कर दो तो काहे पे notice
ଠିକ ଅଛି ଠିକ ଅଛି
32.
Because may be protected because the IA has been filed. Because
No
it is-
protection. Allegations are there. You can go
NBW,
to right court.
NBW issued on 6/3/2020.
ये bail
Bail, my lord, 27/8/2020.
and NBW is
My lord, during COVID period, my lord, everything was shut down, my lord. That
shut down. Thereafter, it is open
my lord.
in 2020 March 2020. NBW issued, and you are coming in 2023.
My lord,
So you pay a little more.
My lord,
1,000. What to do?
my lord, husband, wife,
There are two people.
my lord, 500 each, my lord.
So 500 each. Sure. Yes.
My lord, debt, my lord.
29th you appear, my lord. 29th February. On or before 29th February you will appear, seek remedy available to under law and pay 500 each. Okay. Next. 33.
My lord, at 2 p.m.
Not possible.
Good.
34 matter. Belgium matter, my lord. NPT was issued on 2/9/2023.
Bail.
Bill granted, my lord. Okay, the matter of 2016, my lord. We are on bail, my lord.
He was on bail, but do you have the date? No. He was on bail.
Order was so that I have.
You say he was on bail.
Yes,
NBW issued on 2/9/2023. See, you deserve a cost of 500, but what the 500 each.
Yes, ma'am.
But since you are appearing, it has to be more. Bar council member and.
Example for.
Huh? 500 each. Yes.
35. 35 minute kindly pass over.
Pass over.
36.
2 o'clock, my lord.
Pass over 2 o'clock.
Because, my lord,
Yes.
actually, I have some problem after lunch. Can
put it
it be
next week.
taken up tomorrow?
Next week. Tomorrow will be.
Any day convenient.
No, my
Next
lord, it is a 205 petition has been rejected. The date is fixed to Monday, my lord.
Monday.
So on that day, if you will not appear, then
All right, let it be taken up 2 o'clock. Here, my lord, 205 is not maintainable. This court has already decided. He appeared before the PMLA court in 2017 through lawyer. Sorry, 10/12/2018, my lord. From 2018 to 2023 is going on taking time. His 205 was rejected on 7/9/2023. Thereafter, he had filed an anticipatory bail application 14246 of 2023, which is pending. And under similar circumstances, on same day, NBW were issued to other accused persons. This court, the Lordship kindly see,
Lordship can take note to
bail application,
my senior will
directed them to surrender, move for bail. Court is to consider in accordance with law.
That's right. That is general law.
Now, question is whether 205, unless he appears, gets a bail, whether 205 is maintainable. Same day, my lord. This is for another accused. Accused at 8 and 7. The present petitioner is accused.
I will say that let them go and appear before court.
Yes, my lord.
Move fresh application 205 on me.
205 already rejected, my lord.
No, fresh application they will
My lord,
move.
205 is not maintainable because it's a session trial, my lord. Unless he applies, gives a bond.
No, he has to go and do it thereafter. Thereafter, if
So he
required.
has to first go and apply.
That has to, obviously.
And 205 is not. Thereafter, he can on 317 anytime he can file. 205 is not maintainable.
What do you say? That he's correct there. Technically, 205 is not maintainable.
Lordship can take note 2 p.m. My senior will argue this matter.
And on 205.
Your senior may argue, but have you understood it? You will have to convey what Mr. Agarwal says.
Yes, yes.
Read his judgment. What? 205, what you have to appear and take bail and all.
Yes.
Thereafter, 317 is there for you.
Yes, my lord.
But without appearing in the court, you can't keep on moving 205 and say that I need exemption. It can't be, it is not possible. He has come.
Yes, come.
He has come.
I'm sorry, madam.
What? Yes. Yes, Mr. Bose, what Mr. Agarwal is arguing is, and that too correctly arguing, saying the real
Law decided by my law. I am submitting whatever law decided.
in 205, once you appear and take the bail, then 317 is available to you.
Yes.
But you can't create a situation where you don't go to the court at all and move at the 205. It is not maintainable unless you go and appear and get the bail and avail 317. How 205 will be given to you like this? This is the judgment. What to do?
My lord, the problem
Get over
lies.
it.
Your lordship is correct.
What I'll do is, I can, you tell me, I can give you a timeline. You go and appear, take the bail, and thereafter resort to 270, 317. That's the position of law. You tell me the date. there we can, he will also not oppose, I'll also be lenient. You
Because
tell me the date,
he
when
is-
you going to appear.
He's-
Time, my lord, I never opposed.
That's
Your
right.
lordship, from 2018, I am.
Take appropriate time, let it be first week of March or something. I will protect till then. You go and appear, get the bail and resort to.
My lord, we will not arrest unless
And he making a
if
statement,
any
what
day
else?
your lordship may fix, he should appear.
And
apply for
avail the remedy under law and 317 thereafter. You have the option of 317. That's the law. You can't.
Yes, that is the law, my lord. I have checked up what my senior is saying, and your lordship's order also is that clear.
And
he's taking a lenient view.
After 205, my lord, he has filed, like other accused persons, he has filed anticipated bail application. That is pending.
Yes, I am not seeking bail here.
So, question is, unless he gets a bail, whether 205 is maintainable.
You can't keep on moving.
Should I say something, my lord?
Yes.
So far, 205 is concerned, my lord.
You are telling in favor of him or
No, my lord.
Law, my lord. Question of law, my lord. And I suggest, my lord, your lordship must hear one matter regarding maintainability of 205.
But 205
You're right, I'm with you.
No, my lord.
This
My
is the
lord.
law, what to do.
No, my lord. 205 is concerned, my lord. His personal answer need not be required in the trial court, my lord. His personal answer have to dispense with. So far, 317 is concerned.
That's
He'll go there and
saying in
but
different way.
my lord.
So, my lord,
If you dispense with, he
My
will
lord.
not go and take bail. And
His counsel
and-
by
No, my lord.
required, my lord.
My lord,
Question is,
your
my
lordship
lord,
is one thing. One thing.
Difference is there, my lord.
One thing, my lord. What my friend Mr. Ragada said, 205 doesn't give me a cloud that I will not go on bail. My lord, whenever the law is with the authorities, they can arrest me at any point of time. I am not a absconder that I will flee away from the clutches of the law. 205 gives
But we
me.
need not go into all this.
We have not arrested my lord since 2018.
Yes.
Then you will not, I will protect you.
We have not arrested him since 2018. Your lordship.
My lord, only allegation is 6 lakhs rupees.
It's
Only
not-
allegation.
Not that, it's not that. If you go on marriage, my lord, I will argue. If my friend wants, I will argue.
205, why should you waste time?
27
When
FIR.
Your lordship may give me till first, 2nd of April because he's undergoing treatment due to spinal cord injury. He's undergoing treatment. First week of April, your lordship
When
may
the next date appearing there?
Monday.
No.
Yes.
22nd, my
No, it is Monday.
I am the SPP there, my lord. 22nd
22nd
of this February, my lord.
So you see that,
My lord, on that day he will file. I am giving my words, my lord. He will file application. Your lordship fix up a date. On that day he must appear. Because, my lord, since 2016 this matter is pending. Trial court is unable to proceed because of non-cooperation of the accused persons. My lord.
No, I am not responsible with it. My lawyer is contesting that case.
No. Where is contesting? Your lawyer is seeking time.
I'll simply say no course of action till the next date appearing. You appear and seek remedy available under law. Thereafter,
Your lordship may post it to give it till 1st of April because I've given the medical documents that he's
No
undergoing.
medical document, my lord.
Yes.
Your lordship kindly see.
Your lordship may kindly see the documents.
Index your lordship first kindly see. Serial number
Kindly
10.
see, my lord. One page 159.
No, what I'll say is you appear and revive your application on the basis of medical record.
My lord, there is no medical
Let the
document.
court-
Your lordship,
My lord, I have-
just grant me 1 minute, my lord. Your
Kindly
lordship
see
kindly see
159.
index.
159,
Yes,
kindly see.
2019 document, my lord.
Yes, spinal cord injury. It is
Where?
not every
Show
day.
me,
person.
instead of
My lord, page 159.
159.
9. I have given the entire documents of my medical certificates.
159. Huh?
Yes. And patient attendance. Your lordship may kindly see.
Where-
Bulge. Posterior. margin.
There is no injury, my lord.
At the C.
If your lordship turns to the next page,
Yes.
ECR, leukocyte count, hemoglobin, then your lordship may turn to the next page, 161. And what he has done, 167 and 167, one and same documents, my lord.
Training above the other review.
I've given the documents.
And your lordship kindly see the index, serial number 10, copies of medical reports, page 168 to 170. Your lordship, kindly see page 168.
My lord, that may be a mistake, but that doesn't mean that I have not given the medical documents.
On oath, you have affidavit, you have filed this application.
Index is not a note. The contents of the
Index
petition is a
part of
note.
the application.
1 minute, 1 minute. This is, you say that it's an income tax return.
Yes.
Income, but on the index, my lord, they have said medical
All
reports.
these things.
My lord, 2019 document, we are in 2023.
24.
Oh, many times this happens in index something.
That's true. Index happens. I am not saying. What my friend.
So let us come to the main matter. Unnecessary, instead of wasting time. Let us find out the way.
My lord, in ED case which arises out of this
See,
proceeding, I am on bail.
Now the only thing is you will appear in the next date appearing, or you need little more time.
I need little more. My lord, I need little more time till first week of April. I'll appear.
My lord, it is up to time is up to my lords. Only one situation your lordship may visualize. From 2016, trial court unable to proceed with the matter, unable to frame charges.
That is the reason I'm saying. Look, write down. The petitioner has challenged the order dated 7/9/2023, passed by the Lieutenant Court PMLA so and so. ये पेज नीचे अपना whereby the petitioner's application under section 205 CRPC had been turned down. The petitioner submits that the letter counsel for the petitioner submits that the petitioner is under treatment before court treatment 160.
Privately
he has received some spinal injury for which he is under treatment, and that is the reason he has moved the application under 205 CRPC seeking exemption.
CRPC application was filed earlier, my lord.
That is what he says. That is what he says.
2018 205 petition file ହେଇଥିଲା.
I'll record it. He says, Mr. Agarwal appearing for the opposite party contradicts the statement made by Mr. Bose to say that in fact the 205 application was moved in the year 2018 and the documents.
No, sorry, my lord. It was moved on 2023. Sorry. Other accused has filed earlier. Sorry, my lord.
Malad, there are many accused who filed. Malad, I did not interrupt my senior.
You are able to create successfully able to create so much of confusion. As a result of it, the trial is not proceeding. That's the another.
I never confuse, my lord. Because there are number of accused persons.
Mr. Agarwal submits that indeed the application under 205 CRPC is not maintainable in view of the fact that the petitioners are not on bail and
it's a session tribal matter.
Not bail and it's a
sessions tribal matter. So 205 is not.
And he has relied upon a.
These two persons are co-accused, my lord. The present prisoner is accused number 6. They are 7 and 8. 2 orders I have given.
In this case also they have moved.
They have 205 rejected. Then anticipated bail. Here also anticipated bail has been
He has
filed.
relied upon the order of the coordinate bench dated 9/10/2023, passed in BLAPL number 11179 of 2023, moved by the co-accused Krishna Chandra Das. In the said case as well, the application application moved by the said accused under 205 was rejected, and the
Second page, my lord, paragraph 6 for last line. Application under 20 section 205 was rejected.
Accused was directed to avail remedy under 438.
438, my lord.
Avail remedy under 438 CRPC. Full stop. Yeah, next part. This court may not go into the details of the procedure adopted by the accused persons in this case, but suffice it to say that the petitioner is directed to appear before the court below, seek his remedy available to him under law. Available under law on or before 15th of March 2024. 15th March I have given. 15th March.
End of March, your lordship.
End of March, so 30th March.
Yes.
The date above 30th March and so on. So, full sir. I'm in agreement with the submission made by Mr. Agrawal to the extent that the application under 205 CRPC vis-a-vis an accused who has never taken bail and in a sessions trial case is not maintainable. But I'm leaving it open to decide the case in an appropriate manner.
My lord, one more observation. Your lordship may kindly turn to Annexure 6, page 167, where I'm coming, man. Why I'm saying?
Something you got again, he will show
No, no,
something
no.
and whatever you got.
He is showing the bail order in the schedule offense.
Yes.
That has no connection
No,
with this PML.
kindly wait, sir. Kindly have patience.
Yes.
Why are you jumping?
No,
Yes,
I am
yes.
not jumping all like you, sir.
My lord, I have been
In
granted
the
bail.
schedule numbers you got.
Yes. Your lordship may only say that while considering my bail application.
Learned counsel for the Mr. Bose also points out that insofar as the present petition is concerned, he is on bail in the schedule offences.
Yes.
I recorded
Your lordship also record to his submission that PML offense is a separate and independent offense, and the schedule offense has no connection with this PML offense.
Mr. Agrawal submits that PML offenses being
Separate and independent offense.
PML offense.
Distinct, and
Independent.
separate, distinct and independent offense. The grant of bail in the schedule offense has no bearing in this matter.
My lord, it has certain bearing.
I have recorded the statement. Whatever.
My lord, why it is saying it is bearing? The schedule offense was the first offense.
I think you can persuade the court below.
Yes, no, I'm trying to persuade my lordship. If I cannot persuade your lordship, I cannot persuade the other person.
But in 205,
I know, my lord's hands are limited jurisdiction in 205. But what had happened, my lord, your lordship also should know the scenario. In the schedule offense, I was as an
If I
accused.
would have been in the other jurisdiction, I would have given you bail straight away without listening to me. Because you got the schedule of bail in schedule offense, give it.
No.
That would have been my approach, subject to
45 is bar, my lord.
45 is there.
Constitution bench in Vijay Madan Lal case has said 45 has to be complied with.
Many things has to be said on
That's-
45, you know that.
That's correct, my lord.
Many things has to be said.
And this out of the schedule offense, this proceeding arises. Maybe PML Act is different. I don't dispute it. But question is that once in the schedule offense, the amount is 6 lakhs and not, the PML offense has not made out a case of 60 lakhs against me. It is continuing at 6 lakhs. Once I'm granted bail in that, I should have been granted in this. And 205 would not have been there.
That would be the right argument in the right court.
I think my lord will sit in the right court and I can argue again.
Wait for that.
Yes, sir.
Wait for that.
My lord, no coercive action till 30.
I said
Yes.
that he's
My lord,
making a statement.
we will not take. Because I am there, SPP. Once I said will not take, I will wait till 30th. Your lordship has said I will wait till 30th. Why he is so anxious? I will.
And they've been waiting
in open, in open court.
My lord,
I made a statement.
My lord, I am
I
paid
must
to say.
keep the words of my
I am
lords.
paid to say. My senior is also paid to say. And we are discharging our duties as a lawyer.
Very good. No,
And we have to address your lordship.
I am here to record your statements. That's all. Yes.
Let's item.
On the 90 minutes also. 36.
Well, it's item 36. I have moved a memo for withdrawal of this CRLMC. It has not been listed with liberty to file one afresh.
Liberty.
Yes.
Liberty is always there.
Your lordship may record that.
And even if liberty is not there, lawyer of your caliber can find out some way out.
I'm grateful. My lordship may record with liberty.
Liberty.
Great.
Liberty too.
37.
May I please, your lordship. Lordship, the present application is filed against the cognizance taken up by the learned JMFC Malkangiri for the offences under section 498A, 294, 323, 506, 494.
Your husband?
Yes, my lord.
You are the only accused.
Yes, my lord.
Age? You are 62.
My lord, I am not the, like, as per the order, may kindly have a glance at page number 24.
Your husband.
Yes, my lord.
Your age is 62. That's what I'm saying.
Yes, my lord.
62. Yes.
Judicially, like, the order of judicial separation is passed by the learned family court judge, dated 18/8/2004.
18/8/2004.
Yes, my lord.
And when the FIR?
FIR was lodged on 15/3/2021 by the informant.
So what do you say?
My lord, may I be permitted to proceed with the
When
facts?
the offences are relatable to which incident?
My lord, it is that
2004 is the judgment.
yes, my lord, page number 24 under annexure 3. My lord, may kindly have a glance.
Judicial separation.
Yes, my lord.
Thereafter, you never stayed
No, my lord.
with her.
Yes.
And what are the allegations now?
Allegation is that, my lord,
Pertaining to which year?
allegation written to 2021. It is that, my
Yes.
lord.
My lord. But in fact, my lord,
No, there is a judicial separation in 2004.
but again,
He
my
is not saying 2021. How will you torture and all?
Man, after that, my lord, he was in his service, my lord. After retirement, he got second marriage, and thereafter, my lord, he called the son of the first wife, my lord, and also the informant, my lord, and a brother of the informant, my lord, and thereafter the occurrence taken place, my lord.
My lord,
2021, my lord.
may
For
we-
that,
Occurrence.
It
in
is
so
that,
far
my
as-
lord.
Hey, occurrence in so far as the other offences are contained. 498 is kya hai?
judicial separation,
After 19 years,
judicial separation, the 494 is there, my lord.
may I be permitted, my lord, one thing, that the husband, petitioner, called the son for his share of landed properties towards his favor. That is the only reason why the petitioner called.
I will only issue notice because it is a matrimonial list.
Yes, ma'am.
Okay.
Yes, ma'am.
Don't ask anything.
My lord, an IA is filed 2379 of.
Lordship, pardon, Lordship. Notice issued, Lordship, as per direction of Lordship. But wherever not known, as per wherever not known.
Sorry, I didn't follow you.
It is written, my lord.
Notice
Notice
written.
written with postal, my lord. It is submission.
Oh, notice was issued.
Yes, my lord.
Nobody is appeared. Huh?
Yes, my lord.
Address cannot be located, man. Insufficient address, due to insufficient address.
सर होम एड्रेस से पठायला जो हिसाब रे देइतले एफआईआर जो एड्रेस
देखो नोट
Press notice to go,
प्रेस नोटिस करी तो
Yes, ma'am. Madam, on IA 2379 2023 is filed, my lord, for stay. But in the meantime, my lord, at any date trial may be started. Yes, my lord, that-
investigation going on.
No, charge sheet has been filed.
Okay, then charge sheet in the
In the meantime, I will file a charge sheet.
charge sheet then
you don't know anything what is happening.
charge sheet
No,
then
my lord, charge sheet has been filed dated
When
11/4/2021.
file the charge sheet, we'll see.
Yes, ma'am.
Take fresh steps. I'll give you short date.
Yes, my lord. I'll file the charge.
Okay.
My humble prayer, my lord, for a stay of the cognizance.
What I'll say, I don't know whether charge sheet
Charge
file.
sheet.
He doesn't know anything. You are showing some paper, keeping into your pocket. You have not placed on record.
Today morning, my lord, I received the.
So then we have to place it on record. How can judicial orders are not passed like this, sir? You have to place on record something.
Well, by next date, my lord.
You file it, then only something has to come on record to pass some order. No? Otherwise, how can we pass the order?
My lord.
Yes.
No. Continue.
No, you file it. I'm giving it time.
Yes, ma'am.
There is no point. You file it.
Yes.
Properly. The petition has to be framed. Yes.
By next, which date, my lord?
date. 6 months.
6 months.
Any yes. Mentioning.
My lord,
What mention?
no, my lordship, item 72 on behalf of Mr. Das. He has some personal difficulty. He has requested me for an adjournment next week, your lordship. My lord.
Already. Somebody mentioned it.
72, my lord. Oh.
Any mentioning?
No,
Yeah, yes, Mr. Rati.
Well, item 42 is there.
Huh.
I'm sorry.
No, it's all right. No, that's what I'm mentioning. So that there are a lot of matters. So if something
Exactly.
is
Item 42,
urgent,
there is a note. There is a noting
Hmm.
that the notice pursuant to my lord's earlier order, we had taken out notice on the private opposite party number 2. The report is that it is received in the SO, means probably in the post office the notice has reached.
But it is awaiting that.
It
has
is.
to
So what I am trying to request is kindly direct the registry to verify the tracking report and place it along with it.
42 note kori mat hoye. You need not come.
Grateful.
I'll take care. 42. Any mentioning? No. I have passed the order.
My lord, I want to withdraw it. I've informed Mr. Agarwal. Permitted to withdraw to file a better application if the cause of action so requires.
Counsel for the petition published that he wants to seeks to withdraw this petition, keeping the liberty alive to move appropriate application if cause of action survives.
Grateful. That previous order.
That's item 35, no?
35.
35. The order
There is a matter before Lordship's Board 81. And for the petitioner, no, presence. Agarwal. Every day हुए तो आज
your petition
Your Lordship, sir, record his presence. And my lord, at least I will not speak a false
No. It is your petition. It is your wish. If you want to withdraw.
Until the other day, Maharaj, Mr. Maharaj, a king, his name is Maharaj, my lord. He was accommodating everything. He submitted that I will inform the party, that is good enough. He says, no, let Mr. Agarwal come. He has changed sides.
He has a love for Mr. Agarwal.
Look how people change sides. My lord.
Some government council have little euphoria against me, and he is one of them. They have developed a euphoria against me. But I don't know why that euphoria has come.
Love it. They love it. Don't worry.
Maybe that love euphoria may be there.
Maybe love.
Maybe love
and that will be now culminated to some party in the evening.
No, Thursday will not give. He may shift it to Friday.
Friday.
Yes. Your Lordship, there is a matter before Lordship 81.
81, yes.
We have reached to a compromise. So your Lordship may take it around 3 o'clock if possible better. Both parties.
81. Compromise where parties are there. What is the offense?
493.
493? 493. Parties are there.
Parties are.
You bring them, we will do it.
They are on the, in fact, they are making this pass, your Lordship. That's why.
It's all right. Whenever they come.
Whenever they
493.
Pass over item 4.
Adjourn.
Item 15.
May I please one case?
One side.
The peculiar case in this case, my lord, pursuit of paper is made clear. Facts of the case is like this. There was a suicide in the village.
No, what is the stage of the investigation?
Investigation is going on.
Let it go on.
My lord, I mean, what I say, my lord, kindly glance to page 3, paragraph 4 of my petition. It is added that without any regulation, the petitioners have withdrawn the amount. In the meantime, there was compromise, and the amount has already been paid to the parties.
You compromise.
My lord, my lord, page 4, my lord, kindly glance.
Now I take your statement. You have compromised.
And also, the amount was given in presence of the inspector, but there is no receipt to that effect. But there is a video clipping.
That I'll not examine everything.
That is true. Well, let my friend take instruction. In page 3, paragraph 4, I have above. That it is something.
Oh, I simply issue notice, let him verify.
He is not making the, my lord, made the in front of the party, my lord. I will implement better, my lord.
Minimum that I don't know what is happening.
If not compromise, then my lord, not necessary.
You implement first.
I will implement. There, my lord, will notice. I will.
You
course of the day.
You implement during the course of the day. If opposite the informant is implemented, issue notice to the newly added opposite party. Number 2, written over within 1 week. 1 week. Next week, time given. And the letter counsel of the petitioner says submits that he has settled the dispute with the opposite party number 2, hence seeking indulgence of this court for causing release the matter on 16th of 16th. Will do 16th.
Another thing. I have already paid the amount. Then I pray that no courts of action.
No
courts of action. That is true. No courts of action.
There are 2 consequences. No courts of action means I have to stop the investigation has to be stopped. Which no court can do it.
No courts of action against the petitioner.
So then anticipatory bail.
Accidental filing. Accidental filing.
But nobody is going to arrest you. Why do you?
Petition 1 is a lady.
16, nobody is going to arrest you in this way. Item 18.
Petition 1 is a lady and suffering from different ailments.
Upon the instruction given not to precipitate the situation. If the
ladies.
No, not to precipitate. If they settle the dispute, why do you precipitate by arresting them and unnecessary credit? You just pass on the instruction saying that they have settled and don't take any action. You will do it, no problem. Next, 18.
18, my lord. The petitioner has not been named in the affair, and the petitioner apprehends that he may be charged sheeted. And I have not implicated the informant. I will be implicated in course of the day.
If he is not named in the FIR,
not named,
and you are apprehending that he may be included in charge sheet,
that's it.
So therefore, you want an injunction order from me.
My lord, another thing, my lord. In CRLMC number 171423, Snehasi Samal.
What is your grievance?
My grievance.
If your name is not there in FIR, keep quiet. Why are you filing petition? On the apprehension that you may be an accused in charge sheet. What is this?
My lord, the similar in respect of the co-accused, one person has approached this annual court and no course of action has been taken in CRLMC number. No. But that order is not with me.
Whatever, I will not. You are not an accused, I will pass an order. On the apprehension that you may be an accused, so therefore, I have to, in a 482, I will pass an order of no course of action. What is this? Let us have a limit to the jurisdiction of 482.
But the similar, but since this coordinate bench had passed an order.
Unfortunate that.
But I am fortunate. I am fortunate arguing before.
But see, I can't stress the jurisdiction to that level. Right?
Let it be adjourned.
I am adjourning it. You implead them. We'll see.
Okay.
I am simply adjourning. When do you want?
Next week, any day.
Next week. You give next week? 21st. 20.
But
you implead them.
In course of the day. Both the files may be handed over to me so that I can.
Both the file you the
15 and 18.
Okay.
Yes.
25.
Yes.
In this case, the petitioner is an unfortunate husband, my lord. Challenge the order passed by the
petitioner is
25. Is an unfortunate husband, my lord. He has challenged the order.
Unfortunate husband.
Yes, my lord.
You simply say husband, it is enough.
My lord. Because why I am saying, because the your lordship can appreciate at page 33 under annexure 5. He is going on paying the maintenance allowance in respect of the a major son. still then your lordship can appreciate at page 35, 33, annexure 5, my lord.
Yes, what has happened?
Your lordship can appreciate that. My in the wherein my petition for stay of the execution case that has been rejected, wherein I have stated, your lordship can may I read out my lord?
You have come against which order?
Order dated
11.
30/11/2023.
What this order
Wherein
is
my
passed
order dated
in execution.
execution application, wherein I have stated that since my petition for final order for maintenance has been passed ex parte, in which I filed an application to set aside that petition. That the petition is pending since long. Instead of considering that, I am going on paying that amount.
There is no stay execution.
Exactly that for which I filed an application for stay on the ground that my son has become major. That may be considered. That was not considered. Kindly appreciate. I have filed under Annexure 7.
That you can ask to vary the main maintenance order.
Exactly. That is they are not
Where is
considered. That is yes. That is at Annexure 1, my lord.
Annexure 1.
Yes, my lord. Page 17, relevant portion. My lord. Ex parte order has been passed. Page 17. The petition under section 127 filed
by the order dated. By the order dated. What is the date of this order? 26/6/2019. An ex parte order has been passed against the petitioner by the court of family by family judge Khurda. Inter alia directing the petitioner to pay the maintenance to the petitioner to the opposite party. He has moved application. Counsel for the petitioner submits that he has, although he has moved an application for varying that order, varying the said order.
Yes, ma'am.
But the application is not taken up for hearing as yet. In the full sum. In the meantime, the opposite party has pressed for execution of that execution of the ex parte maintenance order, and the court below, which is the impugn order?
That is Annexure 5, page 34, my lord. 30/11/2023.
By the plus court below by the order dated 30th November 2013 has directed has rejected the application moved by the petitioner for staying the execution proceeding. Therefore, the prime grievance of the petitioner is that his application for varying the ex parte order, maintenance order, needs to be expedited. Accordingly, it is directed that the application. Where is the application?
That is under Annexure 2, my lord. That is to set aside that ex parte order.
Application moved by the petitioner under section 226 bracket Roman 3 CRPC pending before the family judge
Khurda, my lord.
Khurda.
In CLP number 360 of 2009.
Directed to be disposed of within a period of 1 month. Hence, accordingly, this is
till that order may be stayed, my lord. That is because now he is pressing hard to that order dated 3 till that date.
Maintenance in any case you have to pay.
But I will pay, but till disposal of that may be stayed.
Till disposal, she will not eat also. Maintenance is only for vagrancy.
But
you have to keep on paying. It may be little higher, maybe little lower.
I am
that
keeping
will be decided.
That I have already. Your lordship can appreciate. I have annexed all those documents.
Maintenance order, no interference.
No. Maintenance. No. The execution application that may be kept in abeyance. Still that decision. That execution they are proceeding with the execution case.
Within 1 month, it will be decided. In any case, the execution.
At least till that date, lordship only till that.
No, maintenance order. See, somebody's survival is question.
No. I am not praying for maintenance. Stay of the maintenance order. I am praying that the execution application he is pressing.
Subject to petitioner continuing paying the maintenance is awarded, the execution proceeding is stayed.
Oblige.
Subject to paying.
Yes.
Same thing.
Yes. I am paying. Only
subject to paying the maintenance is awarded in favor of the opposite party.
Opposite parties.
By the order dated, what is that order? By order dated 26/6/2019, the execution proceeding pending before the court on so and so, so and this.
Yes.
Till next day.
And that application will be considered within
That-
1
that- that-
Yes, ma'am. Oblige me.
33.
May it please, Your Lordship. Your Lordship, this is a quashing petition, my lord, wherein we had challenged the order at Annexure 3, page 80 of Your Lordship's brief.
Yes.
Now, my lord,
This is the impugned order.
this is the impugned order at page 80, Your Lordship. Your Lordship, if I can, if Your Lordship comes to page 82, the 1910-2023 order, may I just take Your Lordship through the order?
Yes.
Now, my lord, it says the petition filed on dated 13/9/2023 under section 319 of the CRPC by the learned public prosecutor is placed for order. The learned public prosecutor submits that there are ample evidence against Shamsundar Patra, Vishwanath Patra, Gopal Chandra Patra, Ramachandra Patra, and Chintu, alias Ananda Prasad Acharya, to prosecute them under section 120B, 302, 109, 34 of the IPC, as they were implicated by the prosecution witnesses, that is 3,
All the
4.
witnesses, okay.
No, 3, 4.
Ah.
Now, my lord, now, my lord, may kindly turn over. So what the learned court does is, from the next page onwards, they have quoted those portions of the evidence of those prosecution witnesses, and my lord may kindly come to page 85 at the bottom. Therefore, my lord gets it, my lord, the last paragraph.
Yes, I know.
Therefore, I am satisfied that a strong prima facie case against the above named 5 persons, this under section this also exists. So cognizance of offense under this is taken against the accused persons. Now, my lord, then they ordered for a de novo trial. Now, my lord, I'm challenging this on 2 grounds. Now, my lord, number 1 is this is the same, whatever it has been quoted as the same as 161 statement, same as the FIR. Now, my lord, those were done. The police in their charge sheet considered all that and then did not proceed with it. I'll take your lordship. My lord, may kindly have the charge sheet.
Then even then there is no bar.
There is no bar. I bow down. But now, my lord, I rely on a judgment, Hardeep Singh, which says that what should be the standard? The standard cannot be just a prima facie case in such a case, my lord. Now, that's number 1. Now, my lord, number 2 is, here is a case where
Loosely using in word prima facie will not take out the fact that the evidences has come on record. See, there are quality of evidence you will see. The police, when recording 161 statement, the witnesses might have said. That is not, those are not evidences. That is only to have a prima facie view to file for the purpose of filing charge sheet. Charge sheet is filed. Now, full-fledged evidence is taken. And in those evidences, your name is.
I completely bow
copied.
down. My
So
entire.
therefore, 319 is invoked. What is wrong in it?
No, my lord, there is
And
nothing.
you will be acquitted. What is the big deal?
No, my lord, the what I'm
will
relying
not
on is the Honorable Supreme Court says, why should I even face trial if you're only basing on the fact that whatever has been repeated? My lord, may give me some, I have got judgments. Let me place your lordship. That's my lord has canvassed my point. My lord has limited my point. My point is, if I can canvass to your lordships that there is nothing new whatsoever from the 161 statements.
Now, I can't compare the statement of PW, all these PW, vis-a-vis 161.
No, my lord, I'm not saying that. I'm only saying.
That will be tested. You can confront them when they are cross-examination in so far.
My lord, my humble submission is this.
You have not said that those things in 161. Why are you saying this?
No,
Or
my lord.
confrontation that
No, my lord. In fact, my humble submission is it's the reverse. The point is, my lord, what is in short, what has happened? Somebody has gone to the FIR and have said, this is what has happened. Now, my cousin sister was there present. She said that whoever came and shot the husband said this statement. So that this people are involved. Now, the wife does not say so in the witness itself. I'll show. Now, number 2, my lord, interestingly, they have been repeating all these PWs that has been written. I'll show it to your lordships. They have been repeating that they had some bad blood with these people along with some others.
By the way, where are the statement of these witnesses you have placed on?
My lord, may kindly.
Where are those statements?
My lord.
This is the 90 to 193.
Yes, my lord.
It has to be analyzed. Every evidence has to be analyzed.
No, my lord, I'll just place.
Trial court has only extracted part
I bow down, my lord. My lord, my lord, may kindly see the informant. PW3 at page 98.
90.
8, my lord. 98.
Yes.
My lord, has it? My lord, deposition witness number 3.
Yes.
I am the informant in both the cases. My lord, has it? My lord, the relevant portion is next page. If your lordship wants, I'll place the entire thing. The occurrence, my lord, para 2, the occurrence was taken place on dated this morning at about 7:30 a.m. in near the house of Abhimanyu Ponda at Patrasahi, Baliguda. At the time of incident, I was in my house in that Patrasahi. One Sobita Pradhani informed in my house expressing that someone has fired on Abhimanyu Ponda and he has led there on the road at Patrasahi in front of his house, sustaining gunshot injuries. After hearing the same, immediately I rushed to the spot and found that my cousin brother Abhimanyu Ponda has been led on the road, sustaining gunshot injuries on his chest, facing upwards, for which immediately I rushed, shifted him through an auto rickshaw to Subdivisional Hospital, Baliguda. Sometimes thereafter, the doctor declared him as dead for his gunshot injuries. Thereafter, I came to the spot and found that one Khoka has been led near the spot. Then I asked about the incident from the wife of Abhimanyu Ponda, who is my sister-in-law, namely Chabirani Ponda. Chabirani Ponda disclosed before me about the incident by stating that sometime before the incident, 2 unknown persons came to their house and asked about their husband, that is Abhimanyu Ponda. At that time, her husband Abhimanyu Ponda was at the backside bari of the house. During that time, Abhimanyu Ponda came to near the 2 unknown persons, that is near the front gate. My lord, kindly note the following. The said 2 unknown persons asked Abhimanyu Ponda about the Balikuda Jagannath temple and asked him why he has become a trustee of the said Jagannath temple and why he is challenging the activities of Shamsundar Patra, Biswanath Patra, Gopal Chandra Patra and Ramachandra Patra. And during that time, one among them shot Abhimanyu Ponda through a pistol on his chest, by the result of which Abhimanyu Ponda fell down on the ground there.
Then your presence is there.
My lord. So now PW3, who is not the eyewitness.
You can very well say that no overtake is attributed to me, but my presence was.
No, my lord. Just bear with me for a moment, my lord. I'll just press it.
34.
Now, PW.
Under the age of 34.
My lord, just bear. My lord, PW3, as I said, is not the eyewitness. He is saying, I asked my sister-in-law, and she said that. My lord, may kindly see the sister-in-law, PW7, starts at 117. So, my lord, what he is saying is I asked sister-in-law what happened, sister-in-law narrated this. Let us now see, my lord, sister-in-law narration.
Okay.
My lord, starts from 117, my lord. PW7. The informant Nirmal Sahu is my lord, has it?
Yes.
Is my cousin brother-in-law. The deceased Abhimanyu Ponda is my husband. Now, my lord,
Yes.
my lord, may kindly see para 3. At the time of occurrence, I was seated near the window, which is faced towards the main gate of the house, and my husband was inside the garden, which is situated by the side of the house. At that time, 2 persons came in motorcycle in front of the gate. One was one orange color jacket and another one sky color jacket. One of the said 2 accused persons, Ramanarayan Nayak, came to the house passing the gate, for which I came to the front door of the house. On seeing me, he asked whether this house belongs to Abhi Sahu or Abhi Ponda, to which I answered that this house belongs to Abhi Ponda. Then he asked whether sir is at house or not, and I replied that he is in the garden. After that, he got down from the staircase of the house. On the way towards the gate, the accused Ramanarayan Nayak met with my husband and discussed about temple matter and also tried to show any further document to my husband, for which my husband along with the accused Ramanarayan Nayak went towards the gate and in front of the gate. At that time, the accused brought one small gun from the dicky of the motorcycle and suddenly fired as my husband, and my husband fell down. Now, my lord, what I want to press is, she is the so-called eyewitness. Now, she does not name anyone. Now, what the other person is saying that I found out from her, he is narrating the detail names. And my lord, may kindly see, why am I pressing on it? My lord, may kindly.
How many eyewitnesses?
No eyewitness, my lord. She's the only one. She's the only one, so-called eyewitness. My lord, may kindly see the charge sheet. No, my lord, may kindly.
I understood.
My lord, may kindly see the charge sheet. No, my lord, what is important is the background.
300 line, I'm not passing an equitable.
No. I am only saying, my lord, why?
What you are trying to convert is that the single eyewitness doesn't say anything. The other eyewitnesses are saying that I heard Here's
I
evidence.
completely bought it. No, my lord, also the fact.
On if the main accused has not said, main witness has
completely
not
bought
said
it.
anything, on the basis of here's evidence, why have you called?
I completely bought it.
That's
Now, my
what
lord,
we-
one more. Why I want to stress on it, my lord. My lord, kindly see page 76. What was the police? My lord may say that what police said is not important, which I bow down. I'm only trying to canvass to your lordship the background of this case. Why was these names taken? That is at page 76, because that would assist
70?
your lordship. 76. That is part of the charge sheet, my lord. I only wanted to.
76.
So your lordship has a better understanding of the
No,
dispute.
I'm in the process. 76. Yes.
Page 76, my lord. 16, the last 7, 8 sentences from the bottom. My lord has it, hence not other.
One.
Yes.
6, huh? Yes.
My lord has it,
Yes.
page 76. This is part of the charge sheet, my lord.
Yes.
My lord, last 7 lines from the bottom starts with hence not others.
Hence not others.
Yes, ma'am.
But
But Nirmal Kumar Sahu, who came forward saying he's the cousin brother, lodged this FIR about the occurrence, who was not an eyewitness to the occurrence, and reported against the 4 brothers of Patra family, such as Gopal Krishna Patra and his 3 brothers, to have involved in this case as because the deceased and the temple committee president jointly had taken steps to vacate the medicine shop of Gopal Krishna Patra a few days back to the incident.
you are one of the brothers.
I'm one of the brothers. I'm 3 brothers, man. The complainant lodged this FIR on suspicion that the Patra family could have done this incident, taking to the shop vacated issue as because there was no specific identification of the accused persons. Hence, getting no idea, they directly indicated the possible reason of dispute, and moreover, there was bitter family rivalry between the complainant's family with Gopal Krishna Patra's family. Both the family heads lead 2 different political parties in Balikuda and prominent during time of communal riot in the year 2007-8. Many cases were registered, out of which the father of the complainant, Nirmal Kumar Sahu, namely Gangadhar Sahu, has been arrested and forwarded, who vehemently alleges that Gopal Patra family responsible for his involvement and to remain behind bar in PS case number this. Since then, Cold War between both the families prevailed till date. Hence, without taking a second thought, they wanted to indulge the Patra brothers into the case, as it was totally a blind case. Even if the complainant mentioned
Between 2 families.
my lord, that is my
That's perhaps the reason the Gopal Krishna's family members are.
my lord. In fact, they also said, my lord,
There are 2
interestingly,
points.
there are 2 points. Interestingly, the next line, my lord, they in fact, while he gave the FIR, he said there was somebody came in bullet. No, my lord, because their family has a bullet, but they found out it was not even a bullet; it was a Honda vehicle, my lord. So
That is again the micro reading of.
I completely bought. I was only bringing to your lordship, no, there is prior dispute.
There was a background
My lord.
that there is a family dispute between Sahu family and the Patra family,
My lord.
and one of the Sahu family person is
Informant here and
informant, and
he has
therefore
tried
there is
to-
all likelihood that the other family of Krishna Chandra Patra could have been implicated.
Yes, my lord. And
that
to be
again proves that the charge not filing charge sheet against the
My lord.
other member of the
My lord, and to be, my lord, fair to your lordships, the other people, apart from 3 and 7, there are other also who have named me in their deposition statement. But all are consistent. No, all are consistent that he had bad blood with them, which we are not denying. We had certain disputes, my lord. But my lord, it's like saying if somebody unfortunately passes a friend, and I say he had bad blood with 5 people or 3 people, then police found out it is 2 people.
So there is only one eyewitness. She has not.
The wife, correct.
Yes. Yes.
My lord,
I'll also judge
number 1, the 482 is not maintainable because this is a final order. 319 order has been passed, which is a final order, which is revised. That is 1. Number 2, my lord. Number 2, my lord, what has happened? This is a case based on super.
Do you have any judgment?
Yes, your lordship.
319 is not a final order.
I have got judgments, my lord. If your lordship wants, I can do it right away, my lord. Or I will wait.
My lord, in this case, what has happened? The deceased was killed by engaging supari killer. This engagement has been done by these people.
Where is the evidence?
My lord, that is evidence because the person who have come.
None of the witnesses have
Your lordship,
said that
your lordship may kindly.
family
police-
member have engaged Supari killer.
My lord, Supari killer, because that has been proved, they have been arrested. Subsequently, that Babuli Muni, who has taken the Supari, he has been arrested very recently. After 2 to 3 years.
After this petition is filed.
Yes, no,
Yes,
no, not
Mr.
after this petition.
Before-
When trial was going on.
After 319 or before 300?
No, before 390. Before 390. My lord, in the 119, your lordship may kindly see 119 page. Partly he has shown, but the portion which is relevant for the purpose. And there is no family rivalry. Background of the case is that in Baliguda there is a Jagannath temple. That temple was not indexed. On the basis of the demand of the people of Baliguda, it has been indexed. Right now it is a government.
It has come on record that there was a family rivalry.
Endowment. It is coming right now on endowment. My lord, the deceased and one Madhusudan Das, they have been selected as the non-hereditary trustee of the temple in 2016. In spite of and these Ramchandra Patra, Samsundar Patra and all those, they were earlier, when the temple was not indexed, they were managing the temple. And they have misappropriated a huge amount of money. After it has been indexed and they have been selected as the non-hereditary trustee, they didn't give them the hand over the charges, for which several litigation have been filed before this honorable court. By virtue of the order of this honorable court, ultimately they could manage the temple, but as on that Samsundar Patra has not handed over the charges. Recently,
So
another
that goes to show that there are rivalry.
rivalry, not personal.
The
That
family,
is-
family
no,
who,
not
who will have the
family.
control and all.
No, my lord.
In the
That
village.
is not relating to any family. Because, my lord, this Abhimanyu Panda and Samsundar Patra, they don't have any link except this Balikuda Jagannath temple.
But at this stage, I need not go into all these things.
My lord, but
exactly-
your lordship may kindly see. Paragraph 8, 190.
119, I am there.
Yeah. Prior to the incident, there was enmity of K. Biswajit Patra because they were, my lord, in occupation of the sub rooms constructed by the Baliguda Jagannath temple, but we are not paying the rent. K. Biswajit Patra, Samsundar Patra, Vishwanath Patra, Ramo Patra, Chintu Acharya and Gopal Patra with my husband in respect of the property of Lord Jagannath at Baliguda, because Samsundar Patra was the ex-secretary of the temple and he has not given charge of his seat to his successor, for which there was
That goes to show that there was a dispute.
dispute. Not there is nothing personal.
No, I know that because of the temple only, who will have the control and all.
Because I have been selected because of that.
77 also say the same thing.
Yes.
Because of Jagannath
My
temple,
lord, yes.
some cases are registered and.
My lord, paragraph 9. Prior to the incident, my husband has lost FIR against the accused person regarding the temple property and threatening him. This is the copy of the said FIR, so and so. They have given
I
threatening.
understood. Yes.
Then your lordship, my managing trustee, that is also very material. Managing trustee.
Are you on bail?
My lord,
Are you on bail?
No, my lord.
they
I mean,
can
my
file
lord,
a
it was,
petition for bail.
my lord, it was listed today. They have been, because the 319 order came in, we have asked for time because we moved to your lordships. Today, there was the last
Looking
day.
into the peculiarity of this case,
My lord.
what best I can give you, I will protect you, sir.
My lord, may stay that 319 order. I'll tell you why, my lord. I'll try my best. My lord, may kindly see the same paragraph that my
There are
learned.
very many facts which are jumbling.
My lord, may
So
kindly.
it has to be sorted out in trial.
Yes.
My lord, just give me 2 minutes.
You give so many facts, he is giving so many facts. I have not heard him. And he
My lord,
It is
further
on
facts.
record.
my lord, there are no facts. With all due
The idea of
respect,
trial is to find out what
with
is
all due
fact.
respect to my senior, my lord, there is none. They're just beating around the bush. My lord, may give, I'll rely on the same paragraphs. My lord, may come to 119.
Understood it.
No, my lord. My lord, because there is some confusion. I'll try and best. My lord, please see 119. No, what has she? No, my lord, I'll just say. Please have para 8. she has named 6 people or 5 people saying that these are all, they had enmity. Now, my lord, the first name itself, K. Biswajit Patra.
It is,
No,
it is
no, my lord,
double-edged weapon, you know.
Yes.
No, no, my
If
lord.
you say there was a rivalry, therefore they have implicated me. In the same time, there was a rivalry, therefore you have done it also.
Yes.
So both the things are, it is double-edged weapon.
I completely bow down. I'm just stating.
You are saying that since there was a rivalry, so therefore there is all likelihood that they have implicated me. And now Mr. Maharaj will argue because of the rivalry you have given superior to kill. So these things have to be sorted
I
out.
completely bow down.
I can't do it.
My lord, I completely bow down. Let me just, I only pray your lordship for an indulgence, my lord. They have named 5 people. One of, my lord, may kindly see para 8. She has said as a wife, para 8. Now, prior to the incident, there was enmity. K. Biswajit Patra. K. Biswajit Patra has been, my lord, he was charge sheeted. The other people were not. Number 1. Now, number 2.
Family, entire family.
No, my lord. K. Biswajit Patra is not, K. Biswajit Patra is not related to me. K. Biswajit Patra, I am not here for K. Biswajit Patra.
I understand it. You are for Sham Sundar.
Exactly, my lord. And my lord, she said that the shooter was arrested. My lord, may kindly see para 76. He was arrested much before the charge sheet.
My lord, yes. Because he.
So what is, and now my lord coming to law. My lord coming to law.
Camera.
The fact
they have
is,
been arrested.
my lord, the fact is they have been arrested.
The shooter.
Shooter have been arrested.
Okay. He has given disclosure.
Nothing, my lord. That's
My
what I'm
lord,
saying.
He has stated before the police that
Again,
that I have been engaged by so and so, for which Babulu Muni's name came into the picture, who has taken the supari.
my lord, these are stories. My lord, my point is, I would not have any case. No, my lord.
In the criminal matter, stories would be there.
No,
Your
no.
story, his story.
No, I'll say
In the
stories
trial,
with
story is correct. We have to
I bow down. My lord, stories without any basis. Now, my fact is this. Now, my lord, if the lower court would have.
Don't you think that we are laboring hard at this stage for no reason?
My lord, if your lordship thinks that I'm wasting your lordship's time, then I have nothing to say.
See,
I am only.
What best could be done, you tell me. Because 319.
My lord, my lord, if I am not able to satisfy your lordships,
You are
that
entitled for bail.
my lord, if I am
therefore, I'll
not,
protect you.
my lord, if I am not satisfying your lordship, that this entire order needs to be thrown out. If your lordship gives me 5 minutes, then I'll not press for anything, my lord. I have got judgments which says categorically that you cannot just quote evidences of people and say there is prima facie case. My lord, my lord, I'm asking for only 5 minutes. My learned senior is raising that it is not maintainable. My lord sees it. Yeah. My lord, give me 5 minutes by the clock.
It is final order or not? That is
a final order.
My lord, 5 minutes by the clock is what I'm asking. My lord. 5 minutes by the clock. Now, my lord, may kindly see this. My lord, may kindly see the first paragraph itself. Leave granted. First, we take up the appeals of Prabhu Chawla and Jagdish Upasana and others as these two.
I know this.
My lord, it is clear. My lord, may kindly see. So 482 is maintainable. It clearly says and have already reversed, my lord, the judgments given in Mohit.
Maintainable. Therefore, I'm going one step ahead to give you something. Take it and go and fight.
No, my lord, just see this, my lord, with your lordship's permission. If I can just show your lordship single judge bench of Allahabad High Court with your permission, my lord.
Prabhu Chawla,
No, my lord, this is very interesting, my lord. My lord, may kindly have a look. My lord, may kindly have a look. Now, first outset, my lord, may kindly ignore because the first case was whether this is maintainable. My lord, may kindly come to para. Now, my lord, may kindly come to para 18.
Yes.
My lord, has it?
Yes.
By means of the instant application under section 482, prayer has been made to quash the summoning order dated this, passed by the learned additional district sessions judge under section 319. Learned senior counsel appearing for the applicant submits that by means of the instant application, the applicant has assailed the impugned order dated this, passed under section 319.
It was entertained.
My lord, what was done here, my lord? What was done here, my lord, may kindly see. Quoted exactly quoting, my lord, may kindly see. My lord, para 26. This court has also noticed the fact that initially the present applicant were also named in the FIR and an investigation was done, wherein his name was expunged as the investigating officer while collecting evidences against the accused person did not find material evidences with respect to involvement of the present applicant, and thereafter final report was submitted. it also transpires from the impugned order that the trial court found that there is prima facie case against the present applicant, whereas as per the law laid down by the apex court, more than prima facie case, as much stronger case is required while summoning such accused, thereby invoking the jurisdiction under section 319 CRPC. The power given to the court under section 319,
Again, it is remanded back.
it is remanded back. But my point is my lord, I will not stand on the way if your lordship wants to remand it back. I am only here to assist your lordship that they cannot simply quote the statements.
Yes, Mr. Maharaj, what are the other materials except the oral ocular testimony?
Ocular and there are documentary evidence.
What are the documentary?
Exhibit.
Court, while taking prima facie view on 319,
Yes.
has not taken into consideration any documentary evidence.
No, first, you know, the kind
Come to the impugned order.
Yes.
That's 86.
That is
It only deals with the statements of the witnesses,
that is what I
and
am holding.
319 is quoted, and he has not taken into consideration any document as well.
Your lordship,
Yes.
100 now cognizance have been taken against these accused persons 120B 302 109 of 34 of IPC. Lordship, got it please. 120B 302 109 and 34 of IPC. Now how this why the cognizance taken on this after adding these accused persons? The learned trial court has taken into consideration the evidence of P3, P4, P6, P7,
In all the witnesses,
12 and P14.
no, all the witnesses preceding the crime, meeting of mind, allegations are not there. 120B.
Now they have stated
Where, which
in the evidence.
evidence? Where is that?
Evidence, all have stated.
That's prior to the incident. They
Yes,
were
yes,
During
conspired.
investigation,
Prior to the
page 99,
99.
page 99,
Yes, come.
relevant is para 4.
Hmm.
During investigation, police examined me. I had stated about the cause of incident in detail to the police. I had stated before the police that the deceased Abhimanyu Panda was the previous trust board member of Jagannath Temple, Baliguda. Samsundar is the previous secretary of Jagannath Temple Committee, Baliguda.
Where is the name of these people?
Yes, I'm going to that. They said Shamsundar Patra and the accused Biswa Ajit Patra were using the buildings of Jagannath Temple, so and so, so and so. Shamsundar Patra is running a medshop, namely Ambika Medicine Store at Baliguda in the name of his brother Gopal Krishna Patra. Deceased Abhimanyu Panda, being a RTI activist, had asked the detailed papers of Ambika Medicine Store from the drugs inspector about his running, for which Shamsundar Patra and his brothers, namely Gopal Krishna Patra, being associated with accused Biswajit Patra, were given threat to Abhimanyu Panda. Biswajit given shot, a gunshot. But this amounts to, my lord, 120B, 109. So it's not a case of only 302. So that is why this evidence, and exactly on the evidence of P6, 7, 12, also the same things. So that is why this new evidence come out. So that is why the learned trial court has added the accused persons. There is no wrong in it.
111 also, your lordship may kindly see 111 page, paragraph 4.
111, huh?
Yes, 111, paragraph 4.
Yes.
The fact that due to the issue regarding eviction of landlord Jagannath Baliguda and the issue relating to the property of the Lord Jagannath, there was enmity of accused so and so, so and so. Since 2016,
That has been
prior to the 2016, the above named persons were enjoying the property of Lord Jagannath without any lawful authority, for which so many cases have been instituted against them for their eviction. On 29/37/16, in the interference of the endowment commissioner, a trust board was consisted with the managing trustee and 7 numbers of trust members, in which I am the managing trustee, whereas Abhimanyu Panda and 6 others were the trust board members of the temple of Lord Jagannath, to which K. Biswajit Patra, Ramchandra Patra, Shamsundar Patra, Rinku Panda, Anand Prasad Acharya, and Padmacharana Panigrahi have been agitated again and again. They have also approached the courts against the notice issued to them to which rent on the land which they have purchased unauthorizedly, but they have not owned the case. Abhimanyu Panda and myself have actively participated and tried to get back the land of Lord Jagannath under the purview of endowment rules. Abhimanyu Panda has collected information through RTI and we found that most of the people are involved in the irregularity in acquiring the land and alienation of land of Lord Jagannath.
112, you please come and
Yes.
stop. This is the main issue for which K. Biswajit Patra and his associates
Committed
are very often assembled at the Patak so Bazaar.
Patakhanda.
So also on a rented shop in order to make a planning for commission of the murder of so. That is then 120B is there. Why should I get it?
My lord, if your lordship sees the
No,
charge
I
sheet-
can't further. This 120B. I can protect you for some time because see the fact that there is a enmity between the two groups is there, and the fact that there is a murder, and the fact that the enmity is either this side or that side.
I completely got it.
So therefore, you have to face things.
No, my lord, my point
What
is,
protection? I can't
Yes.
further waste it. I have given half an hour.
No, my lord, my
In 319, if I lead.
no, my lord, I'm not, I don't want to
At this
waste it.
rate, I would have completed 2 appeal.
No, my lord, I'm not on that. My lord, I don't want to waste your lordship's time, my lord. My only
That
thing is,
reference appeal also I could have.
no, my lord, is there a new ground if there is coming for the first time? It's not come for the first
The
time. my lord.
evidences, he says
No, my
that
lord.
it precedes the crime.
My lord.
There is a meeting of mind. This is the statement which is coming by one of the witnesses.
My lord, the same witness,
No,
which has been stated.
Whatever.
My lord, all of this. Now, my lord,
Want me to dissect all the.
no, my lord, I'm not saying that. My lord, I have got a judgment which says, my lord, if I can quote, I'll just read it out, my lord. My lord, it says when we translate the
Judgments
aforesaid.
are on the basis of facts.
I completely bow down, my lord. I completely bow down. Now, in this facts, my lord, I am only.
What is the test for 390? I have to see whether prima facie case.
No, my lord, that's my humble submission.
I'm not recording a conviction or not recording. You have to go. The only thing is you have to get the bail. For that, I'll give you little protection and go and face and because of the fact that there are 2 family groups. So therefore, you are entitled for protection.
No, my lord, if lordship, my only
So
thing
I
is,
will
my lord,
give
the
protection. How
lower
much time
court,
you need to surrender and
whatever, my lord, my entire submission
1
was
month?
lower court.
1 month. No
It cannot
court
just be prima facie. Is my only submission, my lord.
1 month, no court date.
As your lordship, please.
Okay. The petitioner has challenged the order dated 19/10/2023 issued by the court of so and so in session style number so and so, whereby they have been summoned summoned by the trial court under section 319 CRPC. The trial court has summoned the witnesses primarily on the basis of the analyzing the testimony of PW 3,
Well, just
3,
well,
4,
just
6,
before-
7, 12 and 14.
Well, just a moment. My lord, there was read out. I just wanted to bring because there's patra confusion. That is why even I was confused when I was reading the entire evidence that my learned senior
K.
read.
Biswajit Patra, you are saying is accused. I know that.
Yes, but K. Biswajit Patra is not related to me, and his associate that's not related
You
to
have
me.
been telling me so.
My lord, that's what
I know that.
My lord, I bowed down.
And if you properly investigated, then in a small village, all patros are related to every patro.
My lord, then I can't really say anything, my lord, if that be so, my lord. Then, my lord, every patra, every month, and every da should be put in 319, my lord.
In a village, there would be a Patra family, there would be a Ponda family, maybe related, whatever.
No, that's why we are not against K. Biswajit Patra. We are on the other brothers, man. And K. Biswajit brother has a different shop altogether.
I've heard Ms. Mahanti, Mr. Jana and Mr. Mahan at length. And all of them has taken me to the evidences of all the ocular testimony of all the witnesses, all the witnesses. All the witnesses. Let counsel for the petitioner points out that except the ocular evidence, nothing has come on record, which calls for, arriving at a prima facie satisfaction that there is a case against his clients. He has emphatically argued that the eyewitness in this case, who is PW?
PW 7.
Eyewitness in the case has not taken the name of any of the petitioners, and it is only the other witnesses. They have and they have attempted to implicate the petitioners on the implicate the petitioners. All of them are hearsay witnesses. Hearsay witnesses. Witnesses. Next paragraph. Mr. Jana further points out that an order under 319 being a final order,
Revision.
since appeal is not provided, the revision lies. So therefore, 482 proceeding is not maintainable against such orders. Such orders. Next paragraph. I'm of the considered view that I need not go into minute detail to examine each and every witnesses, those who have spoken, those who have attempted to implicate the petitioners, so as to analyze the legality of the order dated 319. Order dated impugn order. How will suffice is to say that the trial court has concluded that the prima facie case appears to have been made out against the petitioner. The court has exercised section 319 CRPC. Therefore, no interference is called for at this stage. However, taking into consideration the peculiar facts of the case and taking into consideration the fact that this is the crime has a crime alleged to have taken place in a village due to the interstate rivalry between two families regarding the management of a temple. Regarding
families, two different groups.
Two different groups. Two different regarding the management of the village temple. Village temple. I am of the considered view that the petitioner should be protected for how much I will be.
As your lordship, please.
You tell me to protected for
6 weeks, man.
6 weeks. Protected for 6 weeks, so as to enable them to surrender to the jurisdiction of the trial court and seek appropriate remedy available to them under law. Face the trial.
Grateful.
It would be a rather balancing order. You get protected, go and.
Grateful. I'm obliged for patient hearing, madam.
Yes. 18. So he is there, na? Yes, sir. 81. Lama hearing. Yes. Yes, good afternoon. 81. Yes, 81. We can't do it. But we have to see. Yes. 81. Matrimonial.
My lord, not matrimonial, your lordship. FIR under section 493, 294, 506, 34.
Where is Subhasri Vishwas? Subhasri Vishwas.
Subhasri Vishwas कहीं?
Avinash Polda. Do affidavit. Have they filed affidavit? Who is appearing for Subhasri Vishwas? That legala? Huh? What was the dispute? कौन dispute कौन थे आपने? हाँ, sorry.
जहाँ मिसअंडरस्टैंडिंग थिला सॉल्व रिजॉल्व हो गला
कौन misunderstanding थिला?
She can say in the open court.
Hmm?
She can say in the open court. There is physical relationship between the.
Okay, that way. Okay, it's all right. All right. Okay. अभी किसी problem नहीं? पास कर दो? किसी problem नहीं? Okay. At the instance of opposite party number 2, have you implemented here now or not?
Yes, my
Opposite
lord.
party number 2, the FIR number, which we filed?
83
Where is that?
महिला भुवनेश्वर महिला पीएस के
Where is that FIR? Have you filed?
पेज 6
Page 6. FIR number so and so page 6 under section so and so was registered against the petitioner.
corresponding to city case 5399
Corresponding to city case 539, है ना?
SDGM भुवनेश्वर
The parties have now settled the dispute. अच्छा 493. Parties have settled their dispute. Petitioner and opposite party number 2 are appearing in the court in person, and they are also represented by the respective counsel. Both of them are filing other cards and also the petition. The opposite party number 2 has also filed an affidavit dated 8/2/2024 inter alia stating that she had filed she has filed the case against the petitioner due to misunderstanding. Now she has settled the dispute and doesn't want to proceed further. Therefore, he is seeking indulgence of this court to quash the proceedings against the petitioner. Mr. Ragada appears for the state.
But 2 lines may be added, my lord. The charge sheet submitted showing his abscond. Another thing, anticipated file that has been.
493.
इनकम प्रोटेक्शन भी अच्छी है
Mr. Ragada appears for the state and submits that in the present case, the petitioner was shown absconded while filing charge sheet, and he has also unsuccessfully approached this court for grant of bail. However, at the same time, he submits that the coordinate bench of this court had been pleased to grant interim protection in this matter. In the present matter, interim protection in the present matter. Full stop. Mr. Ragada further states that now since the parties have now settled their dispute and filed the affidavit and reiterating their stand by appearing in the court in person. Therefore, there is no impediment in quashing the said FIR. Next, taking into consideration the aforementioned fact and statement made in the bar, the FIR number so and so and consequence of proceeding thereof stands quashed. How much cost, sir?
Senior
Double cost. Because 493, 493 and senior advocate. Both.
Senior. I have been.
His matter taken up on out of list, my lord, and not out of list, my lord. Out of turn, 500 given. But that is another cost.
Three counts.
Well,
3 counts. 2,000.
He is also
2,000.
very happy.
Okay, subject to 2,000. Okay.
2002.
I could also welfare.
High Court only.
I could also.
Not to you. My lord, I have the details are there in paragraph 2 of the affidavit. Code section. नहीं ସେଥିପାଇଁ କୋନି list.
नहीं will take.
38.
Password. 38 start. Okay. Bail jumping matter, you should have reached more. Yes.
Unnecessary one. Have I gone to page 9?
What do you want?
My lord, here in this case, on the first instance, NBW has been issued. My lord, have I gone to the charge sheet?
I will say the NVW go and appear.
Well.
Write down. The petitioner is agreed by the order dated 24/4/2023, passed by so and so, whereby the level court below has issued non-valuable warrant against the petitioner. The petitioner, the counsel for the petitioner on instruction undertakes that his client would appear before the court on or before 29th of February, so and so, and seek remedy available to him under law. Next, on the strength of the on the basis of the aforementioned submission made with the bar and subject to payment of cost of rupees. Cost of rupees 500. The order dated 24/4/2023, passed by the court of so and so is kept in abeyance till 29th of February 20.
One thing I mentioned, my lord. Here, not mentioned, my lord. 4 bail appeals filed by subscriber. And one case, my lord, given.
But he will surrender at least. Things will start moving. If we reject it, then he will abscond. Better at least this order he will go and your trial will start.
Wouldn't it impose 2,000 rupees cost on him earlier? Suppression of fact.
Suppression of fact.
My lord.
Here also he has suppressed.
No, my lord.
Huh?
For that is I am saying.
You have suppressed here also. What is this?
What suppression of fact? Bail appeal filed. What is the time important?
Both
bail appeals.
My lord, I don't know.
Huh?
I don't know, my lord.
For that is.
Show me if that is the case, then why should the leniency? 20,000 rupees cost was imposed on you.
No,
filing suppressing facts and filing case and case. 4 bail applications. A bail application.
These are all bail applications, my lord.
A bail application.
You whatever you have not disclosed anything in this case.
Citracotta Court Supreme Court College.
No. So I know, my lord. My lord, someone nothing.
No, not that.
Chapter
not fair.
Okil change is na. The court case Supreme Court College.
No. 38 na. 38. Right now. The petitioner. No withdraw. And again, you will go to some other court and suppress this fact also, and very fact that you have suppressed the fact that 20,000 rupees cost was imposed. I should impose more than that. I'll record it and dismiss it. So the petitioner is challenging the order dated so whereby earlier the petitioner has approached this court by filing as many as 1, 2, 3, 4, 5 petitions. 5 petitions, and the last petition filed by the petitioner, that is the ABL number 14684 ABLAPL number 14674 of 2019 was rejected by this the coordinate bench of this court and imposed a cost of 20,000 rupees for having suppressed that he had earlier approached this court. Next one. Surprisingly, he has filed the present petition, and in this petition as well, the petitioner has suppressed the fact that he has approached this court on earlier occasion. This is the 1, 2, 3, 4, 5. This is the 6th attempt made by the petitioner. 6th attempt made by the petitioner by filing the present for seeking relief of similar nature. Therefore, the petition is liable to be dismissed with a cost of 5,000 to be deposited to 5,000. 20 first you give 5,000, and I'm not blaming you. No. Your client might not have taken. You must tell. Yes.
39.
May I please, your lordship?
Yes.
My lord, here petition is challenging the order of rejection passed on 18/7/2023 for rejecting the my lord, petition filed under section 311 CRPC for recalling the witness PW 6 and 7. Here PW 6 and 7 are the by the vital witness who is the complainant and PW 7 is the my lord, file. So it is a case that while the informant was going to the home, a two-person came and
I am not on that. What is it? PW, you
Speak,
have.
I want to
You have
cross-check.
moved an application under 311
Huh.
seeking recall of PW 6 and 7.
Oh, I want the third cross-examination.
And
That's my only plan.
where is that order?
That is
You
my
got sufficient opportunity or not? Where is
no,
that?
that is PW 6 I have given. That was declined, my lord. Only my lord, he has filed a petition that day due to some personal difficulty. He was unable to cross-examine. So, in the, your lordship kindly see page 22 and 24. 22 to 24 are the deposition of PW 6 and PW 7.
22?
22. Running page.
Yes.
That is PW 6. Cross-examination declined, my lord, because the council was due to some.
22, huh? This
Yes,
is page PW?
PW 6.
6. What about PW 7?
PW 7, page 24. Page
Decline. Why have you declined?
He has filed a petition for 317 and due to some personal difficulty, he was unable to, my lord, appear before the
Yes,
court.
Mr. Raghuda,
Only chance.
one opportunity.
Yes.
One opportunity. Please,
Yes.
let the council, the petitioner has challenged the order dated 18/7/2022 passed by the Court of so rejecting his application under 311
Yes.
CRPC, seeking recalling the witnesses, namely PW 6 and 7. The petitioner has pointed out that while the examination in chief of both the witnesses were taken place on
my lord,
on
17 May 2022.
17
Both.
May 2022, the petitioner was not afforded an opportunity to cross-examine. Rather, on that day, the petitioner had moved an application at 317 CRPC, which was CRPC. Therefore, he is braced for a singular opportunity to re-examine these two witnesses. To
Cross-examine these two.
To cross-examine these two witnesses. Mr. Raghuda fairly submits that since no opportunity is afforded to the petitioner for cross-examining these witnesses, one opportunity may be granted to him. Accordingly, the order dated so and so is set aside, and the petitioner is directed to cross-examine both PW 6 and 7 on the next date of hearing. Next date of hearing to be fixed by the trial court. To be fixed by the trial court. The copy of this.
2 weeks, my lord, 2 weeks time. 2 weeks.
My lord, the at this stage, my lord, he filed petition, my lord, for recall of it. In the meantime, my lord, what happened if the trial
2 weeks time.
313 will be repeated once again or kya? Insofar as these witnesses are concerned, no? That they will do. Accordingly, direction is directed to proceed both PW 6 and 7 of the next date of hearing. Accordingly, the trial court may fix a date. For the purpose of cross-examining the same two witnesses. Yes. Hello.
Was proceeding, my lord, on the ground matter. No previous case against the president. The initially case was registered, my lord, under section 363, my lord.
What is the stage of the investigation?
No, investigation already completed, my lord. Now charge sheet filed, my lord, 2% against my younger
brother. Where is the charge sheet?
Yes, I have file already filed.
It's not.
Are date.
Where is the charge sheet?
Scanning. You'll see.
Charge sheet is filed. Flag B. Okay.
There are two accused in this case, my lord. I am and my brother is accused in this case, my lord. Against allegation against my brother, that is Pintu alias Sibo Prasad Biswal, my lord. He loved with the victim girl and they fell away from the house, man, and they recovered at
Purnachandra Biswal.
Purnachandra Biswal.
You are the elder brother.
Elder brother of Sibo Prasad Biswal.
Yes, Mr. Maharaj, my lord. Elder brother. What are the allegations?
Allegation of there are charge sheet 363, 366, 354, 342, 354A.
Any evidence has come against this man?
That has been charge sheet submitted.
They were in relationship.
Yes, yes.
They married also.
No merit. ସେ ପଳେଇ ଆସିଲେ ବା ଝିଅ ତାକୁ ନେଇ ଆସିଲେ ଏବେ ଅଲଗା ଅଲଗା ଅଛନ୍ତି
What role you have played?
ମୋ ପାଖରେ ଭାଇ ଏଗେନଷ୍ଟ ହେଲା ଭାଇ ସହିତ ସେ ପଳେଇଥିଲା ବୋଲି ଆଲିଗେସନ ଭାଇ ଏବେ ଅଲଗା ଅଲଗା ତାଙ୍କ ଘର ଝିଅ ନେଇଗଲେ ତାକୁ ଏବେ ଅଲଗା ଅଲଗା ଅଛନ୍ତି ତାଙ୍କ
କ୍ଲାଏଣ୍ଟ କଣ କଲା? ହେଲ୍ପ କରିଥିବ ଭାଇକୁ?
ଷ୍ଟେଟମେଣ୍ଟ ଅଛି କି ତା ଦେହରେ?
ଷ୍ଟେଟମେଣ୍ଟ ନାହିଁ କିନ୍ତୁ ସେଠି ଲେଖା ହେଉଛି ଆଇ ଏମ୍ ପ୍ଲେସିଂ ମାଇ ଲାଇଫ middle of the charge sheet. At the time she received a phone call number, that person told her now where you are, but the victim told him.
Where is this opposite party number 2? You have not.
You also may issue notice so that I will get the
issue notice and we will stay the further.
Yes.
Issue.
Stay the all.
Why are you not impleading?
काहे को इम्प्लीड करना
करिया stay the we are करना
opposite party number 2, you have to implead the informant. Okay, you implead the
implead.
Mr. Patil seeks time to implead the informant as opposite party number.
Bas.
Issue notice to
OP number 2.
OP number newly added OP number 2.
Bas.
Returnable within 2 weeks. For
further proceeding.
Mr. Maharaj.
Yes.
Further proceeding is it?
Further proceeding is stayed. I will get the receipt.
Okay. Mr. Patil submits that the petitioner is the elder brother of the main accused. What is his name?
Sibo Biswal.
Sibo Prasad Biswal.
Sibo Prasad Biswal.
The entire allegation against allegation in the FIR is regarding the elopement. What is the allegation?
Sibo alias Pintu Biswal.
Sibo alias
Pintu Biswal. Pintu name in the
what is the allegation?
He allegation that in the affair matter I am placing matter. ସନ୍ଧ୍ୟା 2 ଘଣ୍ଟା ପରେ ମୋର ଝିଅ ରୂପା ବିଶ୍ୱାଳ ଘରୁ କୁଆଡେ ଚାଲି ଯାଇଛି ତାର ରଙ୍ଗ ଗୋରା ସେ ଗଲା ବେଳେ ନାଲି ରଙ୍ଗର ସଂସ ଆମ ଗାଁର ପିଣ୍ଟୁ ବିଶ୍ୱାଳ ଝିଅକୁ ଫୁସଲେଇ କୁଆଡେ ନେଇ ପଳେଇଛି
Pintu Biswal has eloped the victim girl on the pretext of getting married. Is also submitted that the brother of the accused, Pintu Biswal, was in relationship with the victim girl. There is no allegation made against the petitioner. Therefore, he seeks indulgence of this court for quashing up the entire proceeding against him. That issue notice to make Patel seeks time to implead the informant in the present case of the opposite party number 2. Issue notice to the impleaded opposite party number 2. In the meantime, the proceeding in court. Proceeding court देखना नहीं.
Yes.
Court. किसी नहीं.
वो देखना.
अब petitioner लिखी हुई है ना कहाँ लिखी हुई है तुम?
क्या है? SDM.
JMFC
खोटा. JMFC खोटा.
Cognizance नहीं लेनी. Cognizance नहीं आई थी.
Cognizance नहीं चुनना.
Court रची pending nobody knows.
Yeah, JMFC खोटा मिला. I have to mention.
Full division पे.
Where have you written?
JMFC खोटा. My state petition.
Cognizance court that.
Full division.
नहीं सेटा कॉग तो ये कहूँ JMFC कॉग कहूँ चंदी सेटा को. अबे cognizance JMFC कॉग लिखा हुआ जी. सेटा अबे तंको आगो SDCM JMFC कॉग 1 2 3 एमती रहू छी.
You face the consequence. What to do?
JMFC
yes, sir. JMFC cost. I election से लिख दियो.
Yes, sir.
Proceeding further proceeding.
अब लेंगे.
You will not implead the main respondent. You will not write the court. You will not file the proper document. And you want everything.
से कॉस्ट जोटा हेतला प्रीवियस केस रे से जो गुडा सब कॉस्ट है सेटा सब डिटेल्स लिखि दे दे जोटा स्लिप है
ହଁ ସେ ମେଟ୍ରୋ ଗୁଡାକ ଦେଖିଦେଇଛି।
ହଁ, ମୁଁ slip ଟା ଦେଇଛି।
ପାଞ୍ଚଟା କେସ୍ ଖାଲି ନା ସବୁ ଗୁଡାକ ନମ୍ବର
ମୁଁ ଦେଇଦଉଛି ପ୍ରିଭିୟସ୍ କେସ୍
ଯୋଉଠି 5,000 କୋର୍ସ ପଡିଲା। Forget 5,000. Who has written? Don't know. You take the numbers. Yes.
41.
May I please, item 41, I am for the informant matter. Petitioner and advocate not there, I suppose.
Adjourned. Yes.
42.
A copy of the brief maybe. Right.
The person who is supposed to give the copy is not there. Where from I?
My lord, I know, my lord. I know.
Yes.
42.
42.
42. Picture of mentioned awaiting tracking report.
Awaiting tracking report agent. The is directed to get the tracking report and place it to report. Yes.
43.
Yes.
May I please, your lordship?
Yes.
My lord, the fact of the case is like this. The lordship may kindly see page 16, annexure 3.
Yes.
The petitioner filed a complaint alleging commission of offence under Rule 21 of the Orissa Timber and Other Forest Produce Transit Rule 1980.
Okay.
Page 18, your lordship may kindly see the offence.
Yes.
Then on this, the Grand Magistrate passed order by annexure 4, page 25. That complaint is filed alleging under Rule 21 of Orissa Timber and Other Forest Produce Transit Rules 1980. 21. I will take your lordship to that provision. But
no. What happened? The complaint was filed.
And magistrate sent it under 156(3) to register a case and start investigation.
Where is that complaint copy?
My lord, complaint petition is annexure 3 and the FIR or
1 minute. Annexure 3. 1 minute. Annexure 3.
Complaint annexure 3.
Yes, Mr. Just see page 24.
Already, the instruction I received, my lord.
No, page 24. You tell me. Where is the supporting affidavit?
Not challenging that, my lord.
But he may not challenge the irregularity act. The court can find out. Then the entire thing we see it. According to those judgments.
And my case commission is.
I am on something.
No, my lord, I am not there on that. My only grievance is court send it to register case under Rule 21. But the police registered it under Section 447 IPC. That is my grievance. The lordship may kindly see the FIR. Page 26. Top my
Where is 156(3) order?
My lord, 156(3) order. Page 25. 25 is the order.
Where does it say?
My lord, a complaint petition under order Rule 21 of the Orissa Timber and Other Forest Produce Transit Rules 1980 has been filed by the complainant named above. The Land Council, Sri Harapriya Sahu, has filed Bhakalatram and other things are there.
Yes. Where is the order? Real order.
This is the order, my lord.
Where does it say that 21 you have to?
My lord, complaint is under 21. So when it is sent to the police, my lord, case is to be registered under that section on charge sheet or after investigation, he may not. But my submission is regarding, I have also stated in my complaint petition.
The petitioner is, in this petition, the petitioner is.
Already, my lord, 21
challenge
added, my lord.
No.
Already added. I have
Okay, but the other point is also there. Challenge the order dated. Which is the order you are challenging?
I am challenging the registration in FIR.
The petitioner in this petitioner is challenging the criminal prosecution launched against his launched against him.
No. I am the informant. I am the informant.
He is coming here, not adding one section 21, my lord, forest act.
Rule 21.
That has already added, my lord.
That I have no information.
I have to search for information.
But this matter, if the accused will come, I will stay.
But my grievance is.
I thought you are accused. I was about to say.
I am the complainant.
That case already added, my lord.
The only grievance, the Mr. Bhag, counsel for the petitioner, that the only grievance the petitioner had is that though the initial complaint was under section 21,
Rule 21
Rule 21, page 18.
of the Orissa for Orissa timber and other forest produce transit rule 1980.
1980. However, after the code below, invoking section 156(3) CRPC, directing to register FIR, the police, instead of registering FIR in the appropriate section, as alleged, registered a case under section
447 IPC.
447 IPC. Full stop. IPC. Next one. Mr. Ragara appears for the states and submits that in the FIR, the right provision has now been invoked.
Letter on it is not in the affair.
Charge sheet raise.
No, my lord. Subsequently added.
Subsequently added.
That's right.
Yes.
There, my lord.
Mr. Ragada, appearing for the state on instruction, submits that subsequently the section 21, the offense under section 20,
Rule 21.
Rule 22,
21.
So has been added. So therefore, added. Therefore, the grievance raised by Mr. Wagh in the present petition is adequately addressed.
Yes.
Hence, the petition is disposed of. Taken up. Yes.
44. Please, your lordship, appearing for virtual.
Yes.
Your lordship, the present case, the
My lord, item 44, am I appearing for the informant?
Yes, who is for petitioner?
your lordship,
Adjourned.
appearing for your lordship. In the present case, your lordship, the petitioner challenges the order dated 29/3/2018, passed by
44. 44.
Yes, your lordship, for item 44.
You have written 37.
By mistake, your lordship. I beg.
Yes. Yes.
I am appearing for the petitioner, your lordship. The petitioner challenges the order dated 29/3/2018, passed by learned SDGM Cuttack, thereby taking cognizance under section 342, 294, 436, 307.
Okay, what is your case? You don't read.
Compromise matter by both parties.
You have settled the dispute, na?
Yes, your lordship. We have also.
Have you settled the dispute or not?
Yes, your lordship. We have
Parties
also.
are there. Who are the parties? Who is Buddheshwar Das?
Present informant is presented.
Informant maybe. Where is where are the accused?
We have filed the affidavit, your lordship, on behalf of the
That's
accused.
right, but accused has to be there. They can't have the luxury of not coming to the court and asking for quashing. Ratiranjan Tripathi, where are they? They haven't come.
No, your lordship, they are in the court premises.
They are there? Ratiranjan Tripathi ki. And ye Buddheshwar Das, you are there. Your clients are there, you don't know. Because you are not in the court.
Absolutely.
I'm Hon'Ble, your lordship.
Who will cause it?
436, 437.
Okay. Same of the petitioner in this petition is seeking quashing of FIR number 22. The parties have it is stated that the parties have settled their dispute. They have filed a joint affidavit before this court. Joint affidavit dated 1/2/2024 before this court, which is taken on record. The parties are present in the court. They are represented by the respective counsel. They are being identified with them. They have also filed the self-attested copy of the Aadhaar card. In the joint affidavit, both the parties have stated that they have settled the dispute out of the court on the intervention of well-wishers. Mr. Moragada appears for the state and submits that in view of the fact that the parties have now settled the dispute and filed a joint affidavit, there is no legal impediment in quashing the FIR. Accordingly, the Cost.
Cost is that. Cost.
How much?
How
many?
Percent 2% are there.
2%, 1,000 each.
500 each, your lordship.
Why? I can see them. They're well up. They can pay.
Your lordship.
You pay. Enrich your bar little bit.
As a
And I can't reduce the cost for one more reason that you being a young lawyer, you are not coming to the court.
I have seasonal flu, your lordship. I'm
So
unwell.
therefore, let it be 1,000 each. Okay. Yes.
45.
45. Your lordship may kindly see the last order. My learned friend was asked to take instruction from the police, because your lordship may recollect, here one complaint case was filed and a civil suit was filed, wherein the party is compromised and the plaintiff has got the relief. The same plaintiff was the complainant. Your lordship directed notice she did not receive. Police was directed to search her and hand over the notice. Police also could not find her. Now it is in the investigation state whether the
Yes. 3 persons served 41 notice, my lord. They complied. The other accused persons, my lord, Abhinav Mukherjee and Raicharan Pradhan, they are not available. And other accused persons also, my lord, the absconding, for that 160 notice, sheriff's notice issued.
Hemant Kumar Sahu and Prakash Chandra Jena is absconding.
My lord.
Huh?
My lord.
Hemant Jena Prakash?
No,
they are not absconding.
41 detailed address.
My lord, may kindly.
You have written here.
My lord.
See,
the detailed address of
rest of the accused, namely Hemant Kumar Sahu, Prakash Chandra Jena,
my lord,
remaining abscond till date.
My lord.
Since step have been taken towards the
My lord,
arrest of absconding accused person.
And 160 notice also, sir.
What are the offences? Why are you absconding?
Yes, your lordship may kindly see the civil suit, page 30.
No, that's right, but why are you not?
My lord, offence, your lordship may kindly see it's a FIR offence. Complaint case was filed 419, 420, 120B, 467, 40,
But the investigation is on.
Yes, my lord, and the parties have already settled the
You have
dispute.
applied for bail.
No, I have not applied for. I have not. No, my lord. Your lordship may check up. I have not applied for bail. My bail has not been rejected. The gist of the
if they other so far other accused persons 41 complied, my lord. So far
my lord, here what has
persons are absconded for
no, here what has happened. My lord, even 41 may not be required, because your lordship may kindly turn to
There are
page
many other accused. Now you are filing only for 2.
Yes, because my lord, the parties have settled the dispute in a competent civil court.
Wherever so of the
Complainant is not available.
Your notice issued to the opposite 2, my lord. Notice could not be served and returned back. Thereafter, you also directed me to serve notice through the IO. IO went there and the in front of the
what is the solution now?
And if they will appear, my lord, her evidence has already been recorded.
What I can, in view of the fact that they have settled their dispute according to them, settled the dispute.
Yes, I have produced that documents. Your lordship
and 41 notice you have given to all other accused persons. What I'll do is I'll pass a no courtship order. Let him go and
appear
with the police, and if you have settled, he'll file a closure report. What is the big deal? 41 notice, on instruction. Sorry, on although the opposite party number 2 was issued notice, she had choose not to appear.
May I once want?
Therefore, yes.
Your lordship may say no coercive action in this interim order. My lord, I'll appear before the police.
I'll record it and go and tell the police.
No, I'll appear before the police. Your lordship may keep it a month after. In the meantime, after 41 is served to me and the complaint is not come.
Wait.
Yes.
Try to help the High Court to reduce the burden.
My lord, I have to come again for questioning. I have to come again. Because
not to appear.
No, not served. Not served.
Not to appear, as he could not be served. Right? Not to appear. Mr. Ragada submits an instruction that repeated attempt by the police to serve has yielded no result. Why I yielded no result? Mr. Ragada has placed on record the written instruction and submits that there are age variance. How many accused? 7 accused.
Seven accused. There are, yes.
7 accused.
7 accused.
In this case, including the two petitioners herein, being accused number 6 and 7. 7. Insofar as the other accused persons are concerned, in so far as
1, 2, 3.
accused number 1, 2, and 3 are concerned.
Madam, I am 5 and 6. Accused number 5 and 6.
Accord service notice. 1, 2, 3, 41 notice.
That's what I'm saying. In so far as the accused number 1, 2, and 3 are concerned, notice under section 41C was served to them. But similar notice could not be issued to the other accused persons as they have been absconding. Absconding. उसके बाद मिस्टर बोस ये ऑर्डर से ले लेना 11/1/2024. Mr. Bose, land counsel for the petitioner, submits that there was a suit filed interest between party and all. ठीक है ये ले लेना. उसके बाद in view of the fact that the parties there is in fact no lease survives. No lease survives as the opposite party has already satisfied on her claims. That perhaps the reason she is not appearing in the court or not cooperating with the investigation. Next, having said that, since the present case is at the investigating stage and the petitioners have not yet participated in the investigation, it would be appropriate if the factum of settlements or the factum of the fact that the complainant has already been satisfied in her claim vis-a-vis the suit filed by vis-a-vis the suit proceedings should be apprised to the investigating agency. Mr. Bose submit that he would be appearing before the here on instruction. Submit that his client should be appearing before the investigation agency
and cooperate with
investigation. In view of the particular facts of the present case, the petitioners are directed to appear before the investigating agency and apprise the aforementioned fact.
Date may be
aforementioned fact.
Date may be on that day.
Date
My lord, 15 to 20 days after, so that I will inform them.
On or before 29th February. And in the meantime, no coercive actions have to be taken against the petitioners. You go and appear and tell all these things. He will file charge. He has to file the closure report because the complainant is not to be seen. Her claims are addressed in the suit.
But in fact, one sister statement already recorded.
Still, there is nothing survived.
My lord. Because now the parties have settled the dispute and there is a compromise.
If there would have been only 2 accused persons, I would have quashed. There are 7.
Yes. Yes.
What happened to the other, we don't know. Go and tell all these things to police. They'll close it.
Let's dispose.
Disposed. Yes.
46.
But it will, again, I have to approach your lordship.
That's good for you.
No, sorry, police wala kon sari. Apan ko department te.
Next. 46 idea.
47.
47, my lord, say pray for an adjournment.
Yes.
48.
Permitted to move this application by your lordship may ignore the defect 14B. Some signature probably not there in the petition.
Okay. What is the case?
Case, my lord, the order of cognizance under challenge, my lord. Let the FIR lodged against the petition.
Where is the charge sheet?
My lord, charge sheet is not with me, my lord, but cognizance taken, my lord. Charge sheet.
How can I see whether cognizance order is correct or not without charge sheet? File the charge sheet. Land counsel what the petitioner undertakes to file the charge sheet.
The cognizance order, certified copy of the cognizance order is there.
Okay. Huh?
Certified copy of the cognizance order.
What will I do cognizance order unless I see what are the allegations, what are the evidence and all? Without charge sheet, how can I pass the cognizance order? That is the basis of the cognizance.
I have employed the informant opposite party number 2.
You don't
That's it.
understand what
By that time.
File, don't waste it.
Yes, my lord. Let it be next week. I will submit the charge sheet and the defect will be removed by that time.
Yes. Cure the defect, file the charge sheet. Okay, next.
49.
Yes.
When appearing from Mr. P.K. Mishra, he is an on record passover request.
Sorry.
What password? Urgent. Next. Next. 50.
50.
Here, my lord, the petitioners are the in-law family members. Petition number 1 and 2 are married sisters-in-law, and the petition number 3 is the mother-in-law.
What do you want?
FIR was registered under section 498A34 IPC and 4 DP Act. Now, they have already been released on bail by this honorable, anticipated bail by this honorable court during the year 2019. Now, the charge sheet has been filed with higher offences under section 498A, 304B, 406, 306 IPC and 4 DP Act. So, on the higher offences, they have been charge sheeted. And cognizance has already been taken against them. Now they apprehend that if they will surrender, they will be arrested. So I pray that they will surrender and.
Susila Agrawal,
and you have to surrender and on the basis of Susila Agrawal, appropriate.
Your Lordship may die.
Petitioner submits that in this petition, petitioner has challenged the order dated 15/9/2020, whereby cognizance of offense under section so page 27 taken. He submits that initially at the stage of investigation, his clients were on bail. However, the charge sheet has been filed including graver and higher offences. Therefore, he apprehends that once he surrenders, he may be taken into custody. These considerations are irrelevant for the purpose of the present petition. However, suffice it to say that the petitioner can seek his remedy before the court below by moving appropriate application under the aid of the judgment of Susila Devi cited.
Madam.
Under the aid of
125 SEC.
Page 1.
Page 1.
Page 1.
Page 1.
Page 1. Okay. Therefore, the present petition is disposed of with a direction to the petitioner to appear before the court below as court below on or before 29th February so and seek the appropriate remedy available to him under law disposed of. I have written Susila Devi.
Obliged.
Yes.
51.
Yes. Urgent.
52.
My lord, kindly adjourn this matter.
Urgent.
53.
My lord, proper one capture for removal defect.
54.
My lord, 54 and 55 are adjourn this matter. Item 50.
For how many people you are appearing? Adjournment counsel. Do you know what is this case is about?
No.
If somebody requests, why should you say that I'll take it? How do you know that I'll adjourn it? Where is your file? You have this file, case file. That also you don't have. Very nice. 54, 55.
57.
Please, Your Lordship. 57. Your Lordship, the NBW order, my lord, is the 1st May 2023.
When you got the bail?
I got the bail from the learned court below, my lord. That is at page number
Date takali port.
Date koi
25 January 2021.
How much will you pay?
My lord, 3 jana achandi, bappa ma puo.
So then give 500 each.
1,000 rupees.
1,000.
All.
All up.
Okay, 1,000.
Great. My lord, another 2 matters is there, my lord.
Same.
No, not same.
Which one? Item?
58 and 59, my lord.
58. Wow. What is this 58?
In this case, Your Lordship may kindly peruse item number 59.
59. Connected matters.
Not connected, Your Lordship. That is mentioned yesterday.
59.
58 and 59 is arising out of same PS case.
Connected matters. Okay.
Yes, Lordship. 59 is of document annex. Initially, Your Lordship, FIR registered. My lord?
Passing up NBW.
NBW and proceeding, because my lord, I am the second row accused, not apprehended. Police filed charge sheet showing absconder.
You be happy with the cancellation of NBW, go and pay.
Your Lordship, I have
Composite prayer, you have 50% allowed, 50% rejected.
I
will not say anything, only NBW will go.
Your Lordship, kindly observe that page number, my lord.
2 anticipated bill, 1 482 already disposed.
Right.
One 482 disposed for non-prosecution.
Whatever, you revive that. That's much more dangerous. Why have you not revived that?
I am not the counselor.
Then the law will change because the lawyer has changed.
No, my lord.
See, this is the what you call forum shopping. You file 482 for quashing, that is dismissed in default, non-prosecution. You don't revive that by moving application. You file a fresh one.
Because
if you revive it, it will go to some other court.
And
so file a fresh one. So this is not a forum shopping. This is forum shopping. So be happy with the cancellation of NBW. Okay.
And your lordship may kindly observe the page number 78 may kindly.
What is that? 78.
At the time of surrender, the learned court below will consider Tufan Singh, NCB Bangalore.
There already. Why should I say?
But my lord, without observation, they will not consider.
No, you are asking for what? This is, you have moved application for
59. The prayer is at page number 9, your lordship.
Hey, you are, what is this? What you have moved NBW, cancellation of a criminal prosecution. Who are you?
Both are two brothers, my lord. Amarjit and Samarjit.
Amarjit. The 78 is something else.
No.
Gupteswara.
No, 78 name, my lord.
No, it is
58 and 59.
Page 58.
No. Item number 58 and 59 arising out of same FIR.
No, I am talking about 78 page.
Yes.
The observation which has been made in some other case.
Some other case.
So then why should you say that?
My lord, at that case, my lord, because of this observation, the petitioner enlarged on bail.
What is this case and what is that case? I don't know. What is the offense in this case?
Same type case, my lord.
Second. You don't understand. Tufan Singh is always there with you.
My lord. So for the Sanjeev Chandra is concerned, my lord, this is a new order.
If you want to cite some judgment, you cite. Who stops you citing judgment in the bail case? What kind of observations? Right now. This is 59, huh?
58 and 59 common order.
Common order. Because there are two axes, huh? Okay. Common order. Look. The petitioner, petition, but order same. Name would have, number would have changed. Name would have changed. Look, petitioner has, by way of this petition is challenging the order dated 7/4/2021, passed by the court below, issuing NBW against his client. NBW, the not claim, NBW against him. Apart from that, petitioner has made a co-prayer, inter alia, seeking passing of the entire criminal prosecution. Entire criminal prosecution against you have been absconding.
My lord, the police cited.
The Mr. Maharaj appears for the state and submits that the petitioners have been absconding in this case, and their attempt to get bail from the court from the court
Yes.
has held no reason.
Yes.
No
Rejected.
Has held no reason. No reason. Taking into consideration the facts of the present case, the order dated 7/4/2021, which page?
Page number, my lord, 73.
Page 73, 7/4/21, passed by so and so, is passed by so is kept in abeyance till 29th of February, so and so. On instruction, Mr. Sahu submits that by that date, the petitioner would appear before the court and seek appropriate remedy under law. Mr. Sahu further submits that he would be relying upon judgments. Page 78 judgment like page 78 to press his relief. To press his case before the court below. Needless to say that the petitioner has all liberty to rely upon any judgment he wished to rely, apart from the judgment taken note of by the coordinate bench in the while disposing of the bail application in ABAP number 11571 of 2020. This order is subject to the petitioner paying cost of rupees 1,000. 500 each.
Grateful.
Item 60.
Yes.
I may be permitted to withdraw. Your lordship
Very good.
recollects that matter, that civil litigation given a color of criminal case, and your lordship wanted it should be sorted out. But many pleas in defense my client is saying, so I am withdrawing.
61.
Next week, next week, along with the CLMC, purchase is order set.
Yes. 62.
The annexure 3, page 20, the order of cognizance is under challenge your lordship on the ground that the offense is
order, challenging a cognizance order today you have listed 91 matter. You have to see everybody is arguing small matter or 91 matter we can do it. 4 o'clock cognizance also. Everybody is arguing.
Fresh matter.
Okay. Fresh matter means where there is the likelihood of hearing. It takes time. We have to give adequate hearing at least. Yes.
My lord.
If the orders matter will be taken up first, my lord. Serial 1 to then fresh addition, then addition matter, my lord. Better.
Like what happens is yesterday there are 60 matters.
Today.
But before lunch is over. Today I say that to put more matters.
Belgium ta adhika asile sori
All
jauchi
the
shigra.
matters are now being heard. That's the problem.
Belgium matter asile sori jauchi shigra. Eta hearing hochi.
So they have also their own problem. At least.
Yes.
Anyway, let us see. We will have an extended hearing today. Little bit. Let us see. Yes.
Annexure 3, page 20, the relevant order is page 21, the order of cognizance under challenge your lordship where the learned magistrate to cognize under section 4 to 10 of IPC your lordship.
Where is the charge sheet?
Normally, it arises out of a complaint case, your lordship. The peculiar case, your lordship, the petitioners before your lordship are the wife and parents of the wife, your lordship. The case, your lordship, the petitioner,
What is the relationship you said?
the present petition number 1 is the wife.
Wife of whom?
Wife of the complainant, Your Lordship.
Opposite party number 2.
Yes, Your Lordship. OP2, the husband lost this complaint
Against the wife and
his relatives. Yes, Your Lordship.
His in-law.
Yes, Your Lordship.
Yes, tell me.
The
What is the
allegations, Your Lordship, they, the OP2 and the petition number 1, they married on 10/12/2012, Your Lordship. And they have been, due to their misunderstanding, whatever may be, they separated since, Your Lordship, 18/7/2014. And in 2019,
legally separated.
no, my lords.
Just separation. Okay.
Yes, Your Lordship. And in 26/8/2019, there is a settlement between the parties for mutual divorce, and they have executed an agreement in respect of their separation, where there is a condition to pay permanent alimony of 6 lakh rupees and to return the dowry articles, but all these things. And basing upon that agreement, Your Lordship, one MAT case was filed before the senior civil judge Bhanjanagar on 29/8/2019, and before filing, paid 3 lakhs, 1 lakhs and 2 lakhs, 2 occasions, 3 lakhs, and thereafter both parties, the allegations of the petitioner, the wife not cooperated with the OP2, for which the mutual divorce application could not be disposed of. And my humble submission, Your Lordship, due to non-cooperation of the husband, the petition is unable to dispose of, and accordingly waiting to the husband, Your Lordship, lastly on 23, Your Lordship,
the husband has filed a case against you under 420 and all.
Yes, Your Lordship.
Because he has paid the
No. When on 8/5/2023, I not pressed the application.
I understand it.
Yes, Your Lordship. The wife not pressed the mutual divorce application.
You have taken the money. Partly.
3 lakhs, yes.
Now you will do it.
Yes, I am ready. But this, how the 420 application is maintainable, Your Lordship, offense?
First, a agreement has been made between the parties. As per the agreement, the amount has been paid to the wife.
But he didn't cooperate.
FR was lost. Against demanded 10 lakhs. Against demanded 10 lakhs. That is the initial statement.
I know.
Yes, that initial statement would have
harassment.
whatever my Lawrence senior submitting, keeping in mind to the
are you stick to the earlier settlement? Will you stick to the earlier settlement? Then I'll enter there.
Agreement means their Lordship.
You have agreed for some certain amount.
Yes, Your Lordship.
Taken that amount.
Yes.
After you are saying give more.
Taken that amount. I have taken 3 lakhs, Your Lordship.
Whatever was the agreement earlier, I will stick to that, then I'll interfere.
Yes, that is the whole thing.
No.
Otherwise, I will not allow you to extract money from your husband like this.
No, Your Lordship kindly
Yes,
have
you tell me.
in the year 2019, Lordship, in the year 2019.
Record your statement and issue notice and stay the proceeding. That you are ready and willing to comply the mutual understanding arrived between you and partly the money you have received.
Yes, Your Lord. Yes.
Okay.
Yes.
Mr. Bharat?
Yes.
But then why? How can you keep on asking your husband like this?
Oh, yes.
The 420, how maintainable, Your Lordship?
That is the way
the law is very clear, Your Lordship.
What was the mutual divorce agreement? First of all, tell me this.
So agreement I have not annexed, but annexer for 13B application I have annexed. Page 22, Your Lordship.
20?
Page 22.
You tell me the date when you arrived in.
That is filed on, Your Lordship.
The
29/8/19.
The petitioner number 1 was married to petitioner number 1 is husband, wife of the opposite party number 2. Petition number 2 and 3 are the in-laws of opposite party number 2. the petitioner was married to the opposite party number 2 on 10 to 12 2012. However, due to the incompatibility issue, they started staying separately. Eventually, both the parties have decided to part away and enter into a settlement. As per the settlement, a mutual divorce application under 13B2 of a Hindu Marriage Act was moved by the petitioner number 1 and opposite party number 2. The opposite party number 2 has partly paid the agreed element. कितना
Tune of rupees 3 lakhs out of 6 lakhs.
Partly paid paid rupees 3 lakhs, partly paid rupees 3 lakhs towards the agreed permanent alimony of 6 lakhs.
এটা রং কি রাইট মু জানি
Whatever it is,
Petitioner
it is
20 লক্ষ লেখা ହେଇଛି কোন সেটা
no, it is written in the body of ye.
Para 7 page 20.
No, not page 24. Written.
Yes.
How? 6 lakhs. However, it is alleged that the petitioner number 1 has begged out from the settlement and started demanding heavy amount for the purpose of extending consent for the second motion mutual divorce. Second motion mutual divorce under section 13B. Therefore, the petitioner, therefore the opposite party number 2 has registered this FIR against the petitioner 1 as well as her in-laws.
Complainers.
In-laws. Okay. Full sir. The learned counsel for the petitioner submits that in no stretch of imagination any offense under section 420 for 506 etc. is made out on the basis of the facts of the case. He further submits that he is always ready and willing to extend the cooperation for the purpose of execution of the terms of settlement. However, it is because of the non-cooperation of the husband, namely the opposite party number 2, the mutual divorce could not be granted. He is the learned counsel for the petitioner on instruction agrees that if the agreed amount of 6 lakh rupees is paid to her, she would give the consent for the purpose of mutual divorce and ready to revive the application MAT case number 32 of 2010 on the basis for the foregoing reasons, considering the aforementioned facts and circumstances and the statement made at the bar, issue notice to the
OP number 2.
OP number 2, written within 2 weeks, and in the internagnum, the proceeding before the court below so and so is taken.
Obliged.
Item number 63, I pray for next week.
Next week do we
64.
64 pay for next week, sir.
Adjourned.
65.
Made with yours. Your lordships, 11 petition has been rejected. 11 petitions. Offense on section 363, 366, 376.
Offense, forget about the offense. Who is the PW1?
PW1, your lordships, victim.
They do waiting 66, 67, 68.
Complete.
Yes. 69. Adjourned.
70.
No, prefer next week, my lord, someone to go in and file.
Urgent.
71. Maybe.
Yes.
Yes, under section 138 NI Act, my lord. Order taking cognizance is under challenge.
Notice was issued.
My lord?
You are
No,
accused.
Your Lordships,
I am
I have appeared so much to Your Lordships. The matter is for trial. In fact, it is stated placed for accused statement. The evidence of the complainant is over, Your Lordships. Copy has not been served also.
You are accused.
I am the accused.
What do you want?
My lord? I will serve copy.
No. What?
The question,
You are asking what?
passing of cognizance
At
is
this
under.
advanced stage of the trial, why should the passing? And what is the check amount?
15 lakhs, Your Lordships.
15 lakhs. A blank check was given. He was the partner. The complainant was the partner.
Now, why don't you pay and finish it up? We will ask her to accept with installment and something. Your partner, you can carry on business in your life. Why unnecessary? Will you pay?
I'll take it.
Send to mediation cell and finish it up.
Yes, madam. I pray I will serve copy on Mr.
And Mr. Naidu will send to the mediation if possible.
If he's, Your Lordship, let him serve a copy. If he's willing, then I don't have a problem. But the fact is wrong.
He is willing. If take the money and finish it up. Let the trial go on. What is the problem?
I don't mind, Your Lordship.
And I pray.
15 lakhs since 2021. So with interest, if he pays, it is okay. 21, 20, 24. It is at the fag end, Your Lordships. If you want
don't be very ambitious. And
Madam,
get a check amount and finish it up.
Madam, I pray one thing, madam. I am serving copy on her. Madam,
sending it to
mediation. Let there be stay for some.
Try.
I shall take
Even
steps.
if interest, if you get some installment time, that's a better idea and finish it up.
Better, and madam, in the meantime,
Petitioner being the accused in a case under 138 NI Act has challenged the entire proceeding pending before the court of SDJM Titlagar. The allegation against the petitioner in 1 CC case number 7 of 2021 is that the check issued by him, a check amounting to rupees
15 lakhs.
15 lakhs issued by him has been dishonored. Therefore, the opposite party is prosecuting him. Mr. Naidu, Ms. Naidu appearing for the opposite party on advance notice. On the query from the court, both the parties have fairly submitted that they can try to mediate try to settle the matter out of court. Therefore, I am of the considered view that the matter should be referred to the mediation cell of mediation cell of Orissa High Court, and the coordinator of the mediation center shall issue notice awaiting the report of mediation and leaves the matter on service.
And I pray in the meantime there shall be stay. So, subject to payment of rupees 2 lakhs, 15 lakhs. Suppose if matter will not be stayed, the case will be over. There will no purpose of mediation.
When the matter is taken up by the trial court, the parties may inform the trial court regarding the pendency of the matter before the mediation cell of the High Court.
And if adjournment will be prayed, that shall be adjourned.
Obviously, all these things, everything I'll write to what?
Your Lordship, he has, and pardon, Lordship, he has taken around 4 adjournments for his defense evidence. The deposition from the side of the complainant is long over since.
Forget about all these things. Will you accept 2 lakh rupees without prejudice? At least something is coming.
3. 15 lakhs, let him pay at least 1/5.
1 minute. If this is the attitude, you can't settle it.
It cannot be settled.
the counsel for the petitioner submits that to demonstrate bona fide of his intention to pay the amount, he would be depositing rupees 2 lakhs to begin with, without prejudice to his right and contention. Let him do so before the mediation cell on the first date of hearing. 2 lakh rupees should take first.
But I may pardon, I pray urgent certificate copy.
Urgent certificate copy.
In course of the day, if possible.
His jury is taking time.
Yes,
Your
case
Lordship,
is
so
posted
time
to tomorrow,
to-
that's why. Case is posted
Nothing will
to.
happen. Yes. No, awaiting report.
I have the report from the mediation, the case will remain
Waiting.
pending.
March.
I may pardon, since I will serve copy on Mrs. Naidu, no notice should serve.
It's all right. You are in any case you are going to mediation. What? Yes.
Your Lordship, just one last query. This 2 lakhs, Your Lordship is fixing a time frame for him to pay? Because
First
then it will
day,
again.
first day in the mediation cell.
Lordships.
He will come with 2 lakh rupees, pay you, show his bona fide, then you proceed.
Lordships.
Yes. Yes.
Obliged.
74.
Huh? 74.
74.
Yes.
In this case, my lord, I am praying for quashing of the criminal proceeding.
74 I have just now received the copy. I don't know. This is a big bunch.
Tomorrow can I? Because
Give a date.
21st.
Before that, not possible. Yes.
75.
May I please, Your Lordship? Madam, I am challenging the order dated 3/3/2023, which has been passed for framing of charge.
It is 75.
75.
Charge has been framed.
My lord.
File revision. For it is not maintained.
My lord, 227 discharge against revision is maintained. Charge has already been framed, my lord.
Charge has been framed.
Yes.
So therefore you have to file a revision.
But,
You don't file a revision. The petitioner is challenging the order dated so and so, whereby the charges has been framed against the petitioner. He seeks to withdraw this petition with the liberty to file a revision petition against the impugned order. The present petition is disposed of.
my lord, may I file conversion petition?
No. Conversion petition, I can't entertain them. The petitioner, the present petition is with liberty as well. Yes.
76.
Your Lordship, my lord. In this application, the petitioner seeks for quashing of criminal proceeding, my lord. Matrimonial dispute, my lord. Already permanent alimony has been granted, my lord. Last occasion, Your Lordship issued notice, my lord.
Yes.
Notice made sufficient. Perhaps Madam is appearing.
You are appearing, madam? What do you say? You want to engage some lawyer? Or you want a lawyer to be engaged by the court? ଆପଣ ନିଜେ engage କରିବାକୁ ଚାହୁଁଛନ୍ତି ନା କୋର୍ଟ କାହାକୁ engage କରିବ? ନିଜେ କରିବେ? ଠିକ ଅଛି। କେତେ ଦିନ ଦରକାର ଆପଣଙ୍କୁ?
Till then, my lord, further proceeding may kind of paid. Doctor, my date of appearance is 17/2. Madam, already 7 lakh paid, my lord. Your Lordship kindly glance to the judgment, my lord. 7 lakh ନେଇ ଗଲେଣି. Divorce granted.
The allegation, let me answer.
Matrimonial dispute, my lord, 498 and other offences, my lord.
Compromise ତ ହବ କି ସେ କଣ?
Compromise ହେଇଯାଇଛି।
ଆଜ୍ଞା 7 lakh paid, my lord. Your Lordship kindly glance to the judgment, my lord.
ଆପଣ settlement ହେଇଯାଇଛି।
divorce-ଟା ହେଇସାରିଛି। ପିଲା କିଛି ନେଇଛନ୍ତି, କିନ୍ତୁ criminal case ଅଛି ଆଉ continue କରିବେ।
ତମେ ବା withdraw କରିବା ପାଇଁ ଏଠି deposition ଦେଲ।
ନାଇଁ ଆପଣ କରନ୍ତୁ, ଆପଣଙ୍କ ରାଇଟ୍ ଅଛି କରନ୍ତୁ, କିନ୍ତୁ ଆପଣ 7 ଲକ୍ଷ ଟଙ୍କା ନେଇଛନ୍ତି।
7 ଲାખ ସେ 3 ଲାख ଦି ଜଣ ଓକିଲ ମିଶିକି ନେଇଗଲେ, ମତେ ଗୋଟେ ଡ୍ରାଫ୍ଟ ଦେଲେ ଭଲ ଆସିବ।
ଆଜ୍ଞା
କଣ ଇଏ କଥା?
ମାଡ 7 lakh your lordship that ଇଏ
ଆପଣ କିଛି ମିଳିନି।
ନା ଡ୍ରାଫ୍ଟ ଚାଲ।
3 ଲକ୍ଷ ଯୋଉଟା ନେଇଛନ୍ତି ଏଠି ଇଏ ହେଇଛି।
ସେମାନେ ଦେଖି
money received that has been exhibited by the court, my lord.
Which one?
My lord, your lordship kindly glance page 35, my lord, judgment.
He is making a very serious allegation.
It's about a serious allegation.
Serious allegation.
That is the judgment, my lord.
Huh?
That is the judgment, my lord. And she has been given evidence, my lord. Your lordship kindly place
अपना settlement नहीं करना थी.
20, my lord, page 21, my lord, in her evidence, my lord.
1 minute.
My lord.
हाँ? कितने दे?
Penalty.
କେତେ ଦେବେ?
इतने कौन आती है? पचारियो तक दे बेरियो नहीं.
କେତେ ଦେବେ?
15 लाख ना.
7 ଲକ୍ଷର ଜଜମେଣ୍ଟ ହେଇଗଲାଣି your lordship.
7 ଲକ୍ଷ ତାକୁ ଦେବେ ତାର 4 ଲକ୍ଷ ତାଙ୍କ ପାଖକୁ ଯିବ ବାକି 3 ଲକ୍ଷ କିଏ ନେଲା କଣ?
ମାନେ 3 ଲକ୍ଷ that document has been exhibited, my lord. And her evidence, my lord. I am not submitting, my lord. My lord, she has given her evidence, my lord. Your lordship page 21, my lord.
There is a child out of the marriage.
My lord.
Why don't you pay a little more? What are you doing, by the way?
My lord, both are doctor, my lord.
Then for 15 lakhs is not big. You are giving to your own.
But already judgment has been made, my lord. She has not challenged the judgment, my lord.
Try to be little generous.
My lord, your lordship, doctor is with me. Your lordship kindly glance to the judgment, my lord. Doctor is with me.
Who is doctor?
Doctor, my lord, out of our world, a female child was born.
Daughter is with you.
Yeah. Judgment, your lordship kindly glance to the judgment. Order it. ତମେ ସେଠି ରାଜି ହେଲ କାହିଁ? ତମେ ଏଭିଡେନ୍ସ ଟା ଦେଇଛ। ୟୁର ଲର୍ଡସିପ କାହିଁକି ଗ୍ଲାସ
ଆପଣ ଡକ୍ଟର ତ ଆପଣ ଟିକେ lenient ହେଲେ ତ you lead your life perfectly. Why are you getting into all these things?
Give me time to.
No, I'll definitely give you time, but think over. Don't try to see you are able women. You are a doctor, and your husband is doctor. There is a compatibility issue. You are leading your separate life. Even if you get little more money, that will not, inure to your benefit. Why don't you settle and finish up unnecessary? I'll give you time. Think over. Do it. I'll put it next week, Monday. Monday is on 15th.
Till then, my lord, 17 date ଅଛି appearance ପାଇଁ।
ସେଇଦିନ 15 ରଖାଲା।
By chance, my lord,
in the absence of a lawyer.
ଏଟା ଥାଉ, my lord.
Not fair. See,
she has already paid, my lord.
Particularly
Further proceeding
for the reason,
my lord,
that
for that date, my lord, for 15, my lord, till 15. 17 appearance ଅଛି
17 appearance till 15 କଣ ହବ?
By chance, my lord, your lordship knows, my lord. In next week, my lord, my lord, in next week, my lord.
15 time. If 15 not
Till then, criminal case already divorce ଟା grant ହେଇଯାଇଛି, judgment ଅଛି, ତାଙ୍କ evidence ଅଛି. I am not suppressing any matter. I am already annexed the document, my lord. Court ତାହେଲେ ମୁଁ wrong ହେଇଯିବ, court ବି wrong ହେଇଯିବ, trial court.
In pursuant to the notice issued by this court, the opposite party number 2, Srimati, what is her name? Dr. Sevanti Rao has appeared in person, and she seeks time to engage a counsel. On query from the court, she says that she is not willing to discontinue with the criminal prosecution launched by her against the petitioner. The petitioner has taken me to the record to show the order dated 20th September 2023, whereby the application under the divorce petition has been allowed, has been allowed by the court of family court Baleshwar with a direction to pay to the petitioner rupees how much? How much you are supposed to pay? Alimony?
7 lakh, my lord.
The direction to the petitioner to pay 7 lakh alimony. According to the petitioner, she has already paid the 7 lakh rupees. However, the opposite party number 2 appears in the court and submits that he has only got 4 lakh rupees draft, draft, and she makes the allegation that although 7 lakh rupees was stated to have been paid to her, but she has only got 4 lakhs. 4 lakhs. That's what she says. I have to.
Your Lordship kindly glance to the judgment, my lord. Deposition, my lord. Deposition recorded on 4/8/2023.
He says
Tap
7 lakh. I am agreeing. I was supposed to get, but the lawyers have taken.
Lawyers
given
and
4 lakh rupees draft.
and deposition document dele 3 lakh receive kale.
You know how.
My deposition is there. After receipt, she made deposition for the court, my lord.
You have given DDs of
4 lakh and a cash of 3 lakh.
that cash.
22 cash diya.
Why have you given cash?
My lord, 22/7.
But that cash is appropriated by whom you know now.
But after giving cash, deposition has been made. If she has not
Not an
received,
issue. That is the whole problem.
that is my lord. But
That cash is taken, appropriated by both the lawyers.
after
Draft was paid and given to her.
but after receipt of the cash, she made
Do
deposition.
you want me to start an inquiry about it?
But
But you are not-
as per the document, certified copy, my lord, I am submitting, my lord.
No. See, don't aggravate it. Don't aggravate it. See, making a statement in the court.
My lord.
What is this? Why have you cash 3 lakh? What is the logic of cash 3 lakhs and 4 lakhs draft? You tell me. The reason you know that?
ମୁଁ ଜାଣିନି ଆଜ୍ଞା ଟ୍ରାଏଲ କୋର୍ଟ ମାନେ after receipt of the cash she made deposition.
This is very unfair.
ତାପରେ
Then comes for the petitioner for the submits that the matter is fixed before trial court on 17th of this month. 17th of February 20. Therefore, he seeks an interim direction. The petitioner may move an application before the trial court, informing the court regarding the pendency of the matter in this court, and seek appropriate and seek an adjournment. Release the matter on 15th. Move an application.
my lord. Obliged.
But persuade her, tell your client to persuade her.
my lord ପେପର ମାନେ after receipt ଯଦି କୋର୍ଟରେ କହିବେ ଏଠି ଆସି କହିବେ ଆଉ କଣ କୋର୍ଟରେ ସେଠି କହିଲେ ଆମେ ନେଇଯାଇଛୁ ରିସିପ୍ଟ
ଆପଣଙ୍କ ସାମ୍ନାରେ ତ ହଉଛି କଣ?
ଆଜ୍ଞା ସାମ୍ନାରେ ହେଲା ଡକ୍ୟୁମେଣ୍ଟ ଯାହା
To
ଅଛି
believe.
I am submitting on basis of document ତାମାନେ ଟ୍ରାଏଲ କୋର୍ଟ ଯେ statement ଟା ରେକର୍ଡ କଲେ deposition ଟା ମାନେ his false on basis of statement recorded.
Many things happens in between, you know.
ଆଜ୍ଞା କୋର୍ଟରେ କହିବେ ଏଠି ଯେମିତି କହିଲେ ସେଠି ବି କହିପାରିଥାନ୍ତେ ଆଜ୍ଞା ମୁଁ 4 ଲକ୍ଷ ରିସିଭ୍ କଲି 3 ଲକ୍ଷ ଓକିଲ ମାନେ ନେଇଗଲେ ସେଠି ବି କହିପାରିଥାନ୍ତେ ନେଲା ପରେ deposition ଟା ରେକର୍ଡ ହେଇଛି
Whatever
ଆଜ୍ଞା
can't get
My
into
lord.
this thing.
ये objection
18. 88. Give it 88. Yes, next.
21st.
Next.
May it please, Lordship. My lords, in this case, my lords, I am challenging the initiation
appear
of
one thing, my
complaint
lord?
proceedings as well as the
May I appear one-
question of the FIR.
In this
He
way,
is,
I am
he
for the
is,
opposite party,
my
sir.
lord, Malan senior friend is appearing for the complaint before the court below, my lords.
What do you want?
Copy of the petition.
We'll give him a copy. He is an informant, my lords.
In
We'll
any,
give him-
at the late evening, you can only get the relief to the extent that you supply a copy.
We'll give him a copy. We'll give him. Right away, we'll give him. Not
I will
that.
place it in early.
Well, my only difficulty here is my lords, the petitioner is the chairman, the managing director of OPGC, my lords, a government company. The claimant here is not the petitioner for whom my learned senior is appearing. He is a busybody. He is no way connected with the incident. He has filed a complaint, basis which an FIR was lodged against me, my lords. And that is the second FIR. And that information was never given to the court below. And the court below passed an order directing that there be an inquiry and a registration of FIR, my lords. May I bring the
Under 156.3.
Yes, ma'am.
Where is that?
May I bring certain factual lordship?
No, don't bring. Where is, show me the 156.3 application.
Yes. Lordship, kindly come to page 25 is the complaint minutes.
Where is that?
And the prayer is at page 29 minutes.
29.
And the order that has been passed is at page 24.
No, where is that application?
Complaint application is that page 25. Page 25, my lords.
Where is that? I think
Again.
that is one. Where is that? Yes. Okay. Mr. Maharaj, let's see. 25.
Yes, yes.
Same problem. No affidavit. Huh?
Complaint.
And in this complaint,
Complaint
in
is by them.
this complaint by them, I understand.
Again.
Thereafter, the FIR was registered
Again.
under 156(3).
Again.
Right now, the petitioner is seeking quashing up for the criminal prosecution initiated against him by the opposite party number 2. The opposite party number 2 moved the court of SDGM Jharsuguda under section 156(3) for direction for registration of FIR against the petitioner. Pursuant to the ICC case number 251 of 2023, the Learned Court below by the order dated
3rd January 2024.
January date 2024.
Page 24.
Where is that? 24.
Again, page 24.
By the order dated
3/1/2024.
Directed the
IAC Banharpalli.
Directed IAC
Banharpalli PS.
Banharpalli PS to register the case, registered the FIR. Registered the FIR. Bulls up under section 156(3) CRPC. Pursuant thereof, the instant FIR has been registered. Instant FIR has been registered. Peruse the perusal of the complaint under section 156(3) indicates that there is no supporting affidavit furnished by the complainant along with the said application. Therefore, as per the judgment of the Honorable Supreme Court reported in so and so, and the judgment of this court reported in so they can the complaint itself was incompetent. The complaint itself was incompetent. Therefore, the subsequent FIR laws, therefore, the entire proceeding is vitiated. Issue notice to the opposite party number 2. Mr. Maharaj appears for the state and waits notice. Mr. Patel appears for the opposite party number 2 on advance notice. Returnable within March the court video. In the meantime, the proceeding before the court below so and so is stayed till next.
And the consequential actions pursuant to the FIR, my lords. FIR the register he. No coercive action pursuant to the FIR.
I have cleared the proceeding.
Investigation he is nobody. He's a busybody.
Have you read those judgments? In 156(3) application, you need to give a supporting affidavit. If you have not given, it is incompetent. Pursuant to that, if any proceeding has been initiated, everything is vitiated.
My lord, may I make
So therefore, I have
difficulty.
My lord, may I make a
Difficulties. There's an FIR of 9 January 2024.
why do you presume that I will get up without exhausting the board? I have listed means I will exhaust the board.
May only play he's the managing director of a government company. Also protection to that extent, my lords. No coercive action against him pursuant to the FIR.
You go to some adjacent court, 438. I have stayed the proceeding because the entire proceeding is vitiated. Thereafter, what do you need?
I'm sorry, my lords. My apologies.
All of us are doing your job. You don't know what is the judgment we are relying upon.
I'm so sorry.
For you.
That's a copy of it.
Yes. I've served a copy upon him, my lords.
Yes, next. Let us go through the entire 78.
My lord, I am appearing in item number 78, my lord.
Yes.
I am the petitioner in this case, my lord. So, my lord, it's a quashing petition, and it is against
it needs to be argued
at length, my lord.
Okay, then I'll put it for some other day. Because at this.
My lord, I appear from outside, but then I, for my lord, like to come and appear in
You
person.
choose your date. You choose your date.
I'll just point
My
out one thing.
my
I'm for
colleague is
there for
there.
the
My
informant.
colleague is there.
He is through online. He doesn't have any inconvenience, particularly when it is before your lordship, because your lordship is accustomed to
I want
online.
to come
So
in
therefore, he
person.
can appear online. I don't think he needs a date for
I'm
that
making a
purpose.
request.
No, he obviously it has to be urgent and a date has to be.
But
A particular date.
Every date suits you because you are around.
I'm in this building only. I don't go outside of this building,
Let us
madam.
ask him.
Madam,
I like to
because
come, my lord, but he doesn't.
madam.
I like to come to Bhubaneswar. That's all right, my lord. I'm in Cuttack, my lord. So that's all right.
Okay, when?
My lord, in any time, my lord, that suits my colleague.
Let it be 21st or 22nd or sometime.
My lord, I'll just take a second, my lord, if your lordship will give me intelligence.
22nd. 22nd. Next.
79.
22nd.
May I just,
Madam,
if
Madam,
your lordship
interim
give
order
me
to
indulgence of a second.
interim order to continue.
Yes, interim order to continue.
My lord, may I see 22nd, my lord? 22nd February. क्या है इसमें अनिल कुमार चौधरी ये क्या है अशोक
79 corner.
79.
Yes, Lord. I am highly obliged, my lord, on 22nd.
22nd.
Well, in this case, I'm for the petitioner, my lord. I pray only lordship dispose of the matter with the direction to give it for 2 weeks to, 8 weeks time to deposit the amount, my lord. This is a case, my lord. I have challenged the order passed by the learned magistrate, my lord, under section 143A, my lord, directing to deposit 18% of the check amount, my lord. The learned magistrate also issued NBW. Due to interim order passed by this order, I am protected, my lord. The lordship direct, I will deposit the 18% in that check amount within 8 weeks, my lord.
8 weeks.
Yellow.
Where is the opposite party?
Yes, lordships, I am.
I think
I'm appearing for the OPU, lordships. Lordships, some less time may be.
1 lakh somewhat, my lord. There is not
1 lakh.
more than 1 lakh. 1 lakh.
1 lakh only you paid 4 weeks. 4 weeks I will make it. 4 weeks. Huh? 4 weeks time.
Lordship.
The petitioner has.
I pray otherwise lordship has 6 weeks.
The petitioner has challenged the order dated 9/8/2021. That is the order by which you are asked to deposit money.
1,08,000.
143 order.
143. That is page 15. Let's see, can see the page 15. Running page 15 of my brief, my lord.
By which the court below has directed the petitioner to deposit 18%.
My lord? Yes, 18%.
18%. 18% of the check amount in compliance with the provisions of 143(5) of NI Act. Within how much time?
That is 143A of the NI Act, my lord.
143A of NI Act. You tell me what was the time given to you?
The time, my lord, is the learned tribunal directed to deposit 1,08,000. Otherwise,
petitioner submits that if 6 weeks time is granted to him, he will comply the order. Accordingly, and the counsel for the opposite party, namely the complainant, has no objection to the same. Accordingly, the petition is disposed of with the direction to the petitioner to make good the payment as directed by the court below within 6 weeks hence.
the DW issued against the president. The learned magistrate also issued in DW, my lord.
DW only.
Distress warrant, my lord.
Distress warrant.
Attach the property. Property, my lord.
Meanwhile, the distress warrant issued by the court below by the order dated.
Order dated, my lord, 17/11/22, my lord.
17/11/21 is
22, my lord.
is kept in advance for 6 weeks.
My lord.
Lordships, failing which law may be taken.
Failing which consequence 6 kept in advance, that will revive. What is that is the consequence?
With your lordship's kind permission, my lord. With your lordship's kind permission, item number 49.
I've not.
That was already had by your lordship. Only I was my lord, supposed to file the 65B affidavit. That release of that gutka and tobacco products.
I think that is not. Was
No,
it
aji
heard
thilla
today?
49 re thilla je. I was held up in another court in another matter.
The date has been given.
Na date ta 22/3 ke huzur de dijante. Asu kalli pardon to asu sorry.
So possible.
It was already hard, my lord.
So give it on 15th then. 12, 13, 15. So many matters is not
এটা সরি যাইଥିଲା ତ ସେଥିପାଇଁ କହୁଛି ମାନେ ଏଟା ହଜୁର ମନେ ରଖିଥିବେ ଖାଲି ଦେଇଦେଲେ 65B ଟା ଦେଇଦେଲେ
I remember you.
yes my lord that
But you should have come.
ସେଠି ଆଉ ଗୋଟେ କେସ୍ ରେ ମୁଁ ହେଲ୍ଡ ଅପ୍ ହେଇଯାଇଥିଲି ଛିଡା ହେଇଥିଲି ଆର୍ଗୁମେଣ୍ଟ ଚାଲିଥିଲା ହଜୁର
Okay.
Item 69 ଟା ଆଜ୍ଞା 15th କୁ ଆସୁ ମୋର ଭୁଲ ହେଇଯାଇଛି ଆଜ୍ଞା 14th ରେ
69 ରେ କଣ ହେଲା?
69 ଟା ଆଜ୍ଞା 22 ଦିନ
So we are proceeding with the.
my lord I am very sorry ଆଜ୍ଞା
There are only 5-6 matters. Let us finish it up.
ଆଜ୍ଞା ମୋର 15th କୁ ଆସୁ ବୋଲି ମୁଁ ପ୍ରେୟାର କରୁଛି
15th ରେ again the same thing will happen.
19th
5 o'clock it will reach. But
19th କୁ ଆସୁ ଆଜ୍ଞା
we will see within this month we will give it.
22 ଦିନ ରଖ
Huh?
That's 28.
Let's see what to do.
28th କୁ ଆସୁ
28th also.
ଆଜ୍ଞା
You keep on listing many matters. Not heard what is you.
ନା ଆଜ୍ଞା ମୁଁ ଜଷ୍ଟ ନିୟର ବାଇ କୋର୍ଟ ରେ ମୋର ଚାଲିଥିଲା I could not come.
That's bad luck.
When I came running, your lordship is in
Your
70.
client's bad luck.
My client's bad luck.
My lord, item number is 83.
82. Let me adjust the board one after another.
82, my lord.
Yes.
Now, this matter arising out of the matrimonial dispute, last of all, your lordship pleased to issue notice to OP number 2 wife and postal noting so the postal tracking so the notice have been duly served upon OP number 2 lordship. Here, my lords, already divorce have been obtained between the husband and wife, and wife opposite party number 2 has already received entire permanent alimony and also dowry article, and have also filed an affidavit therein.
Okay, by the order dated 9/1/2024, this court had issued notice to the opposite party number 2. Notice is sufficiently served, duly served to the opposite party number 2, but she has not appeared.
AD of notice issued to OP2 not returned.
ADS.
Postal tracking report show their copy is duly served upon him.
Another opportunity given.
Now, since he has already paid everything and
Everything.
so let us stay the proceeding. He will come down now. Once the proceeding is stayed, he will come. Otherwise, he will not come. The letter counsel for the petition submits that. Have you said that?
Yes, lord. Last of all, the lordship also stay the.
I have stayed.
Yes, my lord.
Proceeding is stayed, na?
Yes, my lord. To continue to
Interim order to continue.
Yeah, my lord. Oblige.
83.
My lord, item number 83.
Urgent.
May come next tomorrow.
Ticket time like that.
Tomorrow bus song.
6টা কেস এখানে আসছে ticket time.
Last time I was also directed the state to examine each and aspect that after 10 years charge sheet has been submitted. In the meantime, two occasion charge sheet has been supplementary charge sheet has been submitted. This is the final charge sheet, and it was my contention that what is the difference, because since last 10 years, although on 2 occasions supplementary charge sheet has been submitted, we have not been charge sheeted. So my lord has also specifically directed to the state to examine and say what is the allegation.
My prayer in all total 6 cases, my lord. Prayer in each case are different, my lord.
Yes, it take time.
For that is in my lord.
It has also chat week quite
Next week and any date given, my lord.
Next week.
6 matters are there. If you prepare the chart, we can dispose of all 6 at a time.
I have prepared the chart, my lord. But in fact, my lord, some of the terms is not appearing in the but 6 matters, my lord. Only Mr. Chand is appearing, others are not coming.
Anyway, how much time you need then?
It can dispose of just now, my lord. In one matter, my lord.
One matter, we will see, decide all the matters.
My lord, this coordinate bench passed an order, my lord. After this, my lord, supplementary charge sheet, my lord. My lord, CLMC 3508-23.
Yes.
That
what does it say?
That case, my lord. The same thing challenge in the application, my lord. This petitioner, Dr. Gunandhi Naik's case, my lord.
Yes.
Here, Gunandhi Naik filed another case, my lord. On 12/5/2023, my lord. Order dated 12/5/23, and it is submitted by the petitioner was not named in the FIR
further informant being a busybody has lodged the affair without in the least being affected by so-called misappropriation of the compensation amount paid to the land outstream. The petitioner was charged only on the basis of some stray statements made by some witnesses during the investigation. These are matters that can also be considered the court below at the time of framing charge. The CRMC is therefore disposed of granting liberty to the petitioner to move for discharge by filing appropriate application.
No, that is because of the fact that the particular person has been named by some person. Here, my specific cases, I have not been named by anybody, my lord. So that's why my lord has directed the state to examine what is the material, who has.
Facts of each.
Yes.
What are the outage attributed to these individual?
Yes, I am appealing for the my lord, that advocate.
Same person might file another case.
But
after this
no,
disposal,
1 minute. The Gunanidhi, so we can dispose of.
My lord,
Gunanidhi, who is for Gunanidhi?
I am for Gunanidhi.
You have already filed one petition, you got some order, again you have another petition.
No, my lord. Okay, we have,
Mainly because the other accused have filed, you also filed it and got it.
No, I have gone independently to in CRLMC.
But what about this, the order? How will you get over that?
That order is annexed by the annexed in annex number 1.
No, you answer it. In your case, this order is passed. How will you get over that?
Okay. My lord, the coordinate bench has already given me the liberty to file a discharge petition in the court.
You file.
But when that is what is the problem. When I went to file the discharge petition, they did not allow me to file that.
I'll record it.
Thereafter, I have detailed that thing. Not only that.
Which court will not allow?
My lord, I am giving you.
Okay, then I'll clarify. Where is that?
that has not.
Whole problem is that, well, for filing a discharge petition, a person's appearance is must.
That what?
No.
You have
all the persons are shown as absconder, my lord.
No.
In the charge sheet. All these petitions shown as absconder.
My lord, I may kindly be heard.
You write down this petition. What is this? This is Gunanidhi, only Gunanidhi. 3508 of 2020. Gunanidhi. 83 Gutega. The petitioner in the instant case has approached this court. Approached this court by filing criminal MC number 2173 of 2023. The coordinate bench 2023 seeking the same relief.
Annex 1.
Seeking the same relief. The coordinate bench by the order dated 12/5/2023 has passed the following orders. You take this order. Take this order. Take this order. Therefore, the present petition on the same ground and for the same relief is not maintainable. At this stage, the letter counsel for the petitioner submits that when he attempted to move an application under 227 CRPC for seeking discharge, his application was not entertained by the court.
That my application, they have received it and they have stamped it, but they did not file. They gave a number. That copy of that application is with me.
Although he moved the application, the same was not entertained and heard by the court below. Next order. It is it is though the submission made by the petitioner is claims to be believed, still without entering into the dispute as to why the application was not entertained pursuant to the direction of the coordinate bench. I further direct the court below, the court of so to entertain the application filed by the petitioner under section 227 CRP. And here the petitioner on merit of the application. Take the order. Yes. बाकी जो गुड़ा डेट दे दो आपको
85 interim order to continue. I'm sorry.
80
I'm sorry, I thought your lordship said
84.
83 my lord posted.
Posted to the will be.
Ready up to the what suitable. After 1 week
देखिए फांका देखिए
fourth month. ठीक है. Entry model continue.
Entry want to continue. Yes.
One case dispose of that case.
One
For my lord,
Yes.
my lord, the matter has been amicably settled between the parties, my lord. And my lord, on the last occasion, my lord has.
Are they there? They are there.
No, my lord. On last occasion, your lordship directed to file the joint affidavit. Accordingly, we filed the joint affidavit, my lord.
What is the offense?
Offense, my lord, 294, 341, 323, 506, 317.
Where are the accused?
My lord.
Accused.
नहीं,
लोगों का से था सर
Oh.
नेसले सर
Have they come?
Joint affidavit we have already filed one.
No, joint affidavit you file, but sometime they will disown you. That's the problem.
Already.
Let them appear tomorrow.
Yes, ma'am.
Tomorrow.
Joint affidavit.
Tomorrow. They will appear and be.
Yes, ma'am.
85. My lord, I have sought for passing, it requires some time.
Yes. Then
22nd March,
22nd March.
interim order to continue.
Entry will continue.
22 March.
Veyo.
87.
86.
My lord 86 I am for the applicant my lord.
There was somebody mentioned.
86 रे copy भी देना दे.
My lord, already my lord notice issued. Notice issued to all the opposite parties my lord.
That's right, but somebody mentioned.
My lord, only question involved in this case, my lord, whether 102 of the CRPC bank account was seized or not. Because my
Right, but the other side was not there mentioned in the morning. What to do?
my lord, my bank account seized since 2021, my
I
lord.
can-
I'm unable to operate the bank account.
Right, but
Copy क्या है? तो एक मिनट. मेरा की copy कौन? बेटा additional मतलब main
no
copy
more.
नहीं मोटे.
copy 87 है क्या
Only your lord.
सर थोड़ा urgent बन रहा है business का
Your lordship only the annexer 4 your lordship kindly
yeah,
see.
short date I'm giving you.
My lord, tomorrow.
Not tomorrow, not possible. Yeah.
Copy कोटे देबे हमको.
Humanly not possible.
Already solved copy.
नहीं आज्ञा copy देना.
Yes, you can you see that?
कहाँ को दीजिए तो पहले?
Office of the Senior Standing Council Vigilance Cutter.
Oh, vigilance के साथ. बेटा कौन है?
He will give a short date.
Vigilance.
Public.
Yes, next.
88 87 है 87
Yes.
तो मेनली फोन का विषय.
Lord, this is a matter where conviction, order of cognition, section 4 of the
Interim order is already there. Enjoy.
My lord.
Give it.
I'm filing an
March.
affidavit, it may be kept on the.
Take it in March. Interim order is already. Yes. Next.
88
Urgent.
89
89, may I please your lordship? My lord, kindly see order dated 17/1, para 5, my lord. Instruction
17/1.
was called.
Yes.
17/1, my lord.
Mm-hmm.
Para 5.
Yes.
Instruction was called for from IO, my lord. Report was called.
Verify the right.
No report has been received.
Yes.
No report has received. My lord, I have already communicated. I will get some time.
1 week.
Yes.
I may be protected, my lord, in this juncture.
What do you say? Protection is asking.
No coercive action, my lord. I have married to the victim and
Let both the party be appear.
Yes, my lord, your lordship may direct.
Both party will appear before this court, your lordship may.
Huh?
Both
Your
party will
lordship may
before appear.
direct any date, my lord.
Day after tomorrow, let them to appear. Or tomorrow, let them to appear.
Will they?
Tomorrow.
Tomorrow may not be possible, my lord. They will from.
Section 6 POCSO issues.
So
all matters are adjourned to tomorrow, my lord. Section 6 POCSO compromise matters.
Tomorrow the batch matter is there. Let us tag with that.
My lord.
So tomorrow आसो tomorrow आसो किछ भी कहि नहीं 160 पर किछ कहि नहीं
कोई ना
किछ कहि
आपण पॉइंट आउट कर दो काली
हां मु काल कहि मु सुना भलो
tell your clients to be there.
Yes.
On virtual mode, they will be they are from Kalahandi, my lord.
Okay, virtual mode. No.
Okay.
Oblige, my lord.
काली देखि दियंतु जति मैटर उडा अछि ना जोट्रे किछि मटेरियल नाही कोइ देबे ताको साइड करि रिक्वेस्ट कर दवा. ঠিক ଅଛି ଯୋଉଟାରେ material ଅଛି then we will see
ମ୍ୟାଟେରିଆଲ
how
ଅଛି
to
କି
go.
ନାଇଁ ସେଟା ମ୍ୟାରେଜ ହେଇଯାଇଛନ୍ତି ପିଲା ହେଇଯାଇଛନ୍ତି ସେଇଟା ଗୋଟେ ଅଛି
ହେଲେ ମଧ୍ୟ ଯଦି already 164 ରେ ଅଛି କହିଲେ then we
ହଁ,
have to
କିଛି ନାହିଁ।
examine each and every case ଦେଖିଦବା
90
I want to pass a
Manner,
judgment on that so that it will be helpful for the in this only for tribal people,
Tribal people where they are
tribal
not,
and Muslims and all.
yes, and they are not supporting, where the victim is not supporting the prosecution case.
item 90
It tomorrow, 89 tomorrow.
All the, yes, 90.
90
Urgent.
91
Wait, please.
91, Lord. For 91, I have this to say, Lord, in one matter, Lord, we had actually argued the matter, which is 5310/2023, and my Lord was.
It will take time, Lord. It is total up to.
I will take, Lord, I'll tell
Total
Lord.
last.
It's a short issue, Lord, and I will
Mr.
take.
Luthra,
Yes, Lord.
Mr. Luthra, will it be fair to trouble you?
Lord,
At
whenever
this
your Lordship, no trouble, Lord, whenever your Lordship says I'll do it, Lord, it's a 5-minute job. Nothing much, I would say.
पाँचटा बजले
It is already 5 o'clock. Our prosecutor is restless.
Lord, I can't, Lord, I have to keep the prosecutor in good humor. Otherwise, your Lordship knows most important man in our lives is the prosecutor.
He is reluctantly laughing at your suggestions.
Lord, whenever, Lord, whenever, my Lord,
Give me appropriate date so that we can finish it up.
whatever date. Lord, I'm not the only issues in 5310. The issue is not this is to be heard. Others notice may be issued. Other batch. Mr. Tirath Sahu will give the details.
Yes, ma'am.
Yes.
Might
53.
not be listed on any day convenient to your Lordship.
No, what happened? 5310.
5310 of 2023 notice issue is and rest
Notice is
matter-
not notice is to be issued.
Then I'm issuing notice in all the matters. And you prepare a comprehensive chart kind of thing so that it will be easier.
Lord, we'll give you a chart.
The
We'll give
senior
you-
might have prepared it by now, but still, if you have prepared anything, please give it so that we fix a date and finish up all the matters.
We'll do that. We'll do that.
This side you give group matter, we can finish up at least.
February 28
It is not a big matter, it's very small matter.
Very short issue, about 5 minutes.
Short issue, so we can do it.
28
28.
max 22nd
Let it be 22nd then.
Lord, 22nd is perfect, Lord.
And
My lord,
22nd we will fix at 3 o'clock.
My lord,
Grateful, Lord. Grateful, Lord.
22nd is a Friday.
It's a Thursday, sir. 22nd is a
Thursday.
Thursday.
Oh, sorry.
Thursday.
Sorry.
At 3 o'clock I am fixing so that all the matter could be.
I'll be
disposed.
grateful, my Lord. I'll be more than grateful.
Okay, 3 o'clock with
And notice is issued in the other matters.
notice to the respondent in all of them.
Grateful.
Except the matter. Give
5310.
5310.
5310.
Thank you.